Hi, good morning. Welcome to the August 25th Planning Board meeting for the City of Miami Beach. We have several agenda items today. We have 10 or 11 items that we'll go through. And with that, before we start the meeting, City Attorney, would you like to read the protocols for the meeting?
Yes, thank you, Mr. Chair, and good morning, members of the board. Today's virtual meeting of the Planning Board has been scheduled pursuant to Executive Order 20-69 of the Florida Governor, which suspends any Florida statute that requires a quorum to be present in person or requires a local government body to meet at a specific public place and permits local government bodies to utilize communications media technology. In order to participate in today's meeting, members of the public may dial 1-888-475-4499 and enter the webinar ID, which is 828-9059-7204#. Or members of the public can log in to the Zoom app and enter the webinar ID, which again is 828-9059-7204#. Members of the public wishing to speak on an item must click the raise hand icon if they're using the Zoom app, or dial *9 if they're participating by phone. Members who do not have access to a computer and wish to provide testimony or submit evidence in support of or opposition to an item scheduled to be heard today may appear in person at the Miami Beach Convention Center at 1901 Convention Center Drive, Washington Avenue entrance, Art Deco room 229 in Miami Beach, at which location access to a computer will be provided. On quasi-judicial applications before the board today, I'll swear in each presenter or member of the public wishing to speak. I'll also ask each board member to disclose the names of any individuals with whom they've had ex parte communications. Lastly, Mr. Chair, I'd like to read the city's notice regarding lobbyist registration. If you're appearing on behalf of a business, a corporation, or another person, you need to register as a lobbyist with the city clerk's office. If you haven't registered yet, you should register before you speak to the board. You don't have to register as a lobbyist if you're speaking only on behalf of yourself and not any other party, or if you're testifying as an expert witness, providing only scientific, technical, or other specialized information or testimony in this public meeting, or if you're appearing as a representative of a neighborhood association without any compensation or reimbursement for your appearance to express support of or opposition to any item. Expert witnesses and representatives of neighborhood associations shall, prior to appearing, disclose in writing to the city clerk their name, address, and the principal on whose behalf they are communicating. If you're an architect, attorney, or employee representing an applicant or an objector, you must register as a lobbyist. These rules apply whether you're appearing in favor of or against an item, or encouraging or arguing against its passage, defeat, modification, or continuance. That's all for me, Mr. Chair.
All right. So with that, thank you again, Nick. I want to just thank all the planning board members for their diligence always and the processes that we carry out on the board. Really appreciate all of you guys bringing your knowledge and really looking for creative solutions in many cases to some of the challenges that we have sometimes on the items that are brought before us. So with that said, Michael, should we go straight into the minutes, or do you have any announcements?
No, we can go straight into the after action from the July 27th meeting.
Okay, so do we have any support or motion for the minutes, approval of the minutes from the July 27th meeting?
I'll move it.
No, I'll second.
Moved and seconded. Michael, want to call the roll?
Sure. Mr. Vitia?
Approved.
Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Barano?
Yes.
Mr. Pietro?
Yes.
And Mr. Brantley?
Yes.
The minutes are approved, 6-0.
And then, Michael, you want to explain the telecommunications from the June 23rd, which we didn't hear, but it's pretty minor.
Sure. So we're recommending, again, another continuance. It's a very lengthy ordinance, and we need more time to go through it with the city attorney's office. So we're recommending that the board continue this item to the October 27th, 2020 meeting date.
I'll move it to continue to the October.
What's the essence of it, Michael? The core of the item?
Maybe Nick, do you want to provide some background?
I don't want to take us down a long rabbit trail. I'm sorry, I just wanted to get
I promise I won't take you down a rabbit hole. It's really a matter of just comprehensive updates to the city's telecommunications ordinance to reflect recent changes in state law, and it's a highly prescriptive area of law. So we've these are updates that we were working on before the pandemic, and over the next few months we hope to bring them to you.
Okay. Yeah, sounds good to me.
I'll move to continue it to the October meeting.
I'll second it.
Been moved and seconded. Let's call the roll.
Mr. Vitia,
Yes.
Mr. Maland,
Yes.
Mr. Weeder,
Yes.
Mr. Barano,
Yes.
Mr. Pietro. Yes. And Mr. Brantley.
Yes.
That has been continued to the October 27th meeting date.
All right, so let's take the next item up, which is the Planning Board File 20-0370, Faena District Overlay Amendments. And this, just to remind the board, this is a presentation that we heard at last month's Planning Board meeting. And we asked the applicant, or the impacted party rather, to go back to the community and have some dialogue. So with that, you want to introduce the item again, Michael?
Sure. And before I start on that item, I just want to give a general overview of today's meeting regarding the items on the agenda today. To note that everything on today's agenda is legislative, where the planning board will be providing only a recommendation to the city commission. 4 affirmative votes are required for a positive recommendation. The board can also provide a negative recommendation or continue an item to a future date. Ultimately, only the city commission has the power to approve and adopt changes to the city code after consideration and recommendation, either for or against, by the planning board for changes to the land development regulations. In addition, for most of the items on today's agenda, even if the city commission approves the proposed changes, design review board, historic preservation board, planning board, or a combination of the above is still required for site-specific application where applicable. So now to the first item mentioned that was continued from the July 27th meeting is Planning Board File number 20-0370, the Faena District Overlay Amendments. Since the July 27, 2020 meeting, the ordinance has been updated to reflect the recommended rear subterranean setback of 46 feet from the bulkhead line. Additionally, at the request of the property owner, additional language was included in the ordinance to allow security guard houses not to exceed 200 square feet as an allowable encroachment into the front setback. Staff's only noted concern regarding such guardhouses and any related fencing and control structures is a negative impact that could result on Collins Avenue. Provided the traffic study for the future development can demonstrate that there will be no impact onto Collins Avenue, staff does not object to this additional encroachment. And that traffic study would be reviewed as part of any submission to the Historic Preservation Board for a new project within the district. Lastly, the maximum permitted width of a porte cochere has been increased from 45% to 52% of the width of the building's frontage, which is consistent with the most recent microfilm for the original Versailles Hotel porte cochere, which is proposed to be reconstructed. Staff, as last month, does recommend that the planning board transmit the proposed ordinance to the city commission with a favorable recommendation.
Michael, could you also comment on the email you sent this morning, just briefly?
Oh yeah, so I forgot to include a map. The overlay district itself right now has a map in the code, and since we're not changing the map or updating it, I just wanted to reflect the area for the board's information of the property that comprises the Faena overlay district, and there are multiple lots within the district that comprise the RM3 zoning district and our oceanfront.
Thank you.
So this is just a extension of the porte cochere.
No, that's one of the items. There's numerous amendments proposed that were discussed last month, including increasing the height from 200 to 250 feet, modifying the setbacks for oceanfront properties that are over 70,000 square feet and containing a contributing building. You may remember, David, when you were on the Historic Preservation Board, you may have seen an application for the Versailles where it had a 1950s addition that was demolished in order to bring back the original design of the Art Deco tower. So a lot of these changes recommended herein basically move the new construction away from the Versailles structure to allow more separation and push it closer to the property line, which is consistent with variances that were approved several years ago for the project.
Thanks for refreshing my faulty recollection, but I do remember that. I think it was a very good move. And also this involved this project also involved the mural, did it not? That was moved elsewhere.
Yeah, that was part of the building that was removed, the 1950s edition. That was something that I think is really for the discussion of the Historic Preservation Board. And I do believe they discussed that when the building was approved for demolition years ago. I understand, and I believe that the property owner of the Versailles is on the call and could provide some updated information as to the status of that mural. But I do believe it exists still in some form. And there is an application that will be required to the Historic Preservation Board for any new construction on the site, and the board has already reviewed modifications to the original Versailles hotel structure. So I think that that discussion really is appropriate to the Historic Preservation Board, and we wouldn't want to put into this ordinance, a requirement to retain a mural at this point.
Michael, if I could interrupt, on your map, between 33rd and 35th is obviously 34th. It shows a blank there on the map. Is that the parking lot?
Yes, that's correct.
And that entire space is parking lot?
Yes.
And the city of Miami Beach owns that parking lot?
Correct, yes. And it's funny because that is actually, it's not a street end, it's actually a platted lot. It's not a right away, it's actually, even though it's called, or it may look like a street end, it's actually a lot. Okay,
so it's a lot which is being utilized as a parking lot.
Parking lot, yes. Right. Yes, and I believe that at the time that the tower to the south was developed, as part of the prior approvals, the developer for the district did construct the improvements which were required to that lot.
And the Versailles building is located on the northwest corner of 35th and Collins, is that right?
Correct, yes.
And how would you describe the location of Faena within the 32nd to 33rd Street block? Where would it be located? How far to the north?
Well, in terms of the subject of the ordinance in terms of new construction is be located on north of 34th Street.
I understand that. Just how is Faena located within the southern piece?
Well, it's all the Faena district. To the south, you have the new condo tower, which you received letters of objection. So that's the location of the new Faena condo tower, which is south of that lot on 34th Street. And at the time that was approved, that was joined with the Saxony site, which is basically
that's right. There's two. That's right. Okay.
Right.
All right. Thanks.
Sorry to interrupt, Michael, but is this something you sent by email, this map? Because I can't find the map you're referring to in the material.
Yeah, that's why I was asking for clarification. I sent this morning.
And my apologies, I did not receive that this morning from you. I got something on 4,000, but not on this one. If you don't mind sending that to me, I'd appreciate it.
Let me send it again.
And Michael, just so everyone's clear, the map that you sent is the map of the overlay district that's in the code, right?
That's correct. There's no changes. This is just exactly what's in the code. We're not changing it, so it wasn't included in the ordinance language proposed today, but we probably should have included it for reference. So that's why, just so everybody's clear and understanding of the district, and we're not proposing any changes, I sent it to the board members this morning.
Good. Thanks, guys.
And forget it, Michael. I found it. Thank you.
Okay, great.
All right. So, Michael, do we have a presentation on this one, or?
I guess let's see I
not
believe Ackerman's on the line. If they would like to provide an update since the prior meeting,
Yes. Yeah,
and then we have additional public comment.
Yeah, and I'm sorry, I said a presentation. I don't necessarily want to see that again per se, unless board members have a question. But like you said, the update.
Thank you.
Mr. Chair, how much time would you like to allow?
Let's give them. I mean, we want to kind of keep it tight. I don't see that they need more than 10 minutes.
Okay.
Thank you, Mr. Chair, members of the board, Neeson, Kassan, and Ackerman. And we have a slide presentation. If we could now control there, so if you tee that up, please, I will take you through it. Just briefly, next slide, please, to remind you that this is, next slide, 56-room ultra-luxury Aman Hotel and 23 residential units. Next slide. One of the main purposes and public purposes of this set of regulations is to allow this magnificent restoration of the Versailles Hotel, including the porte cochere, and situate any additional construction in such a way that public views of this restored building are maximized. Next slide. This is the porte cochere, which will be reconstructed. Next slide. And this shows you a view on the east side of the restored and expanded Aman Versailles Hotel, including the rebuilt Gulfstream dining and historic dining. Next slide. We've showed you this before. One of the great purposes of this piece of legislation is to create greater views for the historic Versailles Hotel. This yellow triangle that you see shows you how much more of the building will be able to be viewed as you're proceeding north on Collins Avenue, whether walking or by car, which is the principal way in which people view this facade. The dotted line shows the lower level of the proposed new building. The solid line shows the perimeter of the existing approved building. Next slide. And even at the higher levels, dotted line, the new proposed building, solid line, existing approved building, it is still set back. There's an additional 25-foot setback from Collins Avenue for this structure. So this provision mandates the public will have greater views of the restored Versailles. Next slide. And this is a graphic depiction of that. This shows you how with the proposed new tower and the restored Versailles, the view that will be available as you go up Collins Avenue. Next slide. This shows you with the existing approved building, which could be built, how it substantially blocks out the view of the public of the historic Versailles Tower. Next slide. And then again, it shows you the freed Versailles, and the red outline shows you the area that's open to public view. Next slide. Now, I'd like to deal with the objections. Two things. Number one, the concerns that were raised on the board, and there were two issues. Number one, let me talk about the Jack Stewart mural. Although it is not a part of or a condition of approval of this package of zoning items, my client will, in connection with the site plan approval for the overall project, voluntarily agree to repair and install the mural on a surface to be determined by the City of Miami Beach, working with the Miami Design Preservation. They have gone out and surveyed it, and we are even looked at potential sites for it. Not part of this application, but is a voluntary offer on our part. Now let's go to the concerns of the board. They really were based on giving the Faena House owners who had raised some objections an opportunity to further meet with us. First thing I'd like to point out to you is that the proposed building and as well as the already approved building are not as wide or as long as the existing Faena House. In other words, the Faena House building is set back 116 feet from the east property line. The Aman building is proposed to be set back 126 feet, 10 more feet from the east than the Faena house. And by the way, the subject of these overlay regulations has nothing to do with the eastern setback. We are building within the allowable eastern setback as it exists today. However, on the Collins Avenue side, the Faena house is only set back 58 feet from Collins Avenue, where the Amman building is proposed to be set back 128 feet at the ground floor and 97 feet above the fifth floor. So the Faena house is a longer building than the Amman building, and this code provision that you will adopt mandates the greater setback on the east side to promote a greater view. Next slide. These show you the beautiful views of the proposed new building, how it was open, how it was airy, the separation with the parking lot from Faena house. Next slide. Next slide, please. Now let's talk about height, and let's put this in context and let your eyes think and for you, and not hear things that people are going to say that are not true that you can judge for yourself. This is the Collins Waterfront Historic District. Next slide. Already there are 3 buildings in that district from 23rd Street to 42nd, 43rd Street, which exceed the 250-foot height that we are proposing, including Latour, which is only 6 blocks from this site at 285 feet. Next slide. And this is a graphic depiction of it. You see the Latour on the right, and you see the Mirasol and the Atlantis on the left. And by the way, as you go to the next slide, which will show our building in context, as you can see, this is very much in context. When you look at buildings like the Mosaic, the Caribbean, the Faena House, the Latour, it is hard to argue that this is out of context for this neighborhood. Next slide, please. In addition, because of the unique situation of this property, with a 100-foot city parking lot between us and Faena House, and a 290-foot city parking lot and street to the north, this is an isolated property, therefore having less impact than any other neighbor. Now, next slide. If we go to, and you can see that, see a visual image of that. Next slide, please. This is the Latour building. So I want to really bring this home so people do not take the issue and the discussion of height out of context. If a Latour building, which is 285 feet, had the same separation from its neighboring properties, you'll see by those yellow arrows how far apart they would be. In fact, the neighboring properties are significantly closer. Next slide. And this is a visual depiction, an aerial depiction of that. Next slide. And this, I think, really also brings it home in terms of the context of this building in the neighborhood. If you look to the far left, you will see the Latour building. In the center, you'll see Mosaic and Caribbean. And on the far right, you'll see the Faena House. And you can see it is hard to make an argument that this small increase in height in any way is not contextual with the neighborhood. And in fact, what we did is we took a view of the Latour building from across Indian Creek in the residential neighborhood, where you can see the Caribbean on the right and the Latour on the left. It is a gross overstatement to say that this is out of character with the neighborhood. Next slide, please. The next thing we want to show you is how this has minimal, almost negligible impact on the views of existing owners of the Faena House. In fact, it improves some of the views. As we go through this series of slides, you'll see the blue lines represent the existing view corridors from points of the Faena House vis-a-vis the existing already approved building, and you'll see the proposed building. Let's go to the next slide. So this shows you from the northwest corner of Faena House that there's a loss of 4 degrees of view on the east side and an increase in 7 degrees of view on the west side where the new proposed building is going to be. Next slide. Similarly, now we're showing it to you from the northeast corner of Faena House. Next slide. That shows you that there is a 5-degree loss of view of 180 degrees on the east side, and there's a 7-degree gain of view on the west side. Next slide. And finally, we show you from the center of Faena House. Next slide. That shows you there's a 6-degree loss of view on the east side, an 11-degree increase of view on the west side. Next slide. The next thing that we were asked about was the effect of shadows in the sun. And what this shows is conclusively there is zero impact on Faena House from the new construction. In fact, the reverse is true. And there is imperceptible or negligible effect on the public beach whatsoever. This shows you June 21st, the longest day of the year.
Mr. Chair, 10 minutes are up.
Mr. Chairman, I have 2 or 3 more minutes, please.
Let's just kind of wrap it, Mr. Mayor, please.
This shows you here the longest day of the year, 10 a.m. The maroon color is the Faena House shadow. The gray color is the Amman shadow. Next slide. This shows you it at noon. Next slide. This shows you it at 2 p.m. Next slide. This shows you it to you at 4 p.m. Note, by the way, the Faena House shadow is wider and extends almost as far out on the beach. But at no point does Amman shadow Faena House. Next slide shows the winter shadows. This is 10 a.m. in the morning. Next slide shows you at 12 noon. Next slide shows you 2 p.m. Faena House begins to cast a shadow over the Amman. Next slide. This shows you at 4 p.m. And you can see the existing Faena House already takes up a lot of the shadow space that is cast over the beach. So there's very little additional increment. Next slide, please. So what you're seeing here is we have tried to deal with the concerns as they are stated of the residents of Faena House. But the truth of the matter is there are no concerns that merit changing the legislation that is proposed. I'd like to conclude with one other point. We commissioned a study by Lambert Advisors on the economic impact of this project if it goes forward. It will create 985 direct and indirect construction-related jobs, 270 new direct full-time equivalent jobs at a projected annual wage of $59,000, an increase in incremental ad valorem revenue to the city of Miami Beach of $2.7 million a year, an annual resort tax revenue of $1.2 million a year for the city. This does not include taxes to the school.
2 minutes are up.
And counting. So we ask that this project, which is of such immense importance to the city of Miami Beach, taking the city in the direction we want this city to go in and brings many benefits to the city and the public, be approved. Thank you.
All right. Thank you guys so much. Board members, do you want to, well, let me look here and see if we have any comments. Okay, let's just take public comment on this first. So let's go with 7204. PJ, can we get the member of the public ending 7204?
And Mr. Chair, I'll keep track of time. If any individual members would like additional time, they can request that of you.
Thank you.
Caller, please press *6 to unmute yourself. You are live. Caller ending in 7204.
PJ, I think that's the meeting ID.
Next caller.
All right, so let's go to caller ending 5565.
Hi, good morning. Can everyone on the board hear me?
Yes, good morning.
Great, good morning. Hi, Mr. Chair, members of the board. I'm Stephen Avdikov. I appreciate the time to speak regarding this project. I have over 30 years of experience in historic preservation. I have a master's of science degree from Columbia University. I'm a registered architect in the state of Florida and in 4 other states. and my experience meets the federal qualifications for architecture, historic architecture, and architectural history. I'm here today to provide my opinion. Also, beyond that expertise as a Miami Beach resident regarding the overlay amendments for the Faena District, and in why my expert opinion, this amendment should not be adopted. It's located within the Collins Waterfront Historic District, which is locally designated in 2000. It's also a National Register District, which was designated in 2011. According to the local designation report, there are distinctive characteristics of an architectural period, architectural and design styles there. 6 Miami Beach architectural styles, including Art Deco, Mediterranean Revival, Classical Revival, and Post-War Modern. It has high artistic value and with significant architects, including Roy Franz, the architect of Versailles, Russell Pancoast, Henry Hosauer, L. Murray Dixon, etc. I think one of the important items to consider with regards to this district is it's extremely cohesive. It encapsulates a highly significant post-World I architecture dating from 1922 through 68. Significantly, in the designation report that was completed 20 years ago, 76% of the buildings were identified as contributing. So there's a high degree of architectural integrity. And it's representative of the architectural and cultural history of the city of Miami Beach. To allow an increase of height of 250 feet on an oceanfront property, as this overlay district would provide, is not in accordance with the criteria as pointed out by the staff report, specifically with regards to item number 3, whether the change is out of scale with the needs of the neighborhood of the city. It's immediately adjacent. The Versailles, the cupola is much higher than the main body of the building, probably 50 feet. So we're talking about a 250-foot tower adjacent, the main body of a building, approximately 100 feet lower. But it's the proximity and the direct height that causes that non-compliance with that item. Significantly, it's in historic preservation district and will be subject to the HP board review. And it's not in accordance with that criteria. As an expert in historic preservation, I've undertaken several certificate of appropriateness applications, and I can tell you, and we do historic tax credits, it's not in compliance with the district ordinance requirements. Specifically, one of the criteria stipulates that new additions, exterior alterations, or related new construction shall be differentiated from the old and shall be compatible with a massing, size, scale, and features to protect the historic integrity of the property and the environment. This is immediately adjacent to this historic building by Roy Franz. It's out of context and out of scale.
Sir, your time is up. Would you like to request additional time from the chair?
I'd appreciate another minute. That would be great. Also with regard to item 9 of the ordinance, regarding the reduction of light and air to the adjacent areas. I just saw the shadow diagrams. It's going to adversely impact the building adjacent. The Versailles was in significant shadow. These were buildings that were meant to be seen in the light. According to Roy Franz, that in the air and sun, that's what people come for. When towers of this scale constructed in a historic district, the exact opposite occurs. Air and sun is transformed to shade and darkness upon buildings and spaces that were intended for the light. So to close, I just want to say I've heard that this project was considered analogous to a thoughtful game of chess. In my opinion, as a preservation architect, it's more like a game of Monopoly being played in an irreplaceable historic district essential to the character of Miami Beach. Therefore, in my expert opinion, this amendment to the overlay amendment of the Faena District, which would allow a height increase to 250 feet, is incompatible both with the scale of the Versailles Hotel and the structures along the Collins Waterfront Historic District and must be rejected. I appreciate your time. Thank you.
Thank you so much for your comments. Let's move to the next caller, Borsa.
I think Borsa is on mute.
Let's go ahead and go to Elizabeth Miller.
Hi, thank you very much, Mr. Chairman and members of the board. I just want to comment that all of the arguments made by the Amman presentation by the Ackerman group had been viewed as discussed from the street, where so many buildings, obviously people drive by. However, I just want to point out that I enjoy the architecture and I also enjoyed the boardwalk. And I believe that most people who appreciate the buildings in Miami are viewing them from the boardwalk, whether they be local residents or people who are staying at the hotels and walking up and down. I think that a lot of people view them from the beach and the boardwalk, and this was never discussed. And the locate by pushing the building closer to the beach, in fact, they reduced the view of the Versailles from the beach and the boardwalk. Thank you very much.
Thank you so much for your comments. Let's go to Mitch Novick.
Hi, good morning, everybody. I'll be brief. I just want to correct the record. Michael stated that the HPB discussed this mural, discussed Jack Stewart's mural in detail. That is incorrect. I forwarded Michael a letter from Deborah Tackett, the historic preservation manager, which clearly states the HPB never had any substantive discussion on the mural until after the demolition order was granted. And I want to state that the developer proffered back then, 5 or 6 years ago, to find a suitable location for the mural and install it on Miami Beach. So it's time the public gets to appreciate and study Jack Stewart's mural once again. And I urge that this board, the planning board, send a resolution to the commission to cite just that. Thank you.
Mr. Chairman, I'd like to make a comment on that, on the mural, since I was involved, and since in full disclosure, Mr. Kasdan and I had a discussion about an appropriate place for the mural, and we discussed that as part of this project, and not necessarily, and as a voluntary aspect on his part, to the city consider placing the mural on the parking garage opposite City Hall on 17th Street. It's a blank wall, and you know, among all the other alternatives which we discussed, were an absence of really very many other places where it would be suitable. It would be visible on Convention Center Drive, driving south as an entrance to the city, and it would be highly visible. And it is really an important aspect of the city, you know, the historic features of the city. So I think we could probably make a recommendation to the commission that the applicant that the applicant pay for and install the mural at that location. So I just wanted to mention that to the board, and I thought it was a very good idea. So the city would not lose the benefit of the mural. It would be highly visible from that location because people would be coming down, entering into the parking garage for Art Basel and other events at the convention center, and also would be visible as part of the New World, you know, ambient scene when people are going to concerts, and it might even be more visible than it would have been if it were restored in its old location. So I think that would be a great idea, and I think the board ought to consider putting that recommendation to the commission.
Yeah, David, I would be in favor of adding that as a recommendation to the commission to accept the artwork through whatever process that needs to happen. Perhaps we can even get the developer to put in a low maintenance fund in there. I know they don't want me to say that, but I'm gonna say it.
Yeah, that'd be terrific.
All right, let's go to the next caller, Larnette Glenn.
Hello, can you hear me?
Absolutely, good morning.
Good morning, Chairman and members of the board. My name is Larnette Glenn, and I'm a condominium owner and a resident at King David Towers at 3411 Indian Creek Drive. I'm here today to voice my opposition to the developer's request to changes to the Faena Overlay District, specifically the increased height of the Amman residential tower. I noticed in the presentation from Ackerman that only the residents of the Faena house were addressed, I don't know if they have louder voices than us or if they have more money than us, but I want to make it clear that those residents are not the only residents that will be affected by changes. I'd like to address the concept of the greater good, a theme that came up repeatedly in the last meeting and doesn't necessarily apply to me and my neighbors. With the exception of the mostly seasonal owners at Faena House, our community consists primarily of full-time residents. We are a diverse ethnic and cultural mix of young families, the elderly, and a large community of Orthodox and ultra-Orthodox Jews. The impact of the requested changes are amplified for those of us who live here year-round and do not have the financial means to take advantage of the quote-unquote good that Amman brings to the neighborhood. Similarly, I can assure you that adding nearly 50 feet to the residence and setting it back to enhance the visibility of the Gulfstream dining room is unlikely to bring any good for me and my neighbors. In addition to the inevitable disruption anticipated from the hotel residents and restaurant, it will create an environment that is inhospitable to local residents, increasing traffic congestion and limiting sun and light on our streets, beach walk, and our beach. I chose to live in this Midtown neighborhood, in this Mid-Beach neighborhood for a myriad of reasons, including access to the beach and proximity to places of worship. The beach is our neighborhood and it's our shared space. It's our town square that brings us together for walks, recreation, and sport. Increasing the height and positioning of the tower will impose on our shared space and negatively impact our quality of life. And while I'm lobbying to protect our community, the impacts of the changes and requested extended beyond the immediate community to the general public. The families that regularly visit and enjoy the beach thanks to the 2 public parking lots. So I respectfully ask that you deny the developer's request and maintain the integrity of my neighborhood. Thank you for your time.
All right, let's, we have, looks like Commissioner Gonzalez, former Commissioner Gonzalez. Go ahead.
Hi, good morning. I live at 4618 Alton Road, so it is not my neighborhood, but I am concerned about this because you have several groups of residents surrounding that are saying no. And you have to ask yourselves, as members of the planning board, who are you representing? Are you representing the special interest and developers? Are you representing the residents who are disgruntled and upset? The Versailles has been sitting there and been allowed to, I guess, just, fall into disrepair over several years. And now it seems like the restoration of the Versailles is contingent upon the addition of this zoning. And you have to ask yourself, should we be rewarding that? Or should we first say, go ahead and restore the Versailles, and then we'll look and see if we add this additional zoning. This is setting very bad precedent in the historic district. As you can see with the Raleigh Hotel and the addition of that tower, now we're going to add another tower. How many more towers are we going to continue to add? And I'd like to finish by saying that the renderings that have been showed do not really show the scale of this new building in context with the Versailles. You are not really seeing a true rendering. Could the city produce a rendering that will really show what this new tower is going to do to the Versailles Hotel? I would hope that when you guys are making this decision, you consider that both the commission and the Historic Preservation Board are going to have to take certain guidelines in place. And as your approvals are being discredited by these other boards or being reversed by these other boards, shouldn't you consider what the residents want and how important these historic districts in context are for our postcard and the city of Miami Beach? Thank you all for listening to me. Thanks.
Thank you, Commissioner. Let's go to Mr. Stern.
Good morning, Honorable Chairman and members of the board. My name is Thomas Stern, and I'm a condominium owner at Faena House, located at 3315 Collins Avenue, directly south of the proposed Amman development. I'm also a full-time resident of Miami Beach. Thank you for once again giving me the opportunity to speak in front of the board. I'm here today as one of 27 unit owners of the Faina House who feel exactly the way I do and do not support this project as currently proposed. With a total of 38 non-conflicted unit owners in the building, I'm sharing the views of the overwhelming majority of Faina House owners. On this, I want to start by reiterating certain key objections made to you in previous letter transmissions and in my remarks to this board on July 27th. The following is really critical for you to understand. Section 142-867 of the City Code that established the Faina Overlay District in 2014 specifically states, the purpose of this overlay district is to allow limited flexibility of uses and limited increases in heights because of the common ownership and operation of the properties within the overlay district. I have no doubt that the developer, his attorney, and the city spent considerable time negotiating and agreeing to this code. Yet the developer and his attorney, Neeson Kasdan, returned to the Historic Preservation
Sorry to interrupt, but you have an appointment soon.
Returned to the Historic Preservation Board in 2016, requesting additional variances. They were granted approval for a 203-foot tower and other variances, notwithstanding that the Faina Overlay District included an approval to build a 200-foot condominium tower. Our owners understand that an increase of 3 feet is limited, and the variances granted were modest and palatable. Now, however, the same developer, in partnership with Amman, along with the same attorney, are once again before a Miami Beach government body seeking substantial amendments yet a third time. A 47-foot increase in height is hardly limited. It's a 23% increase. And shifting the tower 23 feet closer to the erosion control line, including balconies, thereby encroaching upon the beach, is hardly in the best interests of Faina House or the public. We strongly oppose the developer's request to amend the Faina Overlay District Code. The developer has tried to do an end run to have this board recommend changing the law for their benefit alone. Mr. Kasdan and the developer never sought the buy-in of the residents of the district. Why, I ask? He went to the Mid-Beach Association. That's when we first learned of Amman's plans. Perhaps he thought, since the same developer of Faina House was partnered with Amman, our association would just go along. Perhaps he thought, since 2 of our 3 directors had relationships with the developer, our building would just go along. What is being done here and how it's being done are egregious. So much so that our owners recently recalled our board and have replaced them with 3 new board members to ensure that the best interests of the association on this matter can be properly represented. Mr. Kasdan and Amman presented to our owners and our prior board on August 13th as you requested. There was only one meaningful change to their presentation from the presentation to you and to the Mid-Beach Association. I'd like to quote from that particular slide. Quote, in return for supporting the project, current Faina House owners will receive lifetime priority reservations for both restaurant and spa services at Amman Miami Beach, as well as personal charge accounts at the property. Members of the planning board, seeking benefits from Amman is not our objective. We're happy to welcome Amman to the neighborhood. Let them build their project within the confines of the current code and variances. These codes and variances provide ample room for a successful and beautiful project. These are the codes and variances we relied upon when we bought at Faina House. Distinguished members of the planning board, you're an accomplished and well-recognized group who volunteer for the greater good of Miami Beach. The law is clear here, and so is the process. Please don't kick the can down the road to the City Commission. You'll only force them into wasting precious resources that can otherwise be deployed constructively for the benefit of Miami Beach. Let's not set a precedent for taller buildings encroaching on the beach. I respectfully ask you to carefully consider the facts and deny this developer the amendments they are seeking. Again, I remind you of the Faena Overlay District section of the City Code that states the purpose of the Faena Overlay District is to allow limited flexibility of uses and limited increases in heights because of the common ownership and operation of the properties within the overlay district. We relied on this law. Please don't let the developer change the rules to get what they know they cannot get through more variances and design review. Thank you for your time. I'm happy to answer any questions.
Thank you, Mr. Stern. Let's go to Guerra next.
Yes, hi, good morning, members of the board. My name is Tiago Guerra. I'm a resident of King David Towers at 3411 Indian Creek Drive. And while I'm extremely happy the developers are finally going to restore the Versailles Hotel like it was promised to us back in 2014 when this district was first negotiated with the neighborhood, I can't believe that the developer is once again back in the city asking to make changes to a district that was negotiated with the neighborhood, which the Association of King David Towers was part of it and has an agreement with the developer regarding the development of this district. And after all those negotiations, which we made several concessions that have highly impacted our lives here in this neighborhood. And I'm talking about people that live here full time, that, you know, have their families, have their kids going to school, and are highly impacted by everything that happens every day in the neighborhood, including the increase of traffic, all the events, the noise that has been created by the creation of this district. And now I'm flabbergasted that this developer is back again at the city requesting for more height, less parking requirements. And I just beg to the board to not accept these changes. We have made concessions. We have accepted the decrease in our quality of life for the development of this neighborhood. And these changes are not necessary for them to be able to develop a new building next to the Versailles and to finally, you know, make good to the promise that they made to us that they were going to restore the Versailles to its prior beauty. We've been waiting for over 6 years, and now they're putting new conditions to this restoration. And I think that the city should not accept these new demands. Thank you.
Thank you, Mr. Guerra. Let's go to caller ending 8486.
Hello.
Hi, good morning.
My name is Tucker Gibbs. I have offices at 3835 Utopia Court in Coconut Grove. I represent the King David Towers condominium. And my client's focus today is its opposition to the applicant's request to increase the allowable height in the overlay district from 200 feet to 250 feet, and also the decrease in required minimum parking for a place of assembly from one space per 60 square feet to one space per 80 square feet. The height increase should be rejected because it's out of scale with the needs of the neighborhood and the city, because the Faena district was not created and designed with such a height in mind. And the maximum height of oceanfront buildings do not exceed 200 feet for several blocks north and south of the Faena district. The closest property with a building over 200 feet is approximately 5 blocks to the south and is approximately 7 blocks to the north. The 3 buildings cited by the applicant as a basis for this change are not in the Faena district and are not near enough to the district to create any precedent for such an unwarranted increase. Also, the Faena district is characterized by buildings that are 203 feet and less in height, not more. The increase in height and the reduction in parking for places of assembly should be rejected because neither is needed to allow a proposed building to be used for the pursuant to the existing zoning. The existing zoning allows for a 200-foot condominium. The existing zoning also allows for a place of assembly parking ratio, 60 square feet of floor space per car. Currently, The approved plans allow a building to be used pursuant to the zoning code without need of these two proposed amendments. Please note that the recently completed Faena House at 203 feet in height includes some of the most valuable residential real estate in Miami Beach. And no presentation has been made that shows that the reduction in parking is necessary in order to use the property in accordance with the existing zoning. The applicant has presented a proposed project, but your decision today is not about that project. It's about proposed changes to the Faena Overlay District. These changes could allow a number of different projects, and not just this one. I would suggest that you require the applicant to provide to you a building envelope drawing that shows the maximum project that could be built under its proposed amendments, so we can understand all the possibilities under these amendments, and not just the applicant's pictures. For these reasons, the King David Towers urges you to reject the proposed increase in height, the proposed parking reduction, and require the building the building envelope drawing from the applicant. Thank you.
Thank you so much. Let's go to, looks like Mid-Beach Neighborhood Association. No, that's, yeah.
Yes, hi, good morning, Chairman and Board. I'm Anna Marie Mello, the President of the Mid-Beach Neighborhood Association. The MBNA has 52 active members, including condos and hotels along Collins Avenue and Indian Creek Drive from 24th to 63rd Street. At the recent Sustainability and Land Use Committee meeting, the MBNA shared their unanimous support for bringing this high-quality project to our city. Among the members, there is still a lot of excitement for this project. But most recently, in extensive discussions with King David Towers and Faena House, who are members of the MBNA, we learned that these members entered into their investments with an understanding of the Faena overlay constructs, and they are opposed to the changes, and they feel that the proposed changes are not supported with what their understanding would be and what they would receive in return for their investments. The NBNA wants to be sensitive to our neighbors. We are in support of our members, and therefore we'd like to retract our formal support for this project stated at the Sustainability and Land Use Committee, and at this time we will be abstaining from taking a position. I'm here to answer any questions, and I want to thank you all for your time and consideration.
Thank you very much. Bill S.
Okay, can you hear me?
Good morning, we can hear you.
Thank you. I've been a Mid-Beach resident and homeowner since 2001, and I'm against all height increase variances because one begets another and another and another, as we once again see here. It is patronizing and insulting for the applicant to sit there and say that this additional height will have no impact on light, views, and shadows. Shame on you. But what really gets me is that all of the pretty pictures that they show, all of the pretty renderings, all of their drawings are from above, from a bird's eye view. We're not birds. I wish you would require ground level views of these projects so we could really understand the impact from the beach, from the street, from the places that we like to enjoy publicly as residents. Thank you very much. I am against this height increase.
Thank you for your comments. Let's go to F. Borsa.
Good morning, Mr. Chairman and members of the board. My name is Frank Borsa. I'm a condominium owner, 16-year resident, and board member of King David Towers at 3411 Indian Creek Drive. I'm here today to voice my opposition, shared by my fellow King David owners and residents, to the developer's request for changes to the Faena Overlay District to increase the height of the Amman residential tower from 200 feet to 250 feet. These changes to the code established in 2014 will have a significant impact on me and my neighbors. King David is surrounded by Faena properties on three sides. Given our position within the Faena district, we have already made numerous concessions that have a negative impact on our comfort and well-being. These include increased traffic volume, noise and congestion to and from all Faena properties, noise from activities at the Faena Bazaar atrium and rooftop, the constant drone of the generator housed in the 35th Street parking complex, noise from the rooftop bar and restaurant at Casa Faena, and reduced residential and guest parking throughout the area. Now we are being asked to make further concessions that will compromise our sun and light, our beach and beach walk. We know that increased traffic, noise, and congestion are the inevitable byproduct of development, but the impact, the proposed design decisions that will not impact whether the project succeeds or fails, but which will significantly impact the well-being of our community, are unacceptable. The taller structure will block the sun and light in the morning and significantly reduce the time that our neighbors and I can enjoy the beach in the afternoon. According to the developer sun study, by 4 p.m. year-round, the height and positioning of the residence will cast long, broad shadows on the beach, making enjoyment of the beach impossible. The setback, south and east, will already create a dark corridor between Collins and the beach, blocking the last remaining gap of air, sun, and light in the beach neighborhood. I respectfully ask that you deny the developer's request, honor the code established for the overlay district, and maintain the integrity of my neighborhood. Thank you very much for your time.
Mr. Chairman, may I make a suggestion? Apparently there's a number of, we can't visualize from where we are how many people from the King David are going to voice their objections to this project. And basically those are objections that are pretty similar. I wondered if we could elicit how many more people from the King David are going to speak and perhaps consolidate their objections into one voice, so we can, speed up the process. So we know that their objections are pretty much adequately voiced by now, and we have an idea of what they are. So I wondered if that would be a possibility.
Mr. Weiner, I only see two more individuals with their hands up.
That's what I was going to say. There are two more, David, it looks like. So.
Oh, okay. I thought there were like 15 or 20 more, so I just.
Yeah. So to your point, let's take let's take the last two there, and then we'll go from there.
I see. Just for the right, I see three more, Mr. Chair.
Okay, the last three. So we'll cut it off at Andrew Dickman. So let's go ahead. Caller ending 6810.
I think the caller is maybe on mute.
Caller 6810. If you can, what are the instructions to take yourself off mute when you're calling?
*6. *6 to unmute yourself if you're calling from a mobile device.
Okay, let's go ahead to.
I think.
Oh, I'm sorry. Go ahead.
Is that right? No.
Okay, let's go ahead and move to Elliot.
Hello?
Hi, good morning.
Yes, we can hear you.
Hi, good morning, everyone. Svetlana Elliott, the president of King David Towers Condominium Association, located at 3411 Indian Creek Drive. Today, I speak in strong opposition to grant new changes to Aman Group on behalf of my family and my neighbors. I speak to oppose specially additional 50 feet to a new condo development and limiting parking spaces. In the past 10 years, Historic Versailles Hotel has 3 owner developers. Aman Group is the third one. Planning board needs to stop treating the new developers like spoiled children by continuously granting them all their demands. Aman Group has purchased the empty lot and the Versailles, adjacent to Versailles Hotel and Versailles with approved and agreed plans, and they should move on with them. Thank you very much. Have a great day, and please oppose to these amendments.
Thank you. You too, Ms. Elliott. Thanks for your comments. Let's go to Andrew Dickman. Will be the last caller that we have.
Mr. Chair, can you hear me?
Yes. Good morning, Mr. Dickman.
Thank you. I appreciate the time. My name's Andrew Dickman with the Dickman Law Firm in Naples, Florida. I represent Thomas Stern, who you previously heard from, who's owner at the Faena House. I respectfully request at least 5 minutes to make my comments. Neeson Kasdan at the Ackerman Group had much more than that, but I believe I could do it within 5 minutes. Is that all right?
How about Mr. Dickman? We'll give you 3 minutes and you try to make it in the 3 minutes, please.
Okay. I asked that my 4 letters to the city go into the public record. I sent 4 letters, one on the 21st, the 22nd, the 24th, and also the 14th of August that outline much of my argument. So I asked that they be put in the record. I also asked that my email to you last night with a never seen before planning board application be put in the public record. I had been asking for this for several weeks, and magically it arrived yesterday at 3:30, and now it's up on your agenda. That's a very important issue to this matter. It's unclear why this application was created after your July 27th hearing, and it is unclear why it was signed on the 18th of August and notarized just yesterday. I contacted the city attorney's office about these irregularities and asked that this item be pulled so that it can all be sorted out. One of the assistant city attorneys called me today, this morning, and said basically no. To be sure, it confirms that the ordinance before you is initiated by the city and not the developer. There's a very big distinction between that, and I had been trying to determine who had applied for this ordinance. The city now is claiming that it has applied for it. If the developer had applied for it, there would have been much greater notice to the public and disclosure of individuals. The developer should be given no more priority than anyone else in the Faena Overlay District. If the developer wants special treatment, he should file an application, pay the filing fee, and follow the public notice procedures like everyone else. This is not just a technicality. Why are we here? The developer has maxed out its entitlements and variances. That's why he wants this custom zoning ordinance through the legislation. And I heard a speaker previously referred to this as a variance, and obviously the public is confused. The developer shows you wonderful renderings of a building that frankly you may never see, because all this is a zoning amendment. The buildings may never look the way that you are seeing them today. So please focus on the intricacies of the zoning amendment and not the pictures. The ordinance in its current form is customized for the developer's property. Please ask your planning staff how many parcels in the district meet the criteria to build up to 250 feet. The answer is 1. An ordinance changing the zoning regulations for a single parcel and benefiting a single developer is illegal spot zoning. Zoning is the text and the map. It doesn't matter which one is spot zoning. This particular developer is being singled out for a benefit, and it's illegal spot zoning. If you upzone this parcel, there's no going back. That would be considered a taking of private property rights. Have you thought about the unintended consequences down the road? For example, if parcels are assembled, reducing the minimum parcel size, removing the historic property criteria, removing the oceanfront criteria, expanding the Faena district, all of these things can be done down the road in a similar text amendment that you're seeing today. And I don't think you have discussed these unintended consequences that might happen. If this developer can change the code, who is next? Development by legislation is very dangerous. The 2014 Faena ordinance should be left undisturbed. It created the Faena district, which is a unique neighborhood connecting one part of the beach to another. This ordinance destabilizes that vision. I realize you want the Versailles Hotel restored. I realize Amman brand fits the district, but amending the zoning code requires a public purpose that benefits more than one developer. A slightly better view of the historic Versailles Hotel does not justify upzoning one parcel to a height of 200 feet, at least 50 feet higher than any other building near it. Mr. Kasdan.
Mr. Dickman, your time. I give you another minute or so, but your time is up. Would you like to request additional time of the chair?
I would like at least.
Mr. Dickman, just in fairness to those waiting on other items and our time, and I understand that you do want additional time, but if you can just wrap up in the next 30 seconds, I think your point is being made, and we will add those items to the record. But if you can just wrap up in about 30 seconds.
No, Mr. Chair, honestly, I mean, you've had Mr. Kasdan on both of these hearings with multiple times. I'm asking for 1 more minute at least.
You can have 1 minute, Mr. Dickman.
Thank you. Mr. Kasdan and his client met with the FANA Association, as you heard from Mr. Stern, and that leadership at the condo there will change, and you will have significant opposition. I spoke to Mr. Kasdan yesterday and asked him to pause and consider my client's position and possibly work with our client, and he said he's always willing to talk. But this is not Mr. Kasdan's ordinance, it's the city's. You are the designated local planning agency for the city. It's your job to study and determine if this land development code change is consistent with the comprehensive plan. Staff has concluded it is consistent, but they have not given you an analysis. Don't get sidetracked from your local planning agency responsibilities with the Amman experience. Staff has correctly questioned the height increase. They've also questioned the light and air criteria. We agree. You should strike those from the ordinance immediately. They are dangerous upzoning from which you can never go back. Don't change the 2014 FANA vision. It's working. Amman has plenty to build with in the current entitlements. My client supports Amman, but at the 203-foot design. My client cannot support the ordinance in its current form. And therefore, I would ask that you continue this item. And given the fact that my client is going to have a new board at the association, that you instruct the developer and the city, since it's their ordinance, to work with them and going forward. And just for the record, I have not seen the new map that you all are seeing. I have not received my public records request. One of the board members mentioned that he had discussions with Mr. Kasdan off the record, and I would say that that's an ex-party discussion that hasn't been disclosed. Thank you for your time.
No, Mr. Dickman, just in clarification, he did not say that he had an off-the-record conversation. He just acknowledged that he just had a conversation. So, but thank you for your comments and do appreciate them. And then we just have one more. This person has been waiting. I just hate to cut them off. So let's give them 2 minutes. Frank Megginson.
Mr. Chair, you also had, there was a caller who I think we tried to queue up ending in 6810. I think that individual was in line before too. So I'll set the clock for either one, whomever's first.
Okay, 6810.
Good morning. Thank you for the opportunity of speaking. My name is Frank Megginson. I'm the director and president of Penthouse A in Manor House. I would just like to express my full-hearted support for Thomas Stern and for the other members of the public who've spoken here. There is a city ordinance in place. Any amendment to that would be an abuse of the cultural, historic, architectural, artistic, and aesthetic merits of the district, and I would urge you to vote against it. Thank you very much.
Thank you, Mr. Megginson. Okay, with that, we're going to close the opportunity to speak from the public, and we're going to turn it back over to the board to have discussion on.
Mr. Chairman, may I just, since I was referred to a minute ago,
sure.
My disclosure was in full compliance with the board's regulations. I disclosed that I did have a conversation with Mr. Kasdan. It was not off the record. I disclosed that I had the conversation, as is totally permitted by our function. And so I just wanted to set the record straight on that, as you had recognized a minute ago.
And thank you, Mr. Weeder. I wanted to speak to that too. Since this is a legislative matter, and not a quasi-judicial matter, you were obviously it was within your discretion to make that disclosure, but ex parte communications would not be required to be disclosed.
Thank you.
So I have a question for staff, Mr. Chair. Now is the time.
Absolutely.
So, Michael, we're in the ordinance. We're putting in a required setback from the front from Collins of 75 feet, if I read it correctly. Is it necessary for us to codify that setback and force the building to be setback 75, or can we leave that open for the HPB's preview to have the flexibility? I understand the height is something we need to vote on. I'm just not sure why I need to codify the front yard setback.
I think that the purpose of the requirement for the front setback is to provide greater visibility to the Versailles hotel structure, the original structure. Now, of course, if the board doesn't make that change, then it'll fall back to the underlying zoning regulations, which would require a 50-foot setback.
So I understand we want to codify, hey, if I give you this height, we're giving you this height because you're saying you're doing it in order to set back the building. But the HPB may very well not approve the height increase based on other criteria. And at that point, we would be forcing the building to be set back 75. So I'm just not sure. I understand the intent. I'm not the HPB. I'm not the one that's going to provide the certificate of appropriateness for the ultimate design. All these designs being presented to me are great. I'm looking at this as just the base regulations. As we all know, what gets presented to the HPB may very well be different once it gets through staff. So what I'm trying to do is just keep it open and flexible for the HPB to have the ability to determine what the correct design will be for this site.
Sure. So the planning board. Sorry, the planning board could, for example, recommend in favor of the ordinance with these changes. That could be a recommendation. It could be, one or more items you could recommend for modification as part of your recommendation to the city commission.
Then with regards to the setback requirements, the side street setback, the rear setback, the front setback, we're including all of these. I just want to be clear. This is a unified development site. So none of these setbacks are impacting the existing Versailles hotel that's there now.
There's no proposed modifications to the pedestal or tower on the oceanfront. It's only on the south side. And if for example, these amendments are not included to allow a reduced setback from the south side, then absent a variance, they'd be forced to push the building closer to the original Versailles Tower.
So I'm just to clear, in the ordinance, I'm seeing something referring to 8 inches. Item number V. Can you explain that to me so I'm clear? Because I understand now we're talking about the south side. This is a whole district, by the way. So the south side, you're referring to the city-owned parking lot on 34th Street.
Correct, yes. And that was, let's see. Right, and that's consistent with, so just for additional background information, the project that was approved previously on the site did receive numerous variances to push the new tower as far to the south to the city parking lot as possible. And these proposed changes are consistent with the variances that were approved previously. So if the planning board were not to include these changes in the ordinance, they'd be required, if they wanted to modify the variances, go back to the Historic Preservation Board to have them modify the variances that were previously approved because of the increase in height and the slight shifting of the site plan. That would be the other mechanism for approving these setbacks.
Yeah, just going back to this is a district-wide amendment. You know, I certainly foresee these buildings standing for a very long period of time, but Lord forbid there be some type of disaster and things need to be rebuilt. These would be the prevailing regulations for new development. So I do think the board's consideration, I understand we're codifying it. I think it's too specific to be codified based on a specific design that's being presented to us that we're not approving today. I'd like to hear the board's comments if they feel this is something that the HPB would be better suited to vote on as actual variance, knowing that for this particular site, there is a vacant GU site to the south, and that pushing the building massing southward wouldn't be a bad idea. Again, I am not approving a site plan or a design today. I'm just looking at land development regulations.
Right, and that's correct, Daniel. And I think that we definitely need to keep that in mind. And I think what you're saying, we should consider looking at this on the 75 feet. I read it before. Which item is it in the ordinance exactly?
Let's see.
The 75 is going to be on the section A, item GI. It's where it states the setback is being codified.
Okay, maybe I'm looking at the wrong version.
It's going to be in the actual ordinance on page 2, or I'm sorry, yeah, page 2 of the ordinance.
Okay, I found it. Somehow I have two versions of this very similar. So I see it now.
Oh.
May I speak to this for one moment?
Absolutely. Go ahead, Mayor.
Thank you. Mr. Baker, a couple of things I'd like to point out. That this is designed to provide maximum spacing and from the historic Versailles Tower, which means that the building would be of necessity pushed to the southern end of the property. And so whether it's this building or any other building, that's the envelope that would be required. And the public purpose there is to preserve and expand views for the historic Versailles Tower. Problem is, if it has to be by virtue of variance, then that makes it a much more difficult and questionable process. I would tell you, frankly, that when we sought the original variances back a number of years ago for the predecessor building, the King David Tower was paid a significant sum of money in connection with their not being opposed to the variances. And by the way, just note for the record, there is no shadow impact whatsoever on King David Tower, which is a block away. If you look at our shadow studies, you'll see that. So, I think it's this provides the regulatory framework for building a new structure on a site that contains an important historic structure, and we think it should be incorporated in the legislation. We think that's a preferable way of going.
Mr. Mayor, I have a question. Mr. Dickman addressed some illegalities, technical illegalities, which I don't quite understand. I wonder if you could give us an explanation as to what he's talking about.
Well, Mr. Weed, I'm not exactly sure myself, but the city attorney, I think, has obviously.
Yeah, well, I was going to ask. Yes, I was going to ask him that question.
Just to address a couple of things that he said, that he's called it spot zoning. This is not. This is legislation that has a public purpose, principally of which is to provide better views and setbacks from an important historic building. This property is actually not the only one that could utilize these modifications. If the Faena House was ever redone with the Saxony, it too meets the same qualifications and could take advantage of the same criteria. And as far as calling it spot zoning as well, this is your classic case of spot zoning is you put a gasoline station on one corner where there are 3 houses on the other corner. We're not changing use. We're not changing density. We're not changing intensity. There is a slight adjustment and modification of the regulations, setbacks, height. And by the way, the plan overlay ordinance specifically did contemplate additional height. Now, the objectors may say that it's not minimal, but there is no dispute that additional height was specifically contemplated, and they have yet to tell us what they think additional minimal height is. I would even point out that at one time it was contemplated that a 220-foot building would go there. And Justin, not to bore you too much with history, Mr. Reader, but in 1997, I introduced when the city was reducing heights along Collins Avenue, in reaction to buildings like the Blue and Green Diner, which is 450 feet, I actually introduced an ordinance that said that the height for Collins Avenue RM3, this site on similar sites, should be 250 feet. That was in 1997. Because if you take out the rhetoric and the emotion, if you study what has been built, and that's why I brought the tour forward as a case study. If you study what has been built, you will see it is a totally appropriate height and allows for more architectural freedom and a better design and allows for greater setback and space with the historic building. And not to mention as well, if I may just one thing, you're talking about creating a lot of good paying jobs, a lot of tax revenue to the city from an extremely low impact project, less hotel rooms, less condominium units. This is not the Ocean Drive scene that we're trying to get away from. And what we're hearing is a few people who live nearby who want to preserve, a couple, 2, 3, 4, 5 degrees of view and block a project like this from coming to reality. That's not good public policy. Thank you.
I have some things to explore, Mr. Chair, when it's appropriate.
Absolutely.
But we haven't finished with the other issue. I wanted to ask Nick about his viewpoint on Mr. Dickman's legal arguments.
Yeah, thank you, Mr. Weeder. I just wanted to respond to your question. I spoke with Mr. Dickman this morning, and I've been a party to a number of emails on this application. One of Mr. Dickman's questions was as to the application for the amendment, and I understand that the application for the amendment was posted on the city's website after the agenda printed. But to Mr. Dickman's point about the form of the application and the disclosures of interest, because the developer sought a private sponsor rather than file a private application. I'm sorry, because the developer sought a commission sponsor rather than file a private application. The amendment was sponsored by a member of the City Commission, referred to the Planning Board by the City Commission, and is therefore, as a formal matter, is a commission-sponsored amendment. So that's why the form that's posted on Novus lists the city as the applicant, because even though it may have been sponsored for the benefit of a particular development or overlay district, it was sponsored by the City Commission rather than a privately sought or privately applied for application. If it were privately applied for, you would have before you the typical disclosures of interest that a private applicant would be required to complete.
So what we have is a private application cloaked in the officialdom of the commission?
Well, what you have is a commission-sponsored amendment. I really think that's it, Nick.
it's an ordinance that's brought before the planning board that was sponsored by the commission and for us to consider. And I think more to Daniel's point, you know, I'm in favor of what he said about, you know, not necessarily tailoring this too tightly in terms of some of the things that may be more applicable to one particular development versus another. And his point about, hey, you know, if there were, you know, God forbid, some need to rebuild, you know, you would have these, you know, things that may be there for a particular purpose that may not be applicable later. So I'm fine with amending or changing some of the recommendations within the ordinance to the point that was made earlier.
I agree with that. Daniel usually makes good points. So
yeah. So but let's go to Mike Barano really quickly.
Sorry to interrupt you, Mike.
Yeah, no worries. Thank you. Thanks, everybody. Actually, Kareem, Nick Gelpy wants to make a comment. I think that as the architect on the board, I would appreciate the opportunity to hear his comment, maybe before I speak. Is that okay?
I see you now. Go ahead, Nick.
Hi, everyone. I apologize for being late. I just had a quick question about the presentation of the site plan configuration, speaking about the front setback. If I look at page 31 of the presentation, it shows that the previously approved front setback is 76.4 feet, and the proposed setback is 96 foot 10 feet. Sorry, 10 inches. Could you just clarify, because we're speaking about codifying a 75-foot setback when it was previously approved at 76, and they're proposing 96, if I understand it correctly. Could you just clarify that?
Yes, Mr. Gelby, what we are doing is, so under the existing overlay regulations, the setback would only have to be 50 feet on the west side. So what we are proposing to do, so that it opens up mandates under the regulations, a greater view of the Versailles, is that it be a mandated setback of 75 feet. Now, what we are actually showing you as well is that the proposed new building, which is now, it's not theoretical, but is a pending application that is going to go before the Historic Preservation Board, provides the setbacks that we just showed you, which are 96 feet. So even greater than this code provision would require.
Okay, thank you for clarifying. That was my quick question. I'll comment more after you, Mike, so go ahead.
Okay, thank you, Nick. And I hope you're having a great time in Colorado. It doesn't look like Colorado there, but so a couple of things around the idea of the Versailles, perhaps for Mayor Kasdan. Will that be branded? Are both buildings? Is it anticipated that both buildings will be branded as the Aman brand and operated as one hotel? How will that work?
Yes, Mr. Barano, both buildings will be branded as Aman. One will be the hotel specific, that's the Versailles, and the other will be the residences, which will also be able to have hotel services, but they'll be both branded as Aman.
Okay, so what I'm trying to get at is some of the things that Mr. Dickman and I think Mr. Stern mentioned that we think, okay, this sounds we're interested in this idea, and then we don't end up with Aman, we end up with something else. So that is the plan, and we have just last month we considered a proposal in North Beach with the International Inn where we're exchanging a significant investment in historic preservation in exchange for some height. I think that is something that we routinely consider in Miami Beach, how to make sure that our 2,611 historic buildings continue to be invested in. What is the anticipated investment in in the Versailles? Has that been determined at all? To what degree will it be restored?
I'll get you that information in just one minute as the amount of the investment. Mr. Byrne, I understand your concern and your question. Of course, this legislation is not tied to a specific owner, that's for sure. But we do know that the developer now of the property is Aman, is Oko and Aman Hotels, that Lat Doronen, the partner, the lead developer, owns the Aman brand. And he has determined that what he is proposing is necessary in order to develop a property of this quality and caliber. And it also has the same benefit, not incidental, but also benefit for the public benefit in terms of the restoration and opening up, bringing up of the Versailles. We'll get you, give me 1 minute. We have the economic impact now.
While you're doing that, because a follow-on to that same idea, and really it's kind of a follow-on to Daniel's, comment as well. To what degree do we, how tight is this zoning ordinance, considering the Miami Beach process will kick in? This simply opens the door for them to have the opportunity to submit to the HPB. Am I correct about that? And maybe I'm asking staff. And although if we were to authorize the 250 feet, the HPB could come back and say, no, we don't like the building, we don't like the height, we don't like I think parking. They can accept or reject any portion of it. Am I correct about that?
Yeah. Thank you, Michael. You're correct. What the board would be approving here, or ultimately the city commission with the ordinance, is the maximum, basically building envelope in terms of height and setbacks. Historic Preservation Board, could take a look and say they think the building is too tall, or recommend stepping or setbacks. That's why we sort of did indicate in our staff report for this ordinance that we did note that there weren't any immediate buildings that were over 200 feet next to this property, but we did note of the potential benefits that could result from the height increase by moving the square footage higher and creating more openness to views of the Versailles as going north on Collins Avenue. Mm-hmm. So we did leave that open in terms of the Historic Preservation Board having the final review authority for that item.
I have an answer to Mr. Barano's question, that the total hard costs and soft costs for both the hotel and the condominium project are projected at $266 million.
And that includes restoring the Versailles.
Restoring the Versailles. The hotel alone showing a hard cost of $100 million.
Right.
One other thing, if I may, this is the subject of discussion.
Well, make your comment, Mayor Kasdan. I'm not quite finished, but go ahead.
Okay, I appreciate that, Mr. Barano. I know we're discussing, and I appreciate the willingness to give us flexibility by leaving it up to the Historic Preservation Board. But one thing that has to be legislated, and it is for the sake of, in perpetuity, preserving and providing the best situating of a building vis-a-vis the Versailles, is the side yard setbacks on both the north and the south side, because there's an addition as well to the historic Versailles. Those should not be subject to variance and the vagaries and of going through a variance process. Those should be baked in the legislation. We're willing to live with a 75-foot setback on the west side, but the others, and if you wanted to dispense with it, you could, but we're telling you that when we build, we'll do more of a setback. But the others, particularly the setbacks on the north and the south side, are essential in order to allow for the restoration of the Versailles and the construction of a new building that would be appropriately distanced from Versailles, just the same way Faena House is distanced from the Saxony. And any building that would ever be built would need these variances. It would need these not variances, but would need these relaxation of the current setback requirements.
Michael, will you yield for just 1 second for a question on the building height to Mr. Kasdan? I just wondered if the pedestal design of the building is rendering the building necessary to have higher height. Isn't that more height? Is that correct? I mean, is that pedestal area useful? It's not, it doesn't seem to be useful for parking. What is the purpose of the pedestal to increase view or to make the scene a more view friendly?
It's both. You put the finger on it. Yes, it does enhance the quality of the units, and it's important for them to be able to sell the units in order to finance the entire project, including the first-class restoration.
And it would seem there's a resiliency issue there as well. Is that fair?
Yeah, it opens up, obviously, the view at the ground level and the first 2 stories to the beach and through the parking lot to the property. And there is also some programming in there. It's not all lobby. If you look at the east side of the building, there's a gym and some other things. So the lobby is a relatively small part of it. So,
and how high is that pedestal?
Excuse me?
How high is the pedestal to where the units begin?
55 feet.
55 feet. So that would account for the additional height of the building. Is that not correct?
Well, I mean, yes. I mean, you do need to have there's a first floor and a lobby level, which always has a higher height. So some of it is there. Although, as I said, there is programming in the east side of the building with the gym within that 55-foot envelope, in addition to the lobby.
Thank you. Michael, I'm sorry.
That's no problem. So I am, just to kind of put a cap on that point, I am sensitive to Daniel's suggestion. I'm interested in hearing more what the board thinks about. I just don't want to be, I don't think we should be in a position of making it too tight so that the HPB board has its hands tied and the affected residents and stakeholders, don't have a full measure of feedback overall. And I think that also protects us a little bit on the outside chance. I understand it's not likely, but on the outside chance that it ultimately is not an Aman branded property. Regarding the residents and the feedback from folks, last month I was persuaded that there were perhaps quality of life issues related to Faina, and I think one of the King David residents spoke, and nobody from the King David spoke at our first meeting. This is a continued item from last month. So I would be, without opening it up to full public comment again, I would ask the chair and the board how we might explore. I would like to hear more about how. I was concerned that the shadowing, how this is going to impact the quality of life. That's what I'm hearing. If you're just against height, period, if you're just against height all the time, I get that. That's a legitimate perspective. But if you're saying that building this Aman Hotel and restoring the Versailles is going to impact your quality of life, and if you live nearby, I'd like to hear maybe from Mr. Dickman and Mr. Stern, and perhaps of somebody at King David as to how from their perspective how this is going to negatively impact their quality of life.
Mr. Chair, I see that both Mr. Dickman and Mr. Stern and Ms. Glenn have their hands up. I think in fairness to Mr. Dickman, Mr. Kasdan's been able to speak freely with the board, so you may want to allow him a couple minutes.
Yeah,
if I just a question of order, as long as we keep public comment open, then we're going to continue to allow people to make comments. We have left public comment open. Mr. Ackerman's law firm has clearly been deliberating, so I'm open to allowing additional public comment. But once we're satisfied with public comment, I'd like to officially close public comment, which would close it to all. And that way we can deliberate with staff moving forward. So I'm okay with allowing additional public comment at this time.
That's a good idea, Mr. Vaitia.
Yeah, let's do that. So let's take Mr. Digman, but let's, Mr. Digman, we're gonna limit some time. This is not going to be an unlimited amount of time to speak. So I appreciate you recognizing that and being conscious of the time.
Could you also explore a little more? I'm curious to know about the board change, you know, and what's going on at Faena. Is last time I was pretty comfortable that Mr. Stern was speaking on behalf of a significant number of folks who live next door. I'm unclear about that at this point.
Mr. Chair, am I speaking or?
Yes, go ahead, Mr. Digman.
Okay, thanks, Nick, for responding to my email. I think it's inappropriate to leave Ackerman's mic open and let them advise the city. It's the city's ordinance. However, I will say that what is happening right now is that you're designing a project by legislation. It's complete, staff is completely not giving you the full truth that if this goes to HPB, yes, they can control the design of the building, but at the end of the day, you still have that legislation up to 250 feet. I tried to explain that to you all, that this is legislation that will be codified forever, and don't be misled when Mayor Kasdan describes the building and talks about how it's going to go through HPB and this is what you're going to get. I tried to list.
How is that going to impact your clients? How's that going to impact your clients' quality of life? Please, that's my question. I don't know. The board may have other questions.
Well, first of all, my client lives in the district, the neighborhood, and the neighborhood is going to be impacted. You heard from our expert, Steve Adtikoff, the architect, but 200 feet, you just look at the 200 feet alone. If you look at their proposed design, they have a rooftop amenity that's going to be 50 feet above my client's building, 50 feet. And we all know that the city has problems with rooftop noise. I've represented clients throughout the city where there's code enforcement problems all over the place. So, the 50 foot is just it is a very specific issue. 50 feet and the setbacks are very specific issue. I'm going to let Mr. Stern speak to the internal workings of the condominium. I think you do need to hear about that. But again, stop looking at this project and this building, because this is not what you're going to see. And if you think you are, then you're just designing by legislation. And that's probably illegal, and we'll find out about that.
Okay, let's go ahead and hear Ms. Glenn. You spoke a little bit about the impact to the way of life with regards to where you live. Can you speak to the question that Board Member Barano is asking?
Can you hear me now?
Yes, we can.
Okay, perfect. I wanted to start out just addressing the issue of the shadows. Even on the graphic depiction, you can see a canyon of shadows. But from my personal observation, when I go out to the beach, I walk on that beach every day. Even now, just with the Faena house alone, there is shadows that are cast over the beach, far reaching out into the sand. If we add another 50 feet on a building, there will be an impact for us. Saying that it doesn't impact our building, it doesn't mean that it doesn't impact me. When I utilize the beach, I would like to have a little sun when I'm out there. That's the whole point of being out at the beach. A couple of other things is the less parking. I would like for any of the board members to please, Saturday, come over here, just drive through and look at, even with the 2 full parking lots, how many cars are parked on the side streets, are blocking entrances to some of the buildings. This past weekend, there was the entrance to the parking garage, even at the Faena Forum, was blocked by cars because people are coming over here to go to the beach and there's not enough parking right now as it stands. So minimizing the parking would be a disaster for us. The increased traffic would also be an issue for us. And lastly, and most importantly, the noise. Currently, of course, everything is shut down over here. But when the Faena house, the Casa Faena that's next to us, they have a small rooftop dining party area up there. When they have people up there, not only is it the noise from the music, but the echoes from the voices are so loud that with my doors closed, I can hear it inside my condo. And my condo is not facing their side. It's on the center facing Indian Creek. And I can clearly hear the noise with all the windows and the doors closed. So imagine having a much taller rooftop with the echoes and the sound emanating from that. So there is a large impact on us. And I also want to point out that this is not a court of law. So the former mayor should not be allowed to filibuster and have opening and closing statements and defend his arguments. Thank you for allowing me the time.
Absolutely. Thank you so much. And then let's Mr. Stern, you'll be the last speaker from the public, and then we're going to close the opportunity to speak from the public again.
Thank you, Mr. Chair. Appreciate having the opportunity to speak again. I too want to echo the sentiments of the last speaker from the King David. I don't understand why Mayor Kasdan has an open mic. This is a city-sponsored ordinance, and you're giving a private party an opportunity to have unlimited time to rebut anything they want to rebut. I want to go back and say again that when Faena House owners purchased in the building, they purchased in accordance with the overlay district codes. And those codes specifically talk to limited increases in heights. Mayor Kasdan has said repeatedly that 23% increase, 47 feet, falls within the characteristics of being limited. He came in front of our owners and said the increase in height is de minimis. Look up the definition of de minimis. 47 feet or 23% isn't de minimis. The movement of the building to the east will impact our quality of life. It affects our view fields despite the percentages that Mayor Kasdan has shown. He has shown it without balconies. Balconies also have a substantial impact. We did not buy into Faena House expecting a 250 tall tower to sit next to us, dwarfing Versailles at 183 feet. And what you're being asked to do is codify into law a change in the height of this building and the position of the building. And we're adamantly opposed to it. When we brought up shadowing the last time, it was distorted as shadowing on us. That is not the shadowing we were talking about. We were talking about the shadowing that impacts the public beach, which we care about a lot. I know I was asked about the internal issues at Faena House. I will tell you that we have a 3-member board. The prior board was comprised of 1 member who is a chairman and CEO of a very large global real estate firm, has ties to and does business with OKO Industries, or OKO Group, which is the owner of Aman, and with Len Blavatnik, who is the head of Access Industries, who's the co-developer. And one of our board members was the brother of Len Blavatnik, who is the developer of Aman. They never disclosed their conflicts of interest. They never apprised the unit owners until after the presentation to Mid-Beach Association of their conflicts. And I will tell you that our owners are deeply, deeply upset about how this has all gone down, how it's been an end run around us. When all the unit owners were reached out to and explained what was going on, 27 of them came up in opposition to this, and yet the association board was not willing to take a position. That now has changed. We have a new board in place. We will be taking a position in opposition to the Aman development, and specifically the amendments you are being asked to approve. And again, I'm really troubled that Mayor Kasdan has an open mic here when this is a city-sponsored ordinance and a change in the laws. We bought into the Faena Overlay District. It is a district. And this property has a cap on construction of a new tower of 203 feet. And its position was set back in 2016 when Mayor Kasdan went before the HPB. And again, I ask it, please don't let this continue. Don't kick the can onto the commission and then onto HPB. Thank you.
Thank you, Mr. Stern. With that, we're going to.
Yep, Mr. Chair, motion to close public comment.
So, do we have a second on it?
I'll second it, since I'm the one that opened it in the first place. So.
And Mr. Chair, I just have one quick comment to make. In fairness to you and how you've conducted this hearing, is I don't believe that there's been any sort of open mic. I think board members have had questions that they wanted the developer to answer, and I also think that the board has been very flexible as far as allowing members of the public additional time. So I don't think it's fair to characterize the way the hearing's been conducted as anything other than a fair and professional discussion.
No, absolutely, and I don't want this to turn into somebody who is making a presentation against one particular entity or party from the public either. I think we've had robust conversation from the public, and I want to make sure that we acknowledge that. And thank you for saying that.
And me too, I want to add, I enjoy having the opportunity to ask the public to clarify questions that help us in our deliberations and understanding of what we're going to vote on. And I certainly feel that's what we're doing here.
Absolutely. So we have a motion on the floor. Michael, it's been moved and seconded. You want to call the vote?
I'm sorry, I missed the motion, guys. What was the motion?
That was just a motion to close public comment.
Yeah. I just want to call the vote on it, make sure.
Okay. Motion to close the public hearing. Mr. Batia?
Yes.
Mr. Milan?
Yes.
Mr. Weider? Mr. Juppy?
Yes.
Yes.
Mr. Berno?
Yes.
Mr. Pietro?
Yes.
And Mr. Bradley?
Yes.
Thank you.
By the way, it was always the chair who opened and closed public comment. We've never had it done by motion before. Is there a reason?
I think Daniel wanted to make sure it stuck this time. Yeah.
Yeah.
And I apologize. I don't mean it is a preview of the chair. On other land use boards, you'll notice that they formally close public comment at every single item. At least that's what the HPB and DRB. So that's what I'm accustomed to. But by all means, we can do it whichever way the board feels comfortable with. I just didn't want anyone from the public to feel that they didn't have a chance to speak.
No, I think they were all granted a very generously amounts of time to speak.
So I don't know where the board wants to go from here. I just want to make a general statement. Going back well before 2016, the Versailles Hotel, which was a condo at that time, suffered from significant special master violations. The building was in complete disrepair, and there was no investment being made by the existing owners at that time. So, when we look at historic preservation and trying to preserve these buildings, there is an economic formula that comes forward. And I am so happy to finally see a plan for the Versailles to be restored, because this whole Faena district came about for the purpose of finding a way to restore their Versailles Hotel. So, I understand everyone's concerned about historic preservation. There is a cost to historic preservation. It is significant when you look at completely rehabilitating a building of this age in the oceanfront environment to live another 100 years. So I certainly value the increased development against the preservation, trying to find a way for that to work. I do want to work with the board on codifying setbacks. I don't want to create a code specific to a design. I'm weary of that. I think that's why we have land use boards that can look at a subject application and evaluate it from there. I certainly think, in relying more on Michael here, how to codify setbacks abutting a GU site. Maybe that's a better way of codifying this. I also want to ask staff a little bit about the fences. The setbacks on the fences seem to be greater than the setbacks of the buildings, and I just don't know that we should be codifying every little aspect of it and allow the land use board to look at design to do that. And I'd like to have further discussions with the board on that.
Yeah, I agree with Daniel on that point. And also, you know, when I first addressing the contextuality of the building, when I first served on the Historic Preservation Board a long time ago now, the years are flying by, but William Carey always said that good architecture is of its time. And I don't see that as being out of context with the Collins Oceanfront Historic District at all. In fact, I think it's a splendid project. So I've always opposed, or not always, mostly have opposed height increases. But this seems to be, in my view, perfectly in context. And I applaud the historic preservation of the Versailles. I mean, it's been in just disrepair for so long, as Daniel's pointed out, and splendid hotel come back to its full glory.
Yeah, I'd like to echo some of that as well. I love supporting creative investments in our historic properties, and I think this is a way to do that. I do believe this is in context. I will remind everybody who is against this that this is just the beginning of a process, and I also routinely speak on how much I believe in our process. I think our process works. We are advising the commission, the mayor and commission, on this issue. They're under no obligation to follow our recommendation. And then even if it goes there, it ultimately has many, many more steps where there'll be plenty of opportunities for public feedback, whether it's the rooftop or whether it's parking or setbacks. And so I do support Daniel's proposal to take the setbacks out of the zoning ordinance so that can be further explored as we move along. And so with that condition, I'm a yes today.
Can I make a recommendation? Because I know the board is concerned about some of the setbacks, but I'm just thinking that, absent a change, they would be required to have a very substantial setback along the south side property line. So to Daniel's point, to simplify things, rather than have all these separate setbacks for subterranean, pedestal, tower, balconies, we could leave it more broad and say the subterranean, pedestal, and tower side setbacks shall be 0 feet for properties abutting a GU zone parcel. And that would give the flexibility of the Historic Preservation Board to require a greater setback for one or more of those items if they felt it was appropriate.
I'm okay with, if you want, I'm okay going through the ordinance, section H, and going through each item and trying to figure out which is the best way to do it. I understand, subterranean is really important. People need to understand that we're all talking about height, but if this developer wasn't willing to underground the parking, we'd be looking at a pedestal that blocks all of the views to the ocean, air, and light. So, I think there's value to what you're proposing, and I don't want to take out what you may have thoughtfully felt needed to be in there. I just want us to stop thinking about a specific design and codify and word it in a way that can apply to anything within the overlay district. And I know we did that by defining 70,000 square feet to start as far as what this is applying to, but nonetheless, I think we should specifically go through each line item and look at what you feel should be codified or not, and word it in a way that gives the HPB the flexibility. Again, the developer does have to work within the constraints of the code. We're increasing the height. That surely gives him a lot more flexibility to work on a design that's beneficial for everyone.
I like that. I think that's exactly how I echo that comment.
Right. Let me ask a question, Michael, before we start. So I'm looking, I had a second version of this. So in my final version, item GI is not.
Yeah, I'm sorry. GI, as read before, which says any building whose height exceeds 203 feet shall have a front setback of 75 feet. That's supposed to be included in the ordinance. So that's, I'm sorry, there were different versions floating around. That requirement is in the staff recommendation for the ordinance. Okay. So unless the board wants to take it out, that 75-foot setback will remain in the ordinance.
No problem. I just want to clarify before we start going through these one by one. So we'll have a discussion on that. I think for me, I'm fine with it staying in there. Does anybody have an opposition to that at this point?
Could you restate what?
So it basically says any building whose height exceeds 203 feet shall have a front setback of 75 feet as measured to the closest face of a balcony. Absent that condition, the required front setback is 50 feet, and then you could have a balcony encroachment 6 feet into that required setback.
So this new 75-foot, that's to the outside edge of the balcony.
Of the balcony,
no
right.
balcony encroachment into the 75 feet.
Correct.
Okay, so Nick Jelpe, what do you think about what was just proposed?
I'm happy with that. And look, I mean, I agree with the public comments that we're not approving this design. It's true. This could look quite different, but I feel that that's an appropriate setback for this site plan. It makes sense. The owner is kind of volunteering to do it. But to Daniel's point, by codifying that, I guess it would be for any future building in the district. So I wonder if there's a way to oblige the owner to agree with this setback without codifying it.
Well, I think it's plans now, and also just to clarify, sorry, this in terms of the ordinance right now, the only RM3 parcels that are within the FAINA overlay that this would apply to. This would only apply to the Versailles site, which is the Versailles Hotel and the vacant portion next to the parking lot. And then it would apply to the FAINA House and the Saxony Hotel if they were combined again into one development parcel, because they're over 160,000 square feet. But they would have to probably do some demolition in order to go higher with new square footage.
They're below 203 feet, correct?
Right. But if they were to combine the site with the Saxony Hotel, they would meet the threshold 70,000 square feet requirement, and they could take advantage of the same height allowance that's afforded or is proposed for the RM3 portion that consists of the Versailles Hotel.
Right, but Michael, why don't you look at it in an additional way? Why is it being proposed? The 75 feet, to my understanding, is being proposed to increase the site view from the pedestrian sight line at the street level. Is that not correct?
Correct.
So I'm in support of that because I do think it will increase, and it forces the developer of any property that would fit this ordinance to start to think about compressing their building. And that's why you're giving them the height.
Exactly. This is really integral to the height. I wouldn't, if you take away the height, then I wouldn't have this requirement in here.
Okay, so if the setback, if it's closer to the street, then it can be shorter and squattier. Yeah,
They're going to spread it out at a lower level instead of compressing it vertically.
Mm-hmm. Mm-hmm.
And I agree that staff, they do a lot of analysis. So we do need to go one by one with staff to try to figure out why it is that they are recommending this. Particularly, again, they've started an ordinance with saying this only applies to buildings or lot sizes that are 70,000, unified sites that are 70,000 square feet or larger. So I don't mind going one by one and trying to make sure that, by trying to create something good, we don't throw out what staff feels is important to ensure the best project possible. I just want to also make sure that we think of it on the flip side and, allow the HPB board the ability to do their job and not make their job harder by not giving them the flexibility to decide what's going to be the best design within the context of the site.
Well, I do think so. What's clear in this condition, it says any building whose height exceeds 203 feet. So if the HPB felt that the height was inappropriate, they could say, no, keep the height at 203 feet and locate that additional square footage in the lower portion at a closer setback that the code allows otherwise to Collins Avenue. So I think there is some flexibility in here.
Give them total flexibility because they reduce the height.
You're not hampering that. Well, if you take
Daniel,
away
what do you think about that, Daniel?
No, I'm okay. I mean, the setback of the Versailles Hotel appears to be about 75 feet. We certainly aren't going to want any new development to not share that setback from Collins.
Correct. Yeah.
So I think I'm okay with it. It's just, again, trying for us to remember that we're not designing code amendment specific to a design. It's to the whole district. So that being said, I think I'm okay with the 75 feet. Overall, they're showing us pictures that show 130-foot setback.
But Michael, you're proposing to make it contingent on a building over 203 feet, is what you're saying.
Yes, that's what it says. So if it's over 203, this is the setback you provide. If the HPB says they feel that's too tall, then they could reduce the front setback along Collins Avenue, and that would not be in violation of the ordinance. And then just one last point to Daniel's point. We are looking at this in terms of massing. We're not looking at a particular design in terms of city staff. You have the Versailles Hotel, which, remember, had a giant addition to the south side of it, very close to the parking lot. That was removed to open up views to the Versailles. So in terms of the overall massing, you think about where it's best to be located. You want to push the construction away from the Versailles, so that pushes it towards the GU zone parcel. And that's the reason for most of these proposed setback requirements. So I think we're looking at, in terms of, I think subterranean is very important. We're concerned about pervious open space and landscaping. So I think we have separated out those requirements, especially the front and rear. I think what we have is very good front and rear. And in terms of the side elevation facing the GU lot, we're talking about a variation between 8 inches and maybe 3 feet, whether it's subterranean, pedestal, tower, balcony. So I think if you wanted to simplify it and make it more flexible for Historic Preservation Board, if you lump those all together and just say a 0 setback, because effectively, whether it's 8 inches or 3 feet, it's going to be negligible in terms of the impact or view as viewed from the neighboring building or the parking lot.
I'm concerned about Michael. You're talking about items under H 5, 6, and 7, correct? Lumping those together.
Yes, it'd be.
Actually, it'll be 4, 5, 6, and 7.
Yes.
I have another question that's troubling me about the argument that was presented by Mr. Dickman about a totally different design occurring in the same space, and that we are legislating an issue that could be changed by the design. I mean, part of the reasons I'm voting for this building is because the design is very important, and the design allows the view to the ocean and seems to be very allow a great view of the Versailles heading north on Collins. So what are the implications of a change of design? How is that? What's the answer to that argument?
Well, I think in terms of our review, the overall design, the massing will remain the same. You're going to have a greater setback along Collins Avenue. You're pushing the massing back from Collins. You're going to have, in order to distribute the FAR with those setbacks, it's going to require a higher structure, and it's going to require it to be closer to the GU zoned parking lot. You're not modifying the rear setback along the oceanfront. So there is a very finite area for the construction. And ultimately, I know that this is something that they are ready to submit to the Historic Preservation Board. So we've met with them. They've done a lot of work. I'm sure they're not going to just switch the plans. But in terms of what the planning board is reviewing, you're correct. We're not reviewing a specific design. We're reviewing the code changes. But I do think with reasonable confidence that there is a design that you've seen and has been shown to you, which unless this completely stops and comes back to you, in 4 or 5 years, which is what happened before. There was a design that was approved for the site. This is back before you today because of design. The design has changed, and if they wanted to change it again and modify the code, it would come back to you again. But absent a requirement to review by the planning board, for example, if they have mechanical parking, that would come to you. But otherwise, absent this ordinance, this will not come back to the planning board for review.
Will this be subject to a 50,000 square foot rule as a unified site?
Because that only applies to commercial districts, not to residential districts.
And I prefer to go one by one because I think you've put a lot of thought into this, and I hate to force you to make amendments to a code based on our comments. I know you put a lot of thought. I know staff does that, so I don't want to rush you in any decision. I can speak in general terms, but when we get to specific, there are other things to consider, like the setback in the front yard. There's a porte-cochere entrance, right? The setback isn't just to the tower and the pedestal. The setback is to any construction. And I want to make sure that whatever I'm trying to achieve, that we use your expertise and in-depth knowledge to guide us to make sure that we're not creating something as good as we think we're doing is creating some harm. So I'm okay with the 75-foot setback so long as you understand that there is a porte-cochere that you're trying to introduce or restore for the Versailles, and that won't impact what you're trying to do there.
Sure. You want to go through the items?
Yes, I think we should do that. Let's start with item 8.
So H1 and 2 are connected. This refers to additions to an existing contributing building, an attached addition. So this, for example, would allow a ground floor addition, in this case, to the Versailles Hotel on the north side, following the existing setbacks, so the contributing structure.
I don't have an issue with that. Let's go to the next, and then board members can chime in if they have an issue.
I'm fine with those.
And let's do, so the next items, actually 3, 4, 5, 6, and 7 all pertain to the side setbacks for ground level additions to the existing structure. So this will pertain to the first item, which is 3. It says the required pedestal street side setback for a detached ground level addition is 2 foot 10 inches for the first and second floor. Number 4 is the required pedestal street side setback for a detached ground level addition is 8 inches for the third and fourth floor. So this is prescribing different setbacks depending on the floor. I mean, that's why I think in this case, it'd be better to combine these into, as I suggested, the subterranean pedestal and tower side setback shall be 0 feet, or else, 8 inches, make it something that's consistent. Right now, it is very cumbersome by having separate setbacks depending on a floor that you're on. Typically, we have pedestal setbacks for portions of the building below 50 feet and tower setbacks for portions above 50 feet. So if you wanted to put it more in that form, it would make more sense.
And I support that. I also want us to remind ourselves that side setbacks are usually used to create view corridors. And I support this because I understand I'm creating a separation between the Versailles historic structure and the new development. So is there a way to codify that separation? We're removing the combined yard setback, side yard setback. We're removing the other setbacks to create a view corridor. Do we try to codify that so that there is some type of view corridor maintained? again, I'm very supportive of the HPB. I'm sure their certificate of appropriateness issued will take that into consideration. Do we need to codify that view corridor if we're removing the side yard setbacks?
I think that's something that, from my perspective, the Historic Preservation Board will be reviewing in consideration of the new project. You're right. You don't want to have this approve all of the setbacks along the south and have the building oriented in a north-south manner, abutting the Versailles property. But I think that's something that the Historic Preservation Board, would not approve. So I do think that, without looking at the plans to see what was shown for, the proposed concept plans, I wouldn't want to put in a number without, reviewing that proposal. I think maybe you could, as part of the recommendation, recommend that there is a separation of towers listed in the ordinance for consideration for the commission to review as part of their review on first reading. We could take a look at that number, between now and the city commission review.
I'm okay with that. Again, my support of removing the side yard setback is to allow that tower orientation to be pushed to the south in order to create a view corridor in separation from the Versailles. So if we're codifying one, we should codify the other and support you adding that to what we recommend a commission.
Seems like it would depend on how much confidence we have in the Historic Preservation Board upholding the view corridor philosophy that you just mentioned, Daniel.
Well, why don't we add some exception that states, we could reduce the side setback in order to provide a view corridor from contributing buildings? Can we do something like that? Or is that what you said already?
I mean, there is an argument to, giving the HPB flexibility, but do we as a board want to take a chance that those view corridors would be preserved?
We could be more generic and say a view corridor shall be provided in a manner to be reviewed by the Historic Preservation Board between any proposed new ground level addition to an existing contributing structure, something to that effect.
But wouldn't that be a design criteria, not something that we codify so much? I just want to be consistent, and I also want to remind ourselves that GU doesn't always remain GU as we learn these days. So I want to make sure that we take all these things into consideration.
I think putting the language that a view corridor shall be provided provides the intention without an exact number.
Yeah, good idea.
Again, why I'm supporting the subterranean zero setbacks is to allow these pedestals, these parking pedestals that often don't allow us. We create these view corridors for tower, but the pedestrian is always looking at concrete because they're always looking at that pedestal. So that's something to take into consideration. If they're willing to, remove those pedestal types of setbacks. Then I'm much more, that's going to create the view corridor. But I support what staff is saying.
So are you okay with us lumping conditions H, 4, 5, 6, and 7? Like I had mentioned, the subterranean pedestal and tower side setbacks shall be 0 feet from properties abutting a GU zone parcel, and which also provide a view corridor between an existing contributing structure and any proposed new tower addition in a manner to be reviewed by the Historic Preservation Board, something to that effect.
I think we can do that.
I agree.
I agree too.
So call the
and
question.
That takes care of. We're going to take a motion, a vote on that item.
Call the question.
Mr. Vitia.
We need a.
Yes.
So I'm sorry. We need a motion and a second. Is the motion to amend the draft, or is the motion to adopt the? I'm sorry. Is the motion to amend the draft before you, or to transmit to the City Commission with the amendments?
To amend the draft at this point.
Okay. So we need a motion and a second.
I'll move it.
I'll second the item as described by staff to amend items 3, 4, 5, 6, and 7.
Right.
Okay, Mr. Batia,
Yes.
Mr. Maland,
Yes.
Mr. Weeder,
Aye.
Mr. Berno,
Yes.
Mr. Jelpy,
Yes.
Mr. Pietro,
Yes.
and Mr. Brantley.
Yes.
Motion passes. So the next item is number 8, which is the required subterranean rear setback is 46 feet from the bulkhead line. Absent this change, the required setback is 50 feet. And this pertains to their underground structures, including parking from the bulkhead line. So we didn't want to have this reduced further. This gives them their parking and also preserves the open space that was previously shown to the Historic Preservation Board. So I think that's an important difference that I believe should be retained.
Yeah, the underground structure won't be visible anyway. Right?
Correct. We wouldn't want to have it closer and have it impact, the permeability of the site.
I support items 8 and 9 as written.
I do too.
Same here. Let's go to item 10.
The required front setback for at-grade parking and driveways is 8 foot 6 inches. So absent this requirement, driveways, except for entrances and exits, must be located outside of the front setback, which is 20 feet. So this allows a driveway to encroach. So you would have the edge of the driveway at 8 foot 6 inches from the property line facing Collins Avenue.
Any issues there, guys?
No.
Girls?
Not for me.
Okay.
No.
All right. Continue, Michael. Let's run it.
Okay, we're doing good. The required setback in the dune preservation overlay zone from the erosion control line for a fence is 5 feet. So typically there's no required setback for a fence. So that just provides a greater than required setback for a fence. So unless you want to remove this would allow them to place a fence at the erosion control line.
So can you, just on the whole fencing, on all of them, because there's a lot of items on the fence. Can you understand what you were reviewing that led you to feel that you needed to put this in there for fencing? Because that's super specific.
Right. So part of the reason this is put in initially for fencing is that until recently, the height of all fences on a property, the maximum height is measured from the center line of the front of the property. In this case, it would be Collins Avenue, even though the property slopes up towards the erosion control line at the rear. So let's say you have an elevation of, this is extreme, 8 feet on Collins and 12 feet at the erosion control line. That's a rise of 4 feet. The code allows a maximum height of 5 feet as measured from Collins Avenue. So effectively that would result in a 1 foot tall fence from the apparent adjacent grade along the ocean front. Now we corrected that in the code a couple of years ago, allowing for the height of fences along the rear to be measured from the beach walk for the required rear yard. So within that portion of the rear yard, we take the height, the baseline from the beach walk versus Collins Avenue. So that takes care of most of the issues, but you still have a transition point between that elevation and the Collins Avenue elevation. So that's why the language is in here for the second to last item regarding fences. It basically allows the fence height to be measured from the adjacent grade.
And I got that for item 16. So I agree with that. And I've gone through a permitting process and understand that that's a little correction we need to do because it doesn't really always apply. So I agree with 16. Now we're not talking about height. We're talking about setbacks. And we just approved a 0 setback on one side. And we're requiring 5 feet setback. So I'm just trying to understand that.
It would probably make sense to remove that requirement. It's really not necessary.
I agree, yeah.
I agree as well. I don't think I need to codify the fencing. I agree on your height with the fence. As far as the side yard, I don't want to I want them to be able to secure their property, and I'm sure staff can approve at an administrative level what they feel is an appropriate location for the
And
fence.
the same would apply for the next item, which says the required side setback in the oceanfront overlay zone for fences is 5 feet.
So we could remove 11 and 12.
Remove those, yes.
I support that.
Yeah, do we need to move that, or is all happy to move it?
Is there a motion to remove those two?
No,
Yeah, and then just questioning 13, just to put it all together, which is the pedestal. You know, I don't differentiate a fence.
Yes, I agree. Yeah, I agree. Yes, we can remove that. That language comes from when you can't get a variance for more than 3 feet in height. And because of the great difference in the grade elevations here, the fence would have been more than 8 feet in height as measured from Collins. So the variance they received previously was from a side setback because the fence was effectively greater than 8 feet measured from Collins. But with the modifications that we have later on, there's no need to have items 11, 12, and 13. So is there a motion to remove those items?
I'm okay with moving it. I don't think we need a motion, but I'm okay with removing. The rest of the board is okay with it.
I mean, just in keeping, since we did the other, let's amend the draft order with a motion and
I'll make a motion to remove those items as stated by staff.
Second.
Mr. Vatia?
Yes.
Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Jelpi?
Yes.
Mr. Barano?
Yes.
Mr. Pietro? And Mr. Brantley?
yes.
Okay. The next item, which is 14, is the maximum permitted width of a porte cochere is 52% of the width of the building's frontage. So absent this inclusion here, the code does allow a porte cochere up to 30% of the building's frontage at a maximum height of 16 feet in height. This basically would allow the recreation of the original porte cochere on the Versailles property, which doesn't comply with the current code requirements. So this would basically allow that reconstruction, which is also tied to the next item, number 15, which is the maximum height of 19 feet.
Can we attribute that to an existing contributing structure, or is this also going to apply to new construction?
Yeah, no, we can, if you want to, that's an important point. For a contributing building, we could say that.
Yeah, I mean, we certainly know the hardships associated with trying to preserve the building when it's new construction. We're certainly giving them a lot more of a design envelope that they can maneuver and not create these structures within those setbacks. But I support it if it's associated with the contributing structure. You mentioned 52. I'm looking at 45% width. Am I looking at the right ordinance?
No,
it was updated to 52 based upon additional documentation and microfilm of the original porte cochere. So the number should be 52%.
Okay, just to make sure I'm looking at the right ordinance, I think I'm looking at the right one. 52 was not in anything given to us. We're going to amend what's showing us 45 to 52.
No, that's what I was saying earlier, Daniel. You're looking at the prior. You're not looking at the final ordinance.
The agenda says 52, right, Michael? I'm looking at the agenda. Yeah.
So the 52 is equivalent to the original design.
Michael, why don't
on the rear side for the porte cochere?
Why don't we just say maximum permitted width of porte cochere is, to correspond with historic documentation of what was previously there? Does this apply?
Yeah, you could do it. Yeah.
Yeah, because
maybe the maximum permitted width and height, combine the two for number 14 and 15.
Even better.
And just to the point of height, just looking at historic structures, as I've dealt with this in other ones, the historic height may not always accommodate today's vehicles and where height is measured from. I'm okay with the 19 feet. I think that's more than enough height. But if we had something at 10 or 12 feet, we'd want them to have the flexibility to raise it. But here I am okay for this particular district to include it as proposed by Nick.
and then we'll combine them, correct, Michael?
Well, I think.
Oh, you want to keep them separate now for the 19 feet and the 52?
Do you want to keep the items separate, Daniel? The height and the width?
No, I'm okay as proposed by Nick and looking at the historic context of it and allowing what was historically there.
So, yeah, so if that's going to be the case, Michael, then combine them.
Okay, so the portico share would not exceed the width of the original construction and may be permitted up to a height of 19 feet.
Right.
So that would give the flexibility to raise it, as Daniel mentioned.
Great. I'll move it.
I'll move it as well. Second it.
Mr. Vitia?
Yes.
Mr. Milan?
Yes.
Mr. Weider?
Yes.
Mr. Barano?
Yes.
Mr. Chelpy?
Yes.
Mr. Pietro?
Yes.
Mr. Brantley?
Yes.
Okay. The next item we touched on, which is the adjacent grade for purposes of fence and wall heights. So I think we can leave that as is.
Yeah. That makes
And then
sense.
the last item is the additional item to allow security guardhouses not to exceed 200 square feet as an allowable encroachment into the required front pedestal setback.
Which number is this? I don't see this in the.
You may be looking at the old version. On the website, it's
clicked on the-
listed. It should be final ordinance for August 2020 PB meeting.
I see. Okay. That's number 17.
So
number 17.
Specific to guardhouses are, so we're saying that the footprint for the guardhouse can exceed 200 square feet. So we're limiting the size of the guardhouse. Am I correct in understanding that?
Yes, and also allowing it within the required front setback.
That I think is the primary reason for it. 200 square feet, is that too much? You know, that's a 10 by 20. You know, what's the average size of a guardhouse? I mean, I think this is, again, more in the context when the HPB is looking at everything. But if we are going to put 200 square feet, don't I want to minimize the size of this guardhouse to the minimum because it is an encroachment in that view?
Yeah, do you want to put a lesser number? I think 200 square feet is pretty large.
Yeah, 50 would be closer, right?
I would do a 10 by 10, guys.
10 by
That's
10, 100 square feet. Yeah.
That's a modest walk-in closet right there.
Yeah.
I agree, Nick.
Yeah, I support that. And do we need 2 guardhouses, or do we want to force them as a unified development site to limit encroachments and consolidate these types of structures and amenities?
I mean, we're allowing, the way it's written, Michael, you're allowing 2 guardhouses into the front.
2 guardhouses. It's not a prison.
No, no, but you may need 2 guardhouses, but would you need them both on the front? Do you need them both into the front setback? We're talking about the front pedestal setback.
Correct, yes.
Because I could see why you might need one at the rear. I mean, I can't see a reason why, but that's not to say there isn't a reason why.
I mean, also, you know, it says the location and design is subject to the review of the Historic Preservation Board. So,
I think we could leave it as is. I don't know. I hate to eliminate that option if it's necessary for some reason. Maybe there are 2 separate entrances to the front.
So Michael, why don't you just do this? Just have it read: the number of guardhouses shall be limited to 2 per property, and the number, location, and design of such shall be subject to the review. That way you limit it to 2, and then if HPV wants to limit it further to 1, just add number.
Add the number, okay.
Michael, I wonder, I hate to add an 18th, but should these be separate items? So 1 is about the setback for the guardhouse and 1 is about the number of them?
No, I think it can all be combined. So
Again,
that would be 2.
I just, you know, I think it's a historic building. You're trying to create security. I understand that. It's just guardhouses are structures, you know. I mean, we're doing all of this to create this openness at the sidewalk level. And again, I'm not on the design portion of approval here, but I just, you know, guardhouses are structures that really pop out of nowhere, you know, and take away from that openness. I'd like to challenge the architect to find out how you create modern security amenities, but maintaining that the built context of what's there, you know, and guardhouses do protrude really close to the roadway. So those are my comments. I'm okay with the will of the board, but those are just my comments.
I mean,
somebody want to make a motion to lower the number to 100 and add in the number, location, and design subject to HPB review and approval?
I'll move it since I made the amendment.
I'll second it.
Okay, Mr. Batia?
Yes.
Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Jelpi?
Yes.
Mr. Barano?
Yes.
Mr. Pietro? And Mr. Brantley?
Yes.
Okay. So I think we've gone through all of the changes.
Wait, what? But should we revisit the height?
Oh, if you want to, if you guys want to discuss the height, sure.
You know, I just had some thoughts listening to the public comments, and you know, this is a tricky one, and it's a common tension that I feel. You know, I think height exceptions, you know, should be considered. At the same time, I feel, you know, what is the point of a district overlay if individual properties are free to break it? And I find Mr. Stern's arguments clear. However, when I look at the language, it doesn't say no height exceptions. It says limited height exceptions. And so I feel that the definition of, you know, what is a limited height exception, I wish there could be some agreements upon that between the two parties. But I feel that zero is difficult. I do admire the site plan maneuvering in order to, you know, better present the historic structure. I do think the historic structure is a hardship and it's worth putting additional resource into it. So any way to assist in that, I feel is, you know, worthy of our consideration. That's the tension that I see in this application here for the height. But I do think they ought to be allowed a certain amount of height. And I guess the question is if 50 feet, you know, is limited, 23%.
Nick, you know, Nick, I actually agree with you. I understood there wasn't any kind of limitation in the overlay. And so I do, you know, I'm always the one who is on this board who is better off with height versus mass. I'm always the one pushing for that, you know, but, you know, until Mr. Stern spoke, I didn't realize that the overlay did have some sort of limitations. I understood that it didn't have any kind of limitations. And so, you know, we have to certainly honor that people did rely upon these kind of overlays in making certain decisions. And it seems like, you know, this is now going contrary to that. Now, what is limited? That's the issue. We don't know what that is. But clearly, the people at the tower, the residents, don't think that 50 is limited because they're fighting this. Now, I don't know if they'd fight if it was 10 feet. So they may fight if it was 2 feet. I don't know that. But, you know, again, usually we're not stuck with, or there's no overlay that we're dealing with when we deal with mass versus height. You know, oftentimes we don't have that kind of issue, but here we do. And that's really troubling for me right now. So I don't know if you guys want to comment on that, what you guys think about that. You know, going through this, and I love the project, and I think, you know, it looks great. And I think, by the way, for the residents, I think that, you know, perhaps it would be better, you know, with this modification to the overlay district for them. I think it ultimately would be. But, you know, I do have to recognize that there is something out there that people relied on in making certain decisions.
I mean, the only comfort I get is that I feel the HPB is very considerate. They take everything into account when they're looking at the actual design. And as long as they understand that we're giving this height in order to create something better at ground floor, including the removal of a parking pedestal, which could really just take away the air and light that a pedestrian feels. I think I like providing that kind of flexibility. I'd hate to see the increase in height and then you don't get any of the benefits that we're all, basing our height increase on.
I think the height increase is a tricky issue, but the design is so spectacular, and the other benefits that we get are good. But I'm not sure about the guardhouses. Those guardhouses, I don't know why we need guardhouses. This is on Collins Avenue. I mean, wouldn't the guardhouses be somewhat objectionable? It doesn't. I just I really I'm trouble with the guardhouses. So I'd like to revisit that again.
Sorry to interrupt, but you have an appointment soon.
I'll just add to Mark and to everyone's last comments. I do think this is a very complicated one, and I wish it weren't so difficult. And I think I'm comforted by, as Daniel said, I'm comforted by the knowledge that it's we are simply opening the door to this as a possibility, and that the HPB will have the final say, and that they will really dig into all of these issues and have the opportunity to listen to residents, as will the commission. Frankly, they could still say no. So, but I think for me it tips. That's what gets me comfortable with a yes vote at 250 today.
So I'd like to. Is it possible for me to change my vote on the guardhouses?
Was there there was a vote? So I don't necessarily think there was a vote to. So there was a vote to limit the square footage, and incorporate and combine the conditions. If there's a member on the prevailing side of that motion who would like to reconsider it, and I think Mr. Weeder, I think you could move to reconsider that item, and that motion would need a second, and the board would need to vote on it, and then the item would be back before you.
I would second the motion for reconsideration on the guardhouse.
Okay, Michael, would you like to call the roll?
Sure. Mr. Vitia?
Yes, for reconsideration.
Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Jelpi?
No.
Mr. Berto?
Yes.
Mr. Pietro? Asa? And Mr. Brownlee?
You're muted, Kareem.
So the reason I want to reconsider it is the only guardhouse that I can think of is the blue and green diamond. And I really don't like that guardhouse structure at all. It just takes away from that view corridor. I understand the need for security, but how do you minimize a structure in that setback? You're trying to keep that open. And I don't know what their security plan is, but I just know there's a lot of ways to secure a site.
Yeah, I agree with that. I think on Collins Avenue, guardhouses would be out of context with the spirit of the openness of the neighborhood. Place is not a prison, and with modern technology, there are different ways to appropriate the space, and I don't think we need I don't want to.
You're proposing nothing on Collins Avenue, or nothing at all?
No, nothing. No guardhouse. Period.
No guard. That's what I mean.
But to clarify for everyone, we've established 75 feet as the front setback, and what we're allowing is for a guardhouse to project 8 feet into the 75 feet. Is that correct? We're not putting this
no
on Collins Avenue.
No, 8 feet into the required 20-foot setback for pedestal structures. The required setback is otherwise 20 feet.
So it
Wait,
could
so
be.
How can a pedestal be set back 20 feet when our front required setback is 75 feet?
That's for structures over 203 feet in height.
Which this is.
No, this would be a separate structure. The guardhouse would be a separate structure. So the guardhouse is detached. It's not part of the. It's not part of the rest of the.
The guardhouse could be 20 feet from the street. Then is that what you're saying, Michael?
Yes, absent this amendment, the pedestal setback is 20 feet. So a guardhouse, an enclosed structure, would be required to be set back 20 feet.
Why don't we just have, the language is confusing. Instead of saying 8 feet into the required front, why don't we just have a guardhouse setback? Just say what it is.
Yeah, I understood it the way you understood it, Nick. So that's the way I voted on it.
Does that imply that we are advocating a guardhouse in the ordinance, in the legislation that we're recommending?
It sort of says it's contemplated.
Yeah, I don't want that in there. I'd like to see just let the setbacks remain where they are, and if the HPB decides that they want to grant a variance for a setback, let them do it that way. I'm opposed to a guardhouse.
Couldn't a guardhouse be considered an accessory structure? What are the setbacks for accessory structures?
Accessory structures are not allowed with reduced setbacks in the front yard. The only time you can do accessory structures with reduced setbacks is in a required rear yard.
Michael,
so that would not apply.
If there are board members who oppose the introduction of that guardhouse paragraph, I mean, wouldn't the amendment be to delete it altogether?
Sure, yeah.
Okay.
Somebody wants to make that new motion to delete it.
And what will happen if we delete it? It'll just be up to DRB or HPB?
No, they would have to comply with the 20-foot setback or request a variance.
Yeah, I'm fine with that.
Yeah, I mean, we're giving them, they have a lot of room between 20 feet and 75 feet to figure out where to put this structure.
Yeah, I agree with that. I was under for some reason, my brain got stuck on it being added to the building and not a separate accessory structure on its own. So with that, I will take back my my comments on it, and I would just move that we remove it.
I would agree with that.
So this would be a motion to delete paragraph 17, right?
Correct.
Okay.
Mr. Batia?
Yes.
Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Jelpi?
Yes.
Mr. Berno?
Yes.
Mr. Pietro?
Yes.
Mr. Brantley?
Yes.
I will strike that condition.
So I just have one question because I'm looking at the correct ordinance now that just has one little thing I didn't see in the original one, which was the parking for place of assembly. The parking requirement for residential units remains the same. You're looking to change the parking requirement for like ballroom space or open space?
This would apply to the Faena Forum. That's the one place of assembly that's been approved and that the district allows in the RM2 zoning.
Isn't that already built?
Yes.
So why are we amending that if it's already built and not associated with the district? I'm just confused why we're making an amendment now. Was there something proposed that they're trying to do that we're not aware of?
Not that I'm aware of. I mean, if you wanted to open up the public hearing and ask for Neeson's comment again.
I don't know. It's a staff thing. You know, I'm sure you guys have had conversation as to why this was in an ordinance. Can you help me understand why this is in there?
I honestly, I don't know why that was included. It came as a proposal from them. Tom?
Daniel, it's Tom. Neeson would need to confirm, but I believe, and Neeson would need to correct me if I'm wrong, but I believe that they don't need the same number of spaces for that assembly space that they needed under the current code. That it basically was over parked. And so rather than having those be required parking spaces for that use, they'd like to reallocate those. But Neeson could confirm that. We certainly have no objection to it.
So I understand. So Tom, thank you for that clarification. So by reducing this, they can use some of that existing parking space to fulfill their parking requirement for the new construction. Am I correct in that?
Or another use.
I'm okay with that. I don't want to increase the parking requirement. I think if we all remember, they did an amazing parking plan of undergrounding the parking on the west side of Collins. I've never been down in that parking garage, but I know that it's in a very efficient way to provide parking, and I am okay with reducing that requirement so they can reallocate that to a better use.
We need to vote on that, or?
No, I was just asking.
Okay.
So I think, do we have any other changes to, I think that's it at this point.
Do Mark and Nick have specific suggestions regarding the height, specific recommendations that they'd like to share?
Oh yeah, we can go back.
If different from 250?
Well, yeah. To me, that is the most contentious issue here. And I would just like some consensus on, what we see. I actually think 23% is fairly limited. Of course, 50 feet is 50 feet. But if you consider that a single family home can be up to 27 feet above base flood elevation, there are all kinds of ways of considering it in relation to what's built. I don't think the shadows that are going to affect the beach are out of line with what's already there. Whether it's 10%, 20%, I think 23% is pretty close. And if we're not getting some suggestion from the neighbors of what would be a limited minimal height exception, when I read the language, it does say limited height exceptions. So I have a hard time voting for none at all. And then given the maneuvering of the site plan for certain public benefits of the historic structure and the hardship, I find it appropriate. I just wanted to give the board the chance to discuss this because height restrictions seem arbitrary. It's just that in this case there is an agreed upon overlay, and I would read it to say without any reason there should be no height exceptions. But here I see some reasons for it. David Weeder is usually opposed to all height exceptions.
Yeah.
Well, I mean, is anybody opposed, given that it does have the word limited, which is without definition at this point? I mean, Nick, I don't want to put words in your mouth, so please correct me if I misstate something that you said. But as an architect, is it correct that your training, your kind of like thinking on this is that 23% or 20% is not excessive, and it's not something beyond the word limited?
Is it possible for us to get another rendering in front of us so we can look at the contextuality and the design on this issue? Because I think we're all operating on memory. My memory is that it's not non-contextual with the neighborhood. That's really the issue we're talking about. So right. I'd love to see a picture again. Is that possible for us to see, Michael?
Yeah, we can have them pull it out. 1 second, David, but let me just make sure I heard Nick correctly. Is that what I was saying, Nick? Is that correct?
I think it's close to what, and again, I don't know that there is a legal definition for that, but in my experience, a 10 to 20% increase. This is 23 approaching 25%. Could we restrict it to 20% increase in height? I just wonder. I think it's close. Somewhere within 10 to 20 would be I would be comfortable with that.
Yeah. The only reason.
What's your opinion about how contextual it is, Nick? I understand you're thinking about the expectations that are set by the original overlay ordinance, right? As the 10 or 20%. But what about, because I find it to be contextual with the neighborhood. From my perspective, it is. What is your opinion?
Yeah, and again, I guess it depends on what you define to be the neighborhood. You know, the issue.
Well,
was
how
brought
big
up.
you? How
Right.
big
Well,
it
the
is
issue.
cast.
The issue was brought up that there's nothing above 200 feet within 5 blocks. 5 blocks, you know, I think is still within the neighborhood.
Yeah.
I do find it to be reasonable. I mean, if it was double, if it was a 50% increase, and it was much wider and causing a shadow that's out of context with the other shadow profiles, I think it might be slightly longer. But if you look at it, it's narrow, and it seems consistent with the shadow profile of the Faina house itself. So
it just seems like an improvement over those buildings that were built like in the 60s, where you go in the area of the 47th Street up. Those were really the concrete canyons. And don't forget, you had the Saxony Hotel, which turned into the Faina house. And this is just a beautiful piece of architecture when you look at it. I mean, the design is stunning.
Right, but David, are you comfortable with it being 300 feet tall?
No.
250?
I'm comfortable with I'm comfortable with the 250. Yeah.
Because you like the building, David. That's why.
I agree. I like the building as well, and I think it's a good operator, and it's going to be a great addition to the city. And
that's a big feature of it. I mean, if you look at if you look at architectural innovation throughout the years, I mean, you see buildings that are out of context and that are world renowned. I mean, I think there's a huge subjectivity to examining the value of the structure. I mean, yes,
at the same time,
ad hoc increases in height are just absolutely unacceptable. But I think under these circumstances and with the concessions that they've made and the probability they're going to move the mural to some other location, there's a lot of stuff that we have to compromise on. And I think this isn't much of a compromise in terms of the height on this particular subject. I don't want guardhouses though, but I do think that this building is a very valuable addition to the neighborhood, and it's beautifully executed. So yeah, let's give them a few more feet.
But to be clear, this is an ordinance amendment, so another building on another parcel could also do the same, which I actually find to balance it out. The Faina house hopefully could take advantage of this in the future somehow. I think Michael mentioned they may combine properties. But I find it to be incremental. I'm comfortable with it. I just thought, we certainly should have a discussion about it.
Yeah, I mean, we keep on talking about height, and it's surely a lot easier if I was on the HPB and I can tie the height to a particular design and other proffers that the applicant is making. Hopefully HPB more members or staff will keep them apprised as to all the discussions that were had so that no significant changes to the design are made. But, as many of you know, I spend a lot of time on the water, and I get to look at the whole oceanfront height from the water, maybe about, a half a mile out. And, the oceanfront's pretty tall. If we're talking about a district surrounded by single family homes, it's a little different. But when you look at it within the district, I think it's compatible.
Yeah, I was trying to say that before. Yeah, that's correct, Daniel. You're right.
Particularly with me as a pedestrian, it's all about parking pedestals. That's what kills me. That no matter what we design as a building, we're trying to fit all of this required parking in this box that the building sits on top of that blocks all the air and light that you truly feel as a pedestrian, as someone driving down Collins. My neck doesn't go any higher than 20 stories. What happens after 20 stories, I'm really not as impacted. And for me to feel that impact, I need to step back. And the only way I can step back is when I'm on the ocean. And that's when I can really see the context of height as far as an entire district. And yeah, there are areas when you go from 200 feet to 400 feet that you see a significant increase where clearly there was some change in zoning. But the relationship here, to me personally, I feel it's within context.
Daniel, Mike, I have one concern maybe for everyone is that, we're amending the ordinance, but we're not linking this to any subterranean parking or any, existing adjacent contributing structure. Is that something we should do? I mean, do we want to allow this throughout the district without those conditions, which we view as hardships? Because that's
well, it is limited to sites that have an existing contributing building.
Oh, it is.
So
Okay.
it is, yes, and all the parking they're providing now is underground.
But another property could potentially have a parking pedestal.
So how could we address what is the issue on spot zoning? What does Nick think about that? Is if we tailor the ordinance to be specific to this building, is that spot zoning? I mean,
well, I would defer to staff on whether the I don't read the ordinance, the text of the ordinance to be specific to one building, right? I mean, these just stepping back a minute, these amendments were first adopted because there was a comprehensive plan to redevelop, a several block area of the city, and there were certain accommodations made to account for existing contributing buildings, to account for new buildings, some of which have been built and some of which have not yet been built. And I think that I view the amendments before you as more technical, technical amendments to a broader plan that the City Commission adopted, a few years ago when the Faena Overlay District was created. So, I've looked at this issue with staff, and we do not read the proposed amendments as creating an island where certain uses are permitted that are not permitted on the surrounding properties. I mean, if anything, these are amendments to the design regulations for the broader Faena Overlay District.
so what if I understand you correctly? You're saying that that's the reason it can't be considered spot zoning, and therefore we could tailor the ordinance, the amendments to apply only to this particular property.
I agree with you up until just the last part, because I don't think, when we amend the code, we're not amending the code for one particular property. Now, if it happens that at this moment in time that there's only one property within the broader district that would qualify for these amendments, that's one thing. But there's nothing in the code amendments before you, and staff can correct me if I'm wrong, but there's nothing in the code amendments before you that are you're not approving a project here. You're approving legislative amendments to the LDRs.
Yeah, so the fear is that if we do it for this one, then it's the next one that comes down the line is going to be we're going to be hamstrung by what we've enacted today.
When you say the next one that comes along, do you mean the next component of the Faena project, or do you mean the next request from Faena, or do you mean the next height increase for some other area of the city?
No, I understand. It would only be this only applies to the Faena overlay, correct?
Right. Correct. Yes.
Right.
Yeah.
So in other words, any other buildings, this zoning, this piece of legislation or draft would be only really essentially wind up only applying to this particular project. So we're not giving a green light for height increases all along the Collins Waterfront District.
No, I mean, you as the planning board, you evaluate each proposed amendment on its own. So you're not binding yourself to any future height increases. If you choose to transmit this one with a positive recommendation, you haven't bound yourselves to any future height increases here or anywhere else.
Even in the Faena district.
Right.
So I don't understand why there's a concern about this setting a precedent.
So Michael can address, how many other situations within this specific district with a contributing building that are 70,000 square feet, we might be opening up ourselves to.
Yes. So,
and if that question may have already been asked and answered, but just to reiterate and understand better.
Yeah, so at this time, you see on the map that I sent this morning, the RM3 portion is everything of the Faena district east of Collins Avenue. So as Nick had alluded to, there is another site to the south of the GU parcel, which has a contributing Saxony hotel structure, and that has the Faena house abutting that. When that was approved, that was one development site. That was joined together for FAR purposes, and that project was approved as one development site. I think it's been separated now, but you're correct. Based upon this ordinance, if they were to combine the parcels, there's an existing contributing building. They meet the definition to take advantage of the reduced setbacks, which I think it makes sense because it involves a contributing building. You want to move the construction away from the contributing building. I know when the Faena house was built, the view corridor between the Saxony and the new construction was discussed at length by the Historic Preservation Board, and that's why you have that separation there now. So all the same concepts we're talking about here apply to this site, apply to the Faena district, and can even, in general terms, apply to other projects in the city, not with this ordinance, but general concepts where if you have a very iconic contributing building and you want to allow new construction on the site, if you're hampered by the zoning code, which basically just contemplates a vacant site, you don't want to have all the new construction jammed up against and obscuring an historic building. So this ordinance allows pushing that new construction further away to provide some relief from the historic building. And the Versailles Hotel is very unique, and it's one of the only instances I've seen where the owner has agreed to demolish, a 1950s addition, which really obscured, this iconic Art Deco tower. Unfortunately, here we have such a variety of buildings and architecture and style and sites, but I think the overall concepts, could be applied, for most districts. And also, we're not changing the use. There's no change of use whatsoever as part of this ordinance, which is something typically, alluded to in terms of spot zoning. But this is really, we're regulating the volume and the massing, which is something that typically the planning board does. And that's why we're not approving a site-specific project. It's just the volume and massing in relationship to an existing contributing building.
And I mean, just to add to the conversation, we're guided by FAR. So for the Saxony site, when it was unified, they maxed out their FAR. So, I doubt anyone's going back to demolish anything that's new construction or contributing to gain on the height. How this conversation started with Nick, I'd be concerned with increasing height if we didn't have FAR to govern the total number of square footage. So every time I increase height, I'm forcing the volume to be compressed and take up less of a floor plate. Because by increasing height, I'm not allowing additional square footage. I'm not allowing or changing density. So for that reason, I kind of feel comfortable in that regard. Also, as a city, many cities only have one planning agency that governs both these land use matters and design. Here, we really have the HPB, which is hyper-focused on looking at the historic structure and probably has greater guidelines that they consider when looking at new development that a standalone planning agency that didn't have the benefit of that type of board would. And we would probably be able to tie the two together as far as how do we give them this height and make sure that they still give us no parking pedestal in those open view corridors. So although we benefit from having the HPB and that added review, we don't have the ability to combine them both together here.
I also wonder if we can include something as a recommendation to the commission about the mural.
Yeah, we can do that. So I think at this time, Dave.
Oh, you muted, Kareem.
I'm sorry, guys. I apologize. I thought I was pressing the button. I'm trying to learn how to use the space bar. Obviously, I need some more training. But I think let's finish the discussion on the height. I think I'm in agreement with you, David, that we can add that as a recommendation as part of the overall adoption, because at this point, we haven't adopted the ordinance to a vote because we were discussing the height. And then we can add that as a recommendation as part of the either separately or as part of the ordinance vote.
Okay.
I'm pretty, I kind of, a lot of times when you're doing these developments, in municipalities, you normally get, in many cases, a 10% variance on, things like parking or setbacks or certain heights and things like that. Anyway, 20% doesn't seem like a lot to me. I'm not looking at this as for this particular project that may have been presented. I'm really trying to do what Daniel set out at the very beginning, to look at this more of a policy of the city that could someday impact some other development beyond the one that we may have been looking at. I do understand that the building may not, in fact, in reality, be exactly what was presented to us. So I'm not necessarily falling in love with what was presented. I like the elements of what are presented. I love that you're not having this massing at the ground floor to all the points that you guys have made. So I'm in favor of supporting the 250. Given that, I think that the design board will look at it and give some more context to it as we go. I'm happy with the changes that we've made. I think we've actually made some really important and creative amendments to the ordinance draft that was before us. So, aside from what you said, David, of taking the additional step of recommending that the artwork be received by the city as a gift, and that they'll have to work out the particulars of how much.
Mr. Neeson had said that they would be willing to pay for it. It would be at their expense. It would be at the developer's expense to move the mural to a site certain, and I thought that would be that could be understood or put in the ordinance. I don't know. That would be up to the city attorneys.
What I would recommend on that, I mean, that really wouldn't belong in the ordinance. I understood that more as the developer's proffer, and I would imagine that if the developer intended to commit to that the developer would proffer a covenant sometime between now and when this is transmitted to the city, when this is heard by the city commission. But if you'd like to include in your motion to transmit the ordinance, if you'd like to include a recommendation about, I think Mr. Weeder, you had a recommendation about where the mural be moved. I mean, I think that would be appropriate to transmit as part of your recommendation.
Okay. So Nick, do we do it in two parts or do we do it in one?
I would do it in two parts.
Okay.
I would have one vote on the amendments and then a separate recommendation as to acknowledging the developer's proffer and suggesting that the mural be placed at whatever location the board would like to recommend.
So I'm fine with where we are. I mean, Nick, I know you have to get back to some other obligations as well. Do we want to move this item forward?
If you like, Mr. Chair, I can run down the changes that the board made, so we're all clear on the amendments to the ordinance that the board is voting on.
Sure, that would be great.
So starting with, this is condition number H.
Well, let's start. One second. Let's start there. We're going to add back in GI.
Yes, we're adding a GI, which is any building whose height exceeds 203 feet shall have a front setback of 75 feet as measured to the closest face of a balcony. H, 1 and 2 stay as is. H, 3, 4, 5, and 7 will be removed and replaced with the following condition. The subterranean pedestal, tower, and side setback shall be 0 feet for properties abutting a GU zone parcel, which also provide a view corridor between an existing contributing building and the construction of a detached ground level addition, subject to the review and approval of the Historic Preservation Board in accordance with the Certificate of Appropriateness review criteria. We're going to leave in condition 6. We still need to have that, which says there are no required some of the side yard setbacks for pedestal or tower side setbacks. Conditions 8, 9, and 10 remain as is. Conditions 11, 12, and 13 are removed. Number 14 is modified to read, the maximum permitted width of a porte cochere for a contributing building may exceed the requirements of allowable encroachments as outlined in City Code Section 142-1132, not to exceed the width of an original porte cochere. The maximum height of such porte cochere shall be 19 feet. Condition 16 regarding grade remains as is, and condition 17 regarding guardhouses is stricken.
Agreed. That's what I have. Okay. So do we have a motion on it to move it as amended? I'll move it.
I'll move it.
All right, go ahead. Mike has moved it. Any second? I'll second it.
Okay, Mr. Vitia?
Yes.
Mr. Milan?
No.
Mr. Weeder?
Aye.
Mr. Jelpi?
Yes.
Mr. Barano?
Yes.
Mr. Pietro?
No.
And Mr. Brantley?
Yes.
The motion passes 5-2. And that's with a favorable recommendation as modified to the City Commission. And then the board want to make a separate motion regarding the mural.
Yes,
you want to do it?
Yeah, I'll do it. I would move that the proffer of the developer be accepted, that the Versailles original mural, which was on Collins Avenue, be moved to a site certain, with the suggestion that it be on the City of Miami Beach Convention Center, the garage on 17th Street, with a view of it coming up from Convention Center Drive, heading south, and a view, of course, on 17th Street, which passes the garage.
I'll second that.
Right. Can I add an amendment to that? Did you talk about at the expense of the
at the expense of the expense of the developer?
Okay. All right.
As was profit.
Okay, Mr. Vitia?
Daniel?
Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Jelpi?
My fellow board member, David, yes.
Mr. Barano?
Yes.
Mr. Pietro? And Mr. Brantley?
Yes.
The motion passes unanimously.
All right. With that, I think I need a break. Anybody else need a break?
I do. Yeah, I do. Yeah.
So
I might need a nap.
We thought you were sleeping all along.
Yeah, exactly.
What do we need? 30 or 45 minutes? What do you want? What's your pleasure?
I think we should go less because I think the next one's going to be long also.
Yeah, 30 minutes is good with me.
30 minutes we should do. Yeah.
All right, so let's recess for 30 minutes, and we'll be back here at 1 o'clock.
I think I can get to the kitchen within 30 minutes.
All right.
Yeah.
Thank you.
Welcome back to the August 25th Planning Board meeting for the City of Miami Beach. After a brief recess, we're going to continue to pick up the item Planning Board 20-0367, which is 4000 Alton Road. Well, actually, before I do that, is there a particular order, Michael, that we need to take these in?
Yeah, we're going to discuss them all together, but we'll need to take votes in order that we have them on the agenda. But Virgilio is going to provide the background and update and present the reports, and then we can go through the order for recommendation.
Okay, so there are going to be 3 items that apply to 4000 Alton Road. Planning Board item 20-0367, Planning Board item 20-0369, and I missed one. Yeah. Planning Board item
0368.
0384, right?
Yeah, 367, 368, 369.
Correct. 367, 368, 369. Yes, correct. All right, go ahead, Michael.
And Rogelio is going to provide the introduction on these items.
And Mr. Chair, since the map changes are site specific and quasi judicial in nature, I'll be swearing in any members of staff, any members of the applicant's team, and any members of the public who provide testimony on this item. So I guess I'll start with if Rogelio is going to give the presentation. Rogelio, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Okay, so I guess I'll go ahead and get started. So as was stated, these are 3 companion items. The first is file number PB20-0368. It is an amendment to the 2040 Comprehensive Plan Future Land Use Map. And that's from PF Public Facilities to RM2 Medium Density Residential Multifamily. File number PB20-0367 is a zoning change for the same parcel from GU Government Use to RM2 Residential Multifamily Medium Intensity. And then the third item, PB20-0369, is an LDR amendment for the properties that front the west side of Alton Road and the Julia Tuttle Causeway. So I'll be discussing these 3. The first 2 items, the future land use map amendment and the zoning map amendment, affect a small 0.406 acre parcel that currently belongs to the Florida Department of Transportation. FDOT will be declaring the land as surplus, and as we've been informed, the adjacent property owner will get the rights to the land, the rights to first refusal of the land. So the adjacent property owner, who this ordinance is being worked on for, will be acquiring the land and incorporating it into a development site that is adjacent to the Talmudic University. Since the RM2 district that is adjacent to this GU site has an FAR of 2.0 and a maximum density of 100 units per acre, the parcel will allow for that overall development site to increase by 35,360 square feet and 35 units. Since the GU regulations are based on the adjacent parcel, a change from GU to RM2 does not represent any change or increase in the maximum FAR. And so since the parcel would no longer be a government use, the adjacent RM2 category is the appropriate category for the zoning to change. So as such, staff recommends that the planning board transmit the future land use map amendment and the zoning map amendment to the city commission with a favorable recommendation. And we'd need 2 separate votes with the future land use map amendment being considered first. The third item, the LDR amendment, proposes to change the regulations for the properties, as I stated, fronting the west side of Alton Road and the Julia Tuttle Causeway. By way of background, regulations were originally created for this area in 2014. At that time, the city commission raised the height limit from 60 feet to 85 feet. Additionally, the developer at the time acquired some surplus land from FDOT and changed the zoning and future land use map of that area that they obtained to RM2 as well. On March 4th, 2014, the Design Review Board approved an 8-story building with 72 units on that site. However, it was never constructed, and that approval is still active. In 2015, the applicant filed a private application to raise the height limit from 85 to 150 feet, but the planning board did not recommend in favor at that time, and the proposal was withdrawn by the applicant. So now the current ordinance, it has been modified a few times. So the draft that is before you, the most recent draft, does the following. It increases the height limit from 85 to 140 feet, increases allowable height exceptions from 20 to 30 feet, requires that any structure exceeding 85 feet have a minimum setback of 100 feet from Alton Road, establishes rear setbacks of 10 feet, establishes a maximum floor plate size for the tower of the building at 30,000 square feet, but it does give the DRB the option of increasing that to 45,000 feet. It provides that the residential liner requirement of the parking floors only apply to Alton Road and not to the highway to the rear of the property, and to the Julia Tuttle Causeway to the north of the property. It requires that any new development install green infrastructure such as bioswales, permeable pavement, native vegetation to manage stormwater, and also requires that 100% of the irrigation be through the installation of cisterns and other best practices. The benefits of this ordinance, the additional allowances of height and such, are only available to lots that are over 60,000 square feet as of the adoption date of the ordinance. So staff is supportive of the future land use map and zoning map amendment. However, we do have some concerns with the LDR amendment. Regarding height, the current height limit of 85 feet is consistent with the adjacent 72-foot Talmudic University and the potential built context of the CD3 commercial corridor along 41st Street. Along the west side of the city, north of Sunset Harbor, there's a defined scale of smaller buildings with the exception of the Mount Sinai campus. Just for reference, the Mount Sinai campus has a height limit of 100 feet within 500 feet of a residential district and 150 feet interior to the site. Staff did analyze the site and looked at the existing zoning limitations and determined that the allowable FAR can be accommodated within the existing heights and setback regulations and still have a nice landscape buffer. Regarding sustainability, as I stated, the code requires that the new development have green infrastructure for stormwater and 100% of their own irrigation. Additionally, the property owner has voluntarily proffered a covenant to build some stormwater infrastructure. Staff has not had an opportunity to fully vet the proposed covenant. They've made some modifications to it. The primary rationale for increasing the allowable building height would be to redistribute the building's volume so that it provides opportunities for significant resiliency improvements. So we still need to look at that further. Since the proposed height increase is intertwined with the water management benefits that could be achieved by this, and the proffer by the developer has not been fully reviewed, staff is recommending that the planning board discuss the ordinance and continue the LDR amendment until the September 22nd, 2020 meeting so that we can fully vet what's being proffered. However, should the board wish to transmit the proposed ordinance, staff does recommend that the transmittal be subject to the proposer agreeing to provide additional infrastructure improvements for stormwater enhancements. So with that, if you have any questions, if you'd like me to elaborate on any specific parts of the ordinance, I'd be glad to.
No, that's thank you, Rogelio. Do we have, is there a presentation?
Can I ask a quick question?
Sure.
You said that, Rogelio, you said something about it fits within the existing FAR. What do you mean? Is that the existing height at 85 fits?
Right.
Actually, didn't see that statement.
They have an allowable square footage and an allowable FAR. They can accommodate that FAR within the 85-foot height limit. So by limiting the height to 85 feet, we are not making it impossible for them to achieve their maximum FAR.
And that's with including the FDOT parcel too?
Correct.
Okay, thanks for that.
You're welcome.
Do we have any other questions before we go? Thank you, Mark. I didn't want to cut anybody off.
Yeah, sorry about that.
Questions? Okay. Michael, we have or Nick or Rogelio, actually, I'm sorry, you're doing it. Do we have a presentation on this? Is that what I understand?
Yeah. Kareem, just to clarify, Rogelio, are you recommending that we defer this item, or that's staff's recommendation that we defer it?
Our recommendation is that the first two be transmitted with a favorable recommendation, the future land use and zoning map amendment, and we're recommending that you defer the LDR amendment, the third item.
Okay, so your recommendation is approving one with a favorable recommendation and deferring the other two. That's your...
that you approve the first two with a favorable recommendation and the third item be deferred.
Okay.
I believe the property owner is available. I believe they may have a presentation as well as part of the public hearing.
Who's going to be presenting for Michael?
It looks like Michael Larkin has his hand up, so I believe he'll be presenting.
So, Mr. Chairman, Michael Larkin, good afternoon, everybody, here representing Mass Capital, but our client, Camilo Miguel, is going to do the presentation, so I think he may have his hand raised as well, and he's prepared to do the presentation.
Okay, and if you'd like, I'll take this opportunity to swear in any members of the applicant's team who will be presenting. So please state on the record whether you swear under oath that any and all testimony that you give in this proceeding is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Okay, you have 10 minutes for your presentation.
So I think you guys have my presentation up.
We need to get to the beginning of it.
But that's not the.
I agree.
That's not the correct presentation.
Mr. Chairman, if possible, can Camilo share his screen? Because what they just showed were slides at the end of the presentation, not the beginning of the presentation.
Well, let's give a second. We have some folks working on the technical in the background. I don't have that control, so let's allow them to. Maybe they just are realizing that they need to get to the front. If not, they'll instruct us on how we can take control of the screen.
Sure.
Nick, you want to just go? Michael, you already were sworn in earlier while we're waiting?
Yes.
I think the presentation was sent yesterday afternoon at 4 o'clock, and we received confirmation of receipt.
All right, so this was the presentation that was submitted with the application.
That's not the correct presentation, though.
We sent it to Jessica yesterday at 4, the complete presentation.
This is exactly what's in Novus.
Then can Camilo share his screen, because obviously now the full presentation wasn't uploaded.
PJ, do we have that capability to do that?
Just give me one second. Let me see what we can do here, because I know that was submitted. Let me just give me one moment here. As long as staff is fine with it, we could proceed. Is that the will of the chair?
Yeah, I'm fine with that. That way we don't get into a situation where they're version 1 versus version 2 or 3 or 4 or something like that.
Understood.
I'm not sure if we received this. Could you just make sure to forward us that presentation for the public record?
And I don't know if it helps, but on Novus, file ending 0367 has an item called plans. Maybe that's the presentation they're referring to.
I'm not sure. I know the team forwarded at 4, and Jessica on your team had confirmed receipt. But I can, now that I think I can share screen now.
Just give me 1 second here. You said it was on the Novus, right? 1 second.
0367. There's a third item called plans, and I don't know if that's what they're referring to, but that's what I reviewed. That might be relevant.
Zoom can be great and Zoom can be frustrating.
At least it's working today.
There was an outage.
Awesome.
Actually, the team just texted me saying it was submitted, confirmed at 2:58 yesterday by Jessica.
It's a good thing we have such a light agenda today.
We still have a discussion item.
Yeah, exactly. Which will come at 8 o'clock tonight when I'm exhausted.
So, Mr.
I don't have any brain cells left.
Can Camilo share his screen because they're having?
Yes, Camilo, are you there?
Yes, I'm here.
All right. Can you tell me if you have that ability to share the screen right there? You should be able to. Is that?
There it is.
That's your presentation?
Oh, it's too long.
No, that wasn't it.
All right. Go ahead. You should have the ability to bring it up.
So Michael, just make sure that you guys send over to staff the version that he's sharing with us.
We will, Mr. Chair.
Gentlemen, can you guys see the screen?
Yes.
Yes.
Excellent. So good morning, Chairman and Planning Board members. I am Camilo Miguel, the CEO of Mass Capital, representing the 4000 Alton project before you. Mass Capital is a 14-year-old South Florida-based company that develops and invests in real estate, including condos, multifamily, and hotels. We have over 1,000 units under development. Among some of our signature properties you may be familiar with are Louver House, which we developed south of 5th Street, and the Conrad Hotel, which we continue to own and operate. Since 2015, we have owned the property located at 4000 Alton Road, which is before you today. I will be sharing a 31-slide presentation, which will be taking you through various aspects of the project and joining me to answer any technical questions you may have about the project on this application, or the team, including Michael Larkin from Burkow Raydell, Raymond Forbrescia from Architectonica, Adrian Debkowski from Kimley Horn, Cesar Garcia Ponce, who's involved in the urban planning, Hernando Navas from Schwebke Shishkin, and Andrew Dolkart, who is an economist. As I told you, I've owned the land for 5 years, and I've been working with my team to develop a project that will be an asset to the community as a high-end residential condominium development, which will enhance the current gateway to Miami Beach. As we will further discuss, this project faces many challenges, some due to its unique location and others more recently due to the current economic recession and global health pandemic we all face. Notwithstanding these challenges, our commitment to Miami Beach and this project is unwavering. We believe in the city of Miami Beach and its future. It is in that spirit I want to share my vision in our project, Alton Bay. Just to go over the outline slightly, I'll be reviewing project location for those of you that don't know exactly where it is, zoning and the evolution of the design and all the steps we've taken to come to where we are today, the significant public benefits, and the renderings to help showcase the aesthetic of the design and what the ultimate intent and spirit of the design is going to be, as well as the substantial community support and outreach that we have done throughout this whole project. So to start with the current location, currently the site has an architecturally indistinctive former hotel, now the home to the Tom Munich University, and the adjoining parcel is mostly a surface and dirt parking lot, not an ideal condition for the gateway to the city of Miami Beach. The proposed property project location includes a piece of property that we currently own fee simple and a small landlocked parcel that we're acquiring from Florida Department of Transportation, which allows us to develop this prime corner gateway location. One of the opportunities and challenges of this site is that it's surrounded on all three sides by active and important arterial roadways, which requires us to put a lot of thought into how we develop the site. I'd like to talk next a little about the evolution of the design concepts, as well as discuss with the board the current zoning versus the proposed zoning under consideration for you today. Right off the bat, I certainly would like to acknowledge that this design has evolved greatly over time. Originally consistent with what we thought was the general planning direction of the city, we proposed a taller, thinner tower with a 1-acre park. I will be the first one to acknowledge that that proposal met with significant opposition from the adjoining neighbors. We have received that feedback loud and clear, and therefore we have worked with our architect to significantly reduce the height of the proposed project while maintaining and expanding its proffered public benefits. Here you see how our design has gone from 25 stories down to less than half, 12 stories, and from an overall height of 290 feet to just 140 feet. I want to make clear that we are requesting today is your recommendation for a 12-story structure at 140 feet with the accompanying public benefits. In response to community feedback, we have abandoned our original 25-story proposal. I think it is also important for this board to consider how this site is separated from the adjoining neighborhood. It is almost 3 football fields away in distance from the nearest residences on North Bay Road. It is more than 2 football fields in distance away from Mount Sinai campus. It is almost 2 football fields away from St. Patrick's Catholic Church. It is more than 1 football field away from the nearest adjoining residences on the northern section of Alton Road, and it is 240 feet from the nearest home in the Garden District neighborhood. This separation is a product of both natural conditions and our conscious effort to evolve the design to minimize the impact to our neighbors. I want to talk to this board a little about the current RM2 zoning as applied to the site. The RM2 zoning would allow for a building to cover 54% of the project site. The proposed zoning before you today would reduce that lot coverage to only 39%. We achieve this in part by doubling the required building setback from the Garden District and Alton Road from 50 feet to 100 feet. In doing so, we increase the open green space significantly, so more than half of the site will be open green space. We also reducing the allowable unit count from 204 units to only 128 units. I want to make clear that these are 128 proposed high-end luxury condominium units. We are not interested in exploiting either the maximum allowable density on this site or in developing any of the other more intense uses like a hotel and accessory uses that are currently allowed by the RM2 zoning. We are known for, and we want to develop on this site, a quality, architecturally distinctive product. We know there are some people that prefer to see no development on this site, and we will never be able to satisfy those individuals. There is a project already currently approved for this site. What we are asking this board to consider is a proposed project which we believe is an improvement over the currently approved project from an urbanistic standpoint, accompanied by a generous package of public benefits. We are asking this board to favorably consider our proposal to reduce the building lot coverage from 54% on the approved project to 39% on the proposed project. We are asking you to allow us to double the building setback from the adjoining residential neighborhood. In exchange, we are asking for a modest increase from 8-story structure to 12-story structure. I want to also emphasize to this board that we have tried to respond to community feedback, and as a result, we have slashed the height of our building by more than half while still maintaining the majority of the site open green space. And we have also reduced our proposed unit count from 160 units to 128 while maintaining a building setback of over 100 feet. These changes in design have been in response to community feedback, and although there are some that would rather see no development at this site, we are honored to have gained significant, but not unanimous, community support for our revised project design. Because we are asking this board to recommend this new design and zoning to the commission for consideration, we feel you should also know of the significant public benefits that we have proffered to the city and its taxpayers in exchange for the new proposed code amendment. Here's a summary of the package of public benefits that I'm going to review in detail. Enhanced site resiliency, neighborhood flood mitigation, enhanced stormwater management and infrastructure, enhanced traffic capacity and traffic flow, enhanced open green space, mid-beach gateway entry signage, direct fiscal benefits, and direct public benefits, and what those costs are. In addition, we have proffered a number of enhancements to not only deal with the water from enhanced site resiliency for the site to maintain the water management of our property. We are decreasing building footprint from 54 to 39%, increase site permeability by increasing green space from 25% to 51%. We're maintaining 51% open green space with resilient and sustainable landscaping. 9 gravity wells for required on-site stormwater management, which will allow 100% site stormwater containment. In addition to dealing with our own site resiliency and enhancing flood mitigation for the adjoining residential neighborhood, we are also committing to enhancing new and expanded stormwater management infrastructure. We are going to be installing 5 water quality drainage wells and piping for neighborhood stormwater runoff, as well as making a commitment to install a pump station to pressurize the wells and activate stormwater management for the 14.76 acre drainage basin. We will be providing piping from the west side to the east side of Alton Road to allow the city to provide connectivity into their storm water and sewer systems. We're also offering to provide connectivity into the new enhanced stormwater management infrastructure that we will be constructing on FDOT property.
Mr. Miguel, your 10 minutes are up.
Can I get a few more minutes? Just like another 5 minutes? I kind of had considered a 20-minute presentation. Is that possible, Mr. Chairman?
Camila, we'll give you some more time. Go ahead.
I'll set it at 5 and then check in again.
Sounds good. So we will be installing a 54-inch drainage pipe on the FDOT property along with 30-inch drainage pipe. So all of our wells, the pump station, some will be connected to the FDOT pipes, and we have proffered as well to connect to the neighboring, providing piping to allow the city to connect to the neighboring water and sewer system. Another public benefit that we are proposing is to enhance traffic capacity by providing the additional right turn lane to allow traffic to flow onto northbound Alton Road. This will help capacity at this critical intersection and improve traffic flow. Finally, as I said before, the current site condition, depending on whether you include the FDOT parcel, is over 50% asphalt and surface dirt. And we're proposing to convert that into a site that is over 50% open green space, 100% which will be covered with resilient landscape design. We have also offered to commit significant dollars to improve mid-beach gateway wayfinding and entrance signage. We will do as much or as little as the community wants us to do by way of business district signage or new Miami Beach mid-beach gateway signage. In these difficult times that all municipalities are facing during this recession and global pandemic, we would be remiss not to mention the direct fiscal benefit from the proposed project. It is important to note that Alton Bay will generate approximately $2.3 million in recurring annual direct fiscal benefits to the city of Miami Beach, the county, Dade County Public Schools, and Children's Trust. This is public dollars made possible through the investment of private capital. Finally, as I said, it is impossible to put a price on the value of the package public benefits that we have proposed. That we can quantify is the cost to build it. I want this board to know we are committed to spending over $5.3 million of our money to deliver this package of public benefits to the community. The result is that we are saving the taxpayers of Miami Beach over $5.3 million of precious tax dollars that otherwise would have to be spent to deliver the same benefit. Now I'd like to share with you our latest renderings for Alton Bay. First, the view of the project as we're approaching through the Julia Tuttle. This allows you to understand how it bookends with Mount Sinai and as well as Tower 41 at the other end of 41st Street, which is at 170 feet. Mount Sinai's 150 feet and us requesting 140. I honestly believe this will be much more attractive, architecturally distinctive, and pedestrian-friendly project. Finally, you will hear from a lot of members of our community today during the public hearing, some who support the project, some who do not. I think it is important to note that we have done extensive public outreach and education. As I said, I heard loud and clear from the community that the original proposed project was not fully supported, but I am happy to share with you and this board that our revised project has been endorsed by the Mid-Beach Neighborhood Association, by the Mayor's 41st Street Blue Ribbon Committee, by the Talmudic University. We have had extensive support from the businesses along 41st Street and that business community. And we have substantial support, more than 80 letters of support from residents in the immediate surrounding Mid-Beach neighborhood who have voiced their support for this project. We have provided you, I would ask this board to take a moment and review the binder that we have provided to you with all of the letters of support, all of the resolutions, and all of the, and the list of supporters continues to grow. Keep that in mind as you hear from the public during the public hearing. Thank you for your time. We look forward to hearing back.
I have a question before you go.
Sure.
Is this on the site where the old Holiday Inn, Howard Johnson's was? Is that the other building is going to be demolished?
It won't be demolished. And the answer is yes, David. That's where the Howard Johnson's was. Talmudic University purchased it, and it's going to remain there. So, but that's the answer to your question. Yes, where the Howard Johnson's was located at one time. Correct.
So that building still remains.
That's correct.
Okay, so the renderings didn't show the two buildings; it just showed the one. I thought.
I can go back to see the building on the right here.
Could you pull that rendering up again, coming off the Tuttle?
Yeah.
This one?
You got to share your screen again, Camila.
Oh.
And can I just request real quick? We did not receive this. The presentation that we received was the transportation one. I believe there's a link in the email, but we're not able to open that link. Michael, if you could please submit either as a PDF or as a PowerPoint file the presentation for the public record.
Yes.
Okay, so sure. the building is on the right, opposite from Mount Sinai, correct?
That's correct.
And where is on this rendering, could you point out to me where the Howard Johnson's was?
It's to the left. It's hard to see. The idea is as you arrive, what will draw your eye would be your
building. Oh, so the Howard Johnson's building is behind it? And
yes.
It's right. It's perpendicular to the new building?
Yes.
Okay, so it's just closer to the roadway.
Here is a different perspective. I don't know if you could see on the right-hand side, the building sticking out by the trees.
Yeah, I see it. Let me just pull my screen away. Yeah, I see it. It's obscured by trees in this rendering.
Yes.
Okay. Could you go back to the other rendering, please?
Sure.
I just want to take a closer look. the visuals. Could you zoom in a little bit?
Yes.
I see. You don't. It's just to the left. There's trees there, and you really can't see it on this rendering. But it's and the other building to the left, immediately adjacent to the roadway, are the buildings across the street on Alton Road.
I don't know which buildings you're referring to. They're either on 41st Street or Alton Road.
There's your new building.
Yes.
And there's behind to the immediate left is the little building.
The Talmudic University, yes.
Yeah. And then there's a little bit of, there's a few trees, and then to the immediate left of the trees, what are those two buildings?
Are they kind of shaded looking, David? If so, those are buildings.
One of them has a peaked roof, and the other one has a sort of like they're lined with trees, and they're right where the vehicles go under the trees off the Tuttle. There's a building directly right behind the tree.
That would be 41st Street.
So those are the buildings in the CD3 zoning district that forms along 41st Street.
I see. Do you have a rendering of this site coming from the other direction?
From which direction are you asking?
Coming from east to west. Approaching the entrance to the causeway.
I have Ray Forbrescia on as well, I believe, and he may have that rendering, but I'm not sure if we have it available at the moment.
So, Mr. Chairman, if you'd like, if you want to promote Ray, then he has additional drawings, and he could perhaps respond to David Weeder's request.
Yeah, I just want the board to get a full, because really the issue in here is going to be the objections to it as it being non-contextual, and with the idea that the Tower 41 or whatever it is on Pine Tree Drive, just before you cross the bridge to the other side, which Tower 41 is an eyesore anyway, but it's like, so if you're arguing that makes it contextual, it sort of doesn't resonate with me. But I would like to see how it looks from all angles, and I'm sure all the other board members would as well.
Okay, so Mr. Chairman, I think Ray Ford probably has his hand raised. Would you be able to remote him over to a panelist?
Yeah, well, I don't know about the technical aspects. I have to defer to PJ on that, but we can bring Ray in to just give some response to what David is getting at.
Thank you, Mr. Chairman.
And excuse me, Mr. Chairman, while we're doing that, I just want to remind the board and the public that the meeting has to end at 3 o'clock. So I don't want to spend a lot of time on the presentation and not give time for the public to respond. So
all right, so I'll withdraw that request, and if the board doesn't want to see it, it's okay with me. Also, I have a pretty good idea of what it looks like. I just wanted to clarify the other side. So,
and Mr. Chair, to Michael's point,
this is Ray Fort speaking. What may be helpful.
Ray, can you hold on for just 1 second? To Michael Belush's point about the meeting, what needs to conclude by 3 is this item, because this item has a quasi-judicial element. The 3 other items in the discussion, we can have those because those don't require, since they're legislative in a discussion, those don't require access to the remote room in the convention center. But this one, we would need to conclude this before we lose access to that convention center room, which is a little after 3 o'clock.
We have another hour then. So I don't want to be an obstructionist, but I think it's really important for the board to understand how this is going to look, and whether they're comfortable with how it will look, and whether it's a contribution to the neighborhood, or whether all the voices that I've heard objecting to it are have some sway or not, and I'm sure there's a lot of people who want to talk. So I think maybe we could sort of defer this part of the presentation depending on what everybody else has to say. So I'm willing to, move along.
Well, David, I think what you're saying, we do need to see it. Ray, can you quickly bring it up? And I mean, we can't just spend a lot of time on this. Can you guys quickly bring it up for us?
Yeah, Ray can do that.
And while they're doing that, Tom, just to clarify, do we need to just have public comment open by 3? I just find it really hard to have this wrapped up by 3 o'clock. Is it public
this
comment
is an important
by 3?
Yeah, he's right.
Yeah,
this is an important project. I mean, this is something.
Well, the question I would have, I guess, to Nick would be the one item out of the 3 that's quasi judicial, Nick, is the rezoning, and could they take action on that by 3, and then still have more discussion and action on the 2 other, which are legislative?
No.
Yeah.
So.
Yeah, I mean, I think the map changes are the quasi judicial items. So I think if the board needed more time to discuss the text amendments to the code, that you could go beyond 3 o'clock on that
for those items. But you'll need to do the map changes by 3.
I don't want to feel pressured to do something by 3 o'clock. I mean,
you're not. And by the way, I'm glad you said that because
I'm not comfortable with that.
I'm glad you both said that because you're not pressured. It's what I would, I think my approach would be if you want to, continue, hear the item, have the public hearing, take as much time as you need. You're not pressured. If you can't finish the quasi judicial items by 3, then you'll have to continue those to a subsequent meeting.
But I can't separate 1 from the 3. I know we're going to vote on them separately, but it's all one conversation. I do want to just clarify, can we just have public comment? That's the purpose of the convention center room, is for public comment. Once we close public comment, no one's going to be able to use that room. Am I correct in understanding that?
Yeah, I would suggest we let's let the hearing play out, and if there's if we can't conclude the item by 3, then we'll have another discussion then.
All right, thank you.
All right, perfect. So let's run with the angles that David is speaking of, because I think they will prove important prior to the public comment, just for perspective. Do we have it? Are we queued up to go?
Yes, I'm going to share my screen right now. Can everyone see my screen?
I do now.
Not yet.
I see it.
Ray, I need to swear you in. So
I see an aerial.
Can you state on the record whether you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, nothing but the truth?
Yes.
Okay.
I can see it, Ray. I don't know if everybody else can, but I can see it.
That's an aerial.
Yeah, that's an aerial. I just wanted to say one thing about the aerial and the way that we've put together this design, in that this is the existing Talmudic building here, what you referred to as the Howard Johnsons previously. And we use that as a metric for creating a plan that used that as a dimension for informing the proposed building. So as you can see, the building actually steps in plan, almost taking that same dimension of the Talmudic and using it as a way to inform the scale of the project. So already we're trying to relate the scale of what's there in plan view to what we're proposing. And that would be in contrast to what a lower building would be, which would require a much larger floor plate. So starting with that, I just wanted to make sure you understood how the floor plan worked from a siting perspective. And then the view from 41st, you can see here, the Talmudic is in the foreground.
Right.
Make sure I can outline this properly. And then you can see the proposed building in the background.
That's great. That's very useful.
Great. And I'm glad to answer any other questions you may have.
Thanks.
All right. So with that, let's go to the public, being cognizant of the time. We have some hands raised and want to make sure we get as much feedback and and have a really good discussion around this. So let's go. Leon Smith would be the first.
Mr. Chair, I apologize. Just before we open to the public, since these are quasi-judicial items, I'd like to ask the board if they have any ex parte communications that they need to disclose. And just as a reminder, that means any communications that any board member had regarding this application, with anyone outside of this publicly noticed meeting.
I got a bunch of.
Michael, why don't you just call the roll? Or Nick. All right, David, go ahead, David. We'll start with you.
I had a bunch of emails, most of which were violently negative, and I also had a telephone conversation with Mr. Larkin, and we discussed the prospects for the project, and he informed me as to the nature of the project, and that was basically all I had. I read most of the emails, and as I said, they weren't favorable, but I'm not sure whether the emails were written before. Some of them were written after the height reduction, and some of them were written before. So I'd sure be willing to. I'm eager to listen to the public comment.
Okay, if you'd like, Mr. Chair, I can call the roll on the disclosure. So we've heard from Mr. Weeder. Mr. Barano, do you have any disclosures?
Yeah, so similar to David, obviously I received a lot of emails. I think we all did. I communication with Mr. Larkin and Mr. Miguel's team. I won't be able to remember the names of everyone. I apologize for that. And I have spoken with any number of residents within the general vicinity, and I won't be able to remember all their names either. So I don't know if that's important or not.
Well, in the future, I just ask the board keep track of really all you need to disclose are the names of the communications. You are subject to cross-examination.
That's fine. I'm happy to chat about it. I had open conversations with anybody and everybody that expressed an interest as a stakeholder. So
okay. Mr. Milan, do you have any communications?
Yeah, I spoke to Mr. Larkin and his team. I spoke to Mr. Burkow, who's part of Mr. Larkin's team, and received a tremendous amount of texts and emails and calls from the community. And sorry, Nick, I don't have a log of all the calls and texts, but it was a large amount from community members.
Okay, Ms. DiPietro?
I did not have any communications about this.
Okay, thank you. Mr. Vaitia?
I received a call from Mr. Miguel. I did not have a conversation with him other than no thank you. I did have a conversation with Mr. Larkin. He answered some questions for me, had a fun review. I did not have any communications with members of the public, although I did receive the massive amount of emails that everyone else received. I did not reply or have any one-on-one communication, and I can remain impartial on this item after all that communication. Thank you.
Okay, and Mr. Brantley?
I did speak with the attorney representing the developer as well as the development team, and previewed a proposal or a presentation that was not exactly the one that we saw here today. I can remain impartial. I did receive the emails as well as direct communication from the public on the item, but I can remain impartial regardless.
Okay, thank you. So I think at this time we can open to the public.
All right, let's go with Mr. Leon Smith. Is that the first one, Leon Smith?
I think that's the first name. And Mr. Smith, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 2 minutes.
Yes, my name is Leon Smith. I'm a resident of Miami Beach, and I live in the neighborhood. I support thoughtful development of the area. However, I oppose the development as is currently presented. The possibility for hotels and other high density buildings is still possible. And so those type of structures will increase the traffic in the area. My main comment is with regard to the traffic and the traffic density. Traffic is an extremely critical item for the city, not only for the residents and also the visitors. The traffic study that was presented as a part of their proposal is based upon information from 2013 and is not based upon current data. My profession is as an actuary. I have made many projections over the years as a part of my profession. This particular study does not contain and include sufficient information with regard to support the assumptions and methodology used in the study. But you do not have to have a traffic study to understand what's going on with regard to the traffic around this particular location. There are only 3 ways to enter and leave this development. One is through the intersection of Julia Tuttle and the 41st Street, which is already a congested intersection. The other is to go south on Alton. There is a additional turn lane added as a part of their proposal. This will only alleviate a small part of the traffic going south on Alton. The third method for leaving this, if there's congestion in either one of those other 2 areas, is to go through the neighborhood on 39th Street, which is right next to St. Patrick's. In conclusion, I believe that the traffic situation should have a thorough and complete study to ensure that the development will not increase traffic in this critical area of the city and create a dangerous situation not only for residents but also visitors and the children at St. Patrick's. Thank you.
Thank you, Mr. Smith. Let's go ahead. Michelle Kay.
Okay, and can you state whether you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 2 minutes.
Hi, my name is Michelle Kahn. Hi, my name is Michelle Kahn. I'm a 40-year resident of Miami Beach, and I would like to start by saying that I am not opposed to development. I actually fully support the original project that was already approved by this very committee. For 72 units and 85 stories, as you can see advertised on the outside of the building and on the developer's website until they took it down just a few days ago conveniently. This was supposed to be a beautiful 85-foot building that would have been wonderful in our community. I think the big question here is is there any additional benefit to be gained for the additional height increase? We are going to have an 85-foot building at least, but does the residents get any additional benefit by putting in or allowing the developer to put in a 140-foot building? And the overall answer is a resounding no. Regardless of public statements made that, for example, the developer just said that he will not be putting in a hotel. At 140 feet, the developer would still be allowed to build a hotel. He would be allowed to put in short-term Airbnb rentals, inexpensive units, rental apartments, etc. if this zoning is approved. There is nothing that stops him. Additionally, the developer made a big deal about his small footprint of the current building that will allow for more green space and will also allow for better water mitigation. Under the ordinance, the building would have a maximum floor plate of 30,000 square feet, but would be allowed to go up to 45,000 square feet. That is a 50% increase over what the developer is currently showing you, already showing that this ordinance is building in for him to allow him to have a bigger footprint, which would essentially diminish any benefits of water or green space. The committee turned down a request for 150 feet in a unanimous 6-0 vote just a few years ago. So the developer's allegation of decreasing the size of a project from 290 feet to 140 is grossly misstated and disingenuous. This project is really gone. May I have a few more seconds, please?
Yes, Michelle, go ahead.
This project has gone from 150 feet essentially being turned down to 140 feet. The developer also just said that they are using, that they're not utilizing maximum density, but they already are at the maximum FAR per their plans. Lastly, just as a complete pivot, I really would question this creating this district as an idea. To me, it seems like spot zoning. Historically, it's always been one parcel of land. He's now divided it into two parcels, but one of them is expressly excluded under the 60,000 square foot requirement for anything in the ordinance. So therefore, the only property that's going to be affected by this ordinance is his property, which is one property. To sum up, although the developer says and presents otherwise, there are really no additional benefits to the local residents or to the city at 140 feet. We may end up with a hotel or other such similar project, which would greatly reduce local residents' quality of life. Thank you for your time and consideration, and I strongly encourage you to vote against the additional height increase and to support the original 85-foot building that the developer already has approved. Thank you.
Okay, and while we queue up our next speaker, I'd like to ask you to swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth.
Am I the next speaker? I'm sorry, Gina Russ, yes?
Yes, you are.
Oh, I'm sorry, no one mentioned that. Yes, I do, thank you. My name is Gina Russ. I live on Sunset One. I'm speaking to oppose this height increase for myself, my family, and the Sunset 1 and 2 Homeowners Association, who have come out against any height increase, as has Sunset 3 and 4 Homeowners Association. Just to reiterate, in 2014, this property received a 42% height increase from 60 feet to 85 feet. As Michelle mentioned, in 2015, 4 months after buying the property, the developer was back asking for 150 feet, which was denied and unanimously rejected by this board. Now they're asking for 140 feet, which is a 65% increase from 85 feet and 135% increase when we started in 2014. This is not, quote, a modest ask. And this is not just 140 feet. This is almost, no matter what the drawings or the schematics show that the developers presented, if you want to understand the height, it's almost 2 times Talmudic University's height. Per the staff report, quote, allowable FAR can easily be accommodated at the current height of 85 feet and, quote, a generous amount of perimeter open space can be provided. And as Michelle mentioned, there's currently a beautiful building being marketed at this site at 85 feet. Also, per the staff report, allowing a higher height could, and let me emphasize, set a precedent for future efforts to increase maximum building heights particularly along 41st Street. This has to stop. This is our neighborhood. 140-foot, 12-story tower will be out of scale with our neighborhood and will substantially change our neighborhood forever. It will lead to other high-rise development on 41st Street, as we've seen in other neighborhoods all over Miami Beach. There are single-family homes across the street from this development. This is a neighborhood of residents and low and mid-rise buildings. It is not a neighborhood to start building 140 feet buildings on. And what's to prevent Talmudic University from coming back next door and asking for 140 feet also? Also, as you mentioned and know, anything developer tells you, as Michelle mentioned, number of units, size, hotel, can be changed. This is only the zoning. Within that zoning, they can do whatever they want as they are allowed to legally. So we all moved here because we love Miami Beach. We love to go to South Beach. We love Collins Avenue, but we want to come home to our neighborhood. We didn't buy in South Beach, south of 5th or Collins Avenue. This is an area with schools and churches and synagogues. We are for development. We would love 41st Street to be beautiful, but you need the right development for the right area. And building high rises along 41st Street is not the right development for this area. This is a unique neighborhood on Miami Beach. Please help us keep it this way. The residents strongly oppose this height increase. So far, Sunset 1 and 2 HOA, Sunset 3 and 4 HOA, Alton Road HOA.
Ms. Russ, your time is up.
Can I have just a little bit more time?
Go ahead, Ms. Russ.
One more minute. I'm sorry? One more minute. Just St. Patrick's and residents all over have opposed. So I'm just asking you to please oppose this height increase and keep our neighborhood and build on its unique character. And I thank you all for serving on the planning board.
Thank you, Ms. Russ. Okay, we're going to, hang on, I'm switching my screen. We're going to go to the next caller, and Nick will swear them in.
Okay, I believe Mr. Villamar, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 2 minutes.
Thank you, and thank you, Mr. Chairman. I think important to note here, I live in the Garden District, right across from where this building would go up. This is a neighborhood where we raise our children, where our children ride their bikes to their friends' houses, where they play outside. It's not a neighborhood to have a high-rise in. It's a unique neighborhood, as others have stated, and we want to keep it that way. The increase would be unbelievable in traffic and cars deciding to go through our neighborhood where our children are playing, infringing on St. Patrick's. This is a neighborhood where the neighbors go out and meet each other, where we practice our religion, whatever that religion may be. And this is just inconsistent with our neighborhood. I oppose all 3 of the variances and zoning changes. Thank you very much.
Thank you. Let's go to the next caller. Nick.
Okay, Ms. Rightis, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth? Suzanne, I think you're on mute.
Now, can you hear?
Oh, yes, do you so swear?
Okay. I happen to be on air with you since 9 a.m. and was happy to hear Mayor Gelber discuss spot zoning for a building on Collins Avenue. He said it was not spot zoning because it did not affect traffic density regarding the building itself, noise, and nor did it affect it any other way. So let's take that definition of spot zoning to 4000 Alton, where it will definitely increase density, increase traffic congestion and noise, and destroy, and the consequences being erosion of a single family neighborhood, which is a pedestrian neighborhood. People walk, people bike, people push their strollers, people shop. I happen to have a photograph, aerial photograph of this very area from 1936. It shows the southeast corner building, that circular building that houses all the activities, support, resources of this neighborhood. That would be lost because there would be other high rises to come along. Now, this building, no matter how they try to get around it, how they try to work around it by creating a new district, this is spot zoning. That's all I have to say.
Thank you, Ms. Rudis. And I think the clarification, it wasn't Mayor Gelber, it was somebody else presenting there. But let's take the next member from the public.
Mr. Fernandez, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You have 2 minutes.
Thank you, Mr. Chair and members of the Planning Board. Like so many others have mentioned, I do not oppose development. I think development is important. I think proper development is a key of everything. And I have to say, I'm very proud of my partner, Robert, who when in 2014 or 15, that this planning board approved the increase to 85 feet. He sat on that planning board and he voted for that increase to 85 feet. But I have to be very clear. When my partner and I moved into the house where we live in now, that this building we would be seeing from our pool, from our backyard, from the waterway in our backyard, the height that was allowed at the time was 60 feet. In other words, when Mr. Camilo says that he slashed the height of his building by half, he's increased the height by 130% of what was originally allowed at that site when I moved into my house, and that I knew what was going to be behind my house at the time that I bought. It's an increase of 65% of that 85 feet that my partner helped approve when he sat on the planning board. This is the entrance to Miami Beach. It's not owned by one neighborhood. It's not owned by one developer. It's owned by all of us. And quite frankly, as a resident and as a taxpayer, I have to say that I am disappointed that a discussion of this nature is given such little time for consideration before the planning board. I would urge you that none of these three items should be voted on today. I know about the changes to this because I proactively reached out to Christina from the development team. Last week, I met with Mr. Camilo, but my neighbors are not privy to this. And a matter of fact, one of the property owners that resides right across the street, or that's building a home, not resides, but is building a home right across the street from where this development will happen, is not aware of the details about this. And so I asked that more time be given. I support continuing this discussion in September 22nd. If I just could be granted a few more seconds, Mr. Chairman, if you indulge me. Thank you so much. Because again, I have to urge you that this is the historic and iconic entrance to Miami Beach. Though it's a building, it will define, in my opinion, that entrance. I need to have some sort of assurance that if this is approved, that in the future, the developer will not come back and ask for future increases once this is approved. And I need to know that this is tied to some sort of design, because a height increase is important, but also the design of it is important too. So I need to know how the impacts to my quality of life are going to be mitigated, and to those of my neighbors are going to be mitigated and protected. So thank you very, very much. I urge you, these three items should not be voted on today.
Thank you, Mr. Fernandez. Mr. Parker?
Okay, Mr. Parker, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 2 minutes.
First of all, I want to thank everybody for their time and attention today. I've worked with numerous developers throughout the state of Florida, and I've seen opposition to high-rise development in various communities. I've worked with Mass Capital and Camilo Miguel both personally and professionally for many years, and I know and believe that the structure that Camilo and Mass Capital will ultimately create will be accretive not only to the entry, the gateway to the 41st Street corridor on Miami Beach, but also to the real estate values, to the retail components. And I ultimately believe, and is why I'm in favor of the project, that bringing a new structure with the sophistication and quality that I know Mass Capital stands behind and will represent will ultimately add to the values that should be ascribed to a neighborhood as specifically beautiful, luxurious, and identified with the quality that Miami Beach is known for today, and that we've seen along other corridors of the Miami Beach market. I know, once again, that Camilo's team will work with the highest quality of architects, designers, and interior designers to ensure that the benefits are not only visually and aesthetic, but also that we will benefit from a city perspective by the green space, by the environment that it's going to create around it in terms of its structure, by the light that I'm sure he'll work to bring to us. And I work in support of this project and hope that we will have an opportunity to see it come to fruition. Thank you.
Thank you, Jay. We're going to go to Michael Cole.
Okay, Mr. Cole, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth? Mr. Cole, you're on mute.
Unmute. Yes, I do.
Thank you. You have 2 minutes.
I'm just here to speak against the proposal because I think that it's going to be way out of proportion for the city. And it was, I don't understand why we're even discussing it when it was already approved for 85 feet when we're coming back to ask for more footage. It just doesn't make any sense. And I just urge that the board votes no for the whole thing. Thank you.
Thank you, Mr. Cole. We're going to go to Roger Thompson.
Okay, Mr. Thompson, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do. I do.
Okay, you have 2 minutes.
My name is Roger Thompson. I'm a 21-year resident. I live in the 4200 block of Alton. So I live about 2.5 blocks from this proposed site, and I'm speaking in favor of it. One of the first things I see when I open my gate and I look outside is I see the Mount Sinai buildings. And so to me, the size of the building, the height of the building that's being proposed is approximately the same height that I look at every day across the street. And I live in pretty good harmony with what that site is. And I walk by this site all the time, and the height does not bother me. In fact, I think that if it's done properly, which I suspect it will be, knowing Mr. Miguel's reputation, is that it could be a showstopper. And it could be the great, great entrance to Miami Beach, and it could be the shot in the arm that 41st Street needs to have. Somebody was speaking before is the trade-off for the extra 4 feet. I mean, there's going to be an additional half acre of garden space is going to be there. There will be resiliency. They've got the gravity wells. They've got the other pumping stations. Once it all gets connected to the city, it'll be a major benefit to the city. And the illuminated sign that they're talking about doing will also be a really great statement for the entrance to Miami Beach. And like I say, I think it'll be to build a luxury mid-rise building there will be a shot in the arm to our neighborhood, and it's not going to infringe one bit on my day-to-day life, and it's not going to be a negative to the neighborhood. In fact, I think it'll be a positive. I also don't know that the traffic issue is a real issue that we're talking about, because if you build the 8-story building, you're going to have the same traffic. So he builds the 8-story building versus this one, it's the same traffic issue. So I'm not sure that I think that's a sort of specious argument at this point. So anyway, so I'm very excited about the proposal. I think it could be a real shot in the arm to the neighborhood.
2 minutes are up.
I'm strongly in favor of it. Thank you.
Thank you, Mr. Thompson. Mr. Canellis.
Hey, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 2 minutes.
Thank you, Mr. Chairman and members of the Planning Board. My name is Stephen Channels. I live in the Nautilus neighborhood, just a few blocks north of 41st Street. And I lived there since purchasing our home in 1998. As you know, as you've heard, there's no shortage of opinion or public opposition to these zoning change applications, which seek significant departures from existing zoning, notwithstanding the developers' attempts at minimizing the significance of those changes. To be clear, I believe in economic development, in particular along the 41st Street corridor, and I believe developers should be entitled to enjoy the highest and best use of the properties, but with an existing law just like the rest of us must. South Florida is renowned and notorious for its gross lack of comprehensive and disciplined land use planning. Recommending and granting these zoning changes, certainly at this stage, will simply be another example of knee-jerk land use management. Indeed, it would be a stark example of zoning to a design that Mr. Vatia described in this morning's discussion. We have zoning laws for a reason. They provide stability, predictability, consistency, protection of local aesthetic interests, and balance commercial and residential interests. But any innovation, economic innovation or development should result from a comprehensive discussion about what makes sense for the area, including the surrounding neighborhoods as a whole, and not just one parcel, which would result in patchwork development, which can't be undone. It seems premature for these changes to even be considered, considering that the owner has not purchased the FDOT parcel yet, and that as staff indicated, FDOT hasn't even declared the parcel as surplus. The property will dominate the entrance to Miami Beach eastbound along the Julia Tuttle, and the city will relinquish control of that gateway if it yields to the owner's desire to build to a height above what is currently allowed. I would also challenge city staff to articulate in specific terms what has changed since 2015's rejection of the height interest request. The only thing that may have changed is the owner. The property hasn't moved, the surrounding neighborhood hasn't changed in any material way, and traffic has only gotten worse and will only get worse as we increase density. And this is
2 minutes are up.
A historic preservation. I just have 2 comments left, if I may.
Go ahead.
Thank you. Thoughtful and prudent planning dictates that you take a pause on these applications, find the courage to hold the line for the community, and force a more comprehensive long-term evaluation of what zoning changes, if any, make sense, rather than take an irreversible piecemeal approach to development. Please reject these applications. The future erosion of our skyline should be subject to the will of the voters, and you should recommend either to table this or issue to the commission a request for further proceedings so that there could be a comprehensive discussion of what's appropriate for the entire area, not just one parcel. Thank you for the opportunity to speak.
All right, we're going to go to Bill S.
And Bill, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay,
And
thank you. You have 2 minutes.
I'm going to request 3 in advance so that we don't have to go through that dance at the end. Can you hear me?
Go ahead, Bill.
Can you hear?
Yes, we hear you. Go ahead.
Okay, thank you. I've been a Mid-Beach resident and property owner just above 42nd Street since 2001. I'm also a career real estate developer, so I'm not a stereotypical all change is bad neighbor. Some have argued that the entrance to Mid-Beach needs a gateway building to make a statement. The fact that Mid-Beach doesn't look like the typical neighborhood on the beach is that statement. Why make the area look more like Collins Avenue or south of 5th? If I wanted that type of community, I would have moved there. As a way of revitalizing 41st Street, the Mayor's Committee has floated the idea of using bonus FAR to spur development. Allowing this height increase will give momentum to increasing the height and density along the rest of 41st Street. Also, with plenty of other RM2 zoned buildings in Mid-Beach, expect to see many of those properties line up for their height increases if this gets approved. None of this will help preserve the character of Mid-Beach. I just sat through the FAINA presentation, where the applicant specifically relied upon the precedent of other nearby buildings that were granted increased height to justify their increase. The massed application before you represents the most dangerous and disruptive kind of precedent, as it would be the first such increase in this area. And just like the FAINA, this applicant is requesting a single property special zoning district, which by any other name is a spot zone. Both of these are very dangerous precedents. It's naive to think that if this is approved, other similar applications won't follow nearby. Lastly, I urge you to examine the claims of their public benefits. Many of these items are merely ways to meet the baseline stormwater management requirements for any development on this site. The most significant truth is the set of injection wells to manage stormwater quality for the neighboring garden district. Unfortunately, the system they're offering is not completely self-sufficient, nor will it address mitigation. As proposed, these wells will provide little real benefit to the city. They've also placed a valuation of $1.2 million on the easement for their public water improvements. Please note that these improvements will largely occupy land that's in their required setbacks or within an existing easement, both of which prohibit any sort of vertical construction on this land. This valuation is therefore greatly exaggerated. And their proclaimed recurring annual benefits to the city will also occur with an 85-foot full FAR building. In closing, I'd be remiss to say that having this agenda item so delayed is incredibly unfortunate and frustrating, as we've lost many resident speakers who opposed the zoning change who had to go back to work. It's a shame this process can't enable more constituent involvement. Anyhow, I thank you for listening to me, and I implore you to listen to the rest of the neighbors and vote this down. Please save our neighborhood character. Thank you.
Okay, our next speaker is Jackie. Jackie, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You have 2 minutes.
Okay. I am a longtime beach resident. I have lived here since 1968. I live in the Garden District, and I have listened to the description by the developer as he said we were football fields away. We are not football fields away. We are right across the street from this proposed plan. And I'm in support of the revitalization of 41st Street. I think it's very important that that happen also with a like other people have said, with a plan. Sorry. Hello?
Yes, we can hear you. You have a minute, 20 seconds left.
Okay. But I am not in support of this project. I speak for many people in my neighborhood. I know it has been said that there was a large portion of the Garden District that was in favor, but actually most of the Garden District neighbors are opposed. And the few that are not actually, may not be residents here for much longer. So I wanted to speak out and just say that most of the Garden District, the most affected residential part of this, we are opposed. Thank you.
Thank you, Jackie. We have someone calling from, I think this is St. Patrick's.
Okay. Do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth? I think the speaker is on mute.
You almost had it. You almost had it. Try one more time. There you go.
Yes, my name is Roberto Cid. I am a Catholic priest. I am the pastor of St. Patrick's. I have been the pastor since 2012. We're opposed to the requests made by the developer, all three of them, and our position has been very articulately outlined by the speakers that spoke before me in opposition. So I would just like, for the sake of brevity, I would like to say that there is great concern in our community among our school parents about the negative impact that this project will have if it is approved. Also, I would like to point out that in my conversations with Mr. Iglesias, the planning director for the district for the Florida Department of Transportation, he explained that the property that the developer seeks to acquire is not surplus, but will be declared so at the request of the developer if there is a change in zoning. So I urge not to change the zoning, not only because that will add to the square feet of the development, but also that piece of land will be unavailable to address the rapidly deteriorating traffic situation here in 41st, I-195 and Alton Road. And also, I would, in listening this morning at the Faena district, Mr. Wheeler said, and I quote, ad hoc increases in height are unacceptable. And then Mr. Betia commenting also stated that especially, quote, when it is a district surrounded by single family homes. That is exactly what you're dealing with in this case. Ad hoc increases in height and a district that is surrounded by single family homes. So I urge the board to reject all three points and to recommend that these proposals are not approved. Thank you very much for your consideration.
Father Cid, do you swear that the testimony that you've given in this proceeding is the truth, the whole truth? I do. Thank you. Okay, our next speaker is Christine. Christine, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Thank you. You have 2 minutes.
Thank you to the planning board for your service. I'm a 20-year homeowner in the Mid-Beach area. I appreciate that the developer stated they want to work with the community and is taking community comments into consideration. I propose that in the best interest of the community, that increase to 85 feet not be approved. I support helping and revitalizing the businesses along 41st Street, and I think those businesses could still see a benefit from having a development that stays within the current city codes. Once this variance exception is made, you cannot put the genie back in the bottle. This sets the precedent for more Mid-Beach exception requests, which takes up time with the planning board and the citizens. Take a firm stand now and vote against the height increase. On a final note, I question the developer's statement of the distance from St. Patrick's Church. I believe it was stated as 2 football fields. I am a St. Patrick parishioner, and it's a 3-minute walk to 4100 Alton. Thank you for your time and your consideration.
Thank you.
Okay, our next speaker is Kristen Rosen Gonzalez. Do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 2 minutes.
Thanks. Good afternoon, everyone. I'd like to focus on the big picture this afternoon. Miami Beach has zoning laws for a reason. We have zoning restrictions to protect our neighborhoods. We own single-family homes here. There are no big buildings here. You can see that in the rendering, and that's for a reason. It's a low-scale and primarily single-family home neighborhood. Zoning restrictions do not exist for the planning board to remove when approached by a developer. So I'm trying to appeal to your sense of community. What about empathy for those of us who live here? I live at 4618 Alton Road. What about caring what the majority of the neighbors in the community think? This building dramatically changes the neighborhood. You can see it in the rendering. It could devalue properties. It starts a scary precedent. Do these residents' opinion and community members' opinions matter? Does my opinion matter? Does our collective opinion mean anything? I ask you to not just listen, but that you hear the collective voice of the community. You were appointed to this board by elected officials who believed that you would represent the best interest of the residents. I didn't hear that earlier today when you didn't show enough concern for the residents that were upset about the Amman project. But I do have faith that you're going to make the right decision now. I think the latest rendering doesn't show the true scale of the building in relation to the neighborhood. I question the public benefit. And I do think that this will do little to, in terms of traffic, density, and precedent. Please consider deferring this item or just keeping with the 85 feet that they currently have. Thank you very much for listening. And please, come on, guys, vote with the residents just once. I don't think it's that much to ask. Thank you.
Thank you, Commissioner. Let's go to the next caller.
Our next caller is Alex. Alex, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You have 3 minutes.
Thank you very much. Thank you, Mr. Chair. Thank you, members of the Planning Board, and thank you for inviting public comment. I've been waiting here since 9:45, as many others. I would like to make 3 arguments and to ask you to actually deny this application. One is the optics. This area is the calling card of Miami Beach. When you come from 195, hundreds of thousands of people every week, if not millions, many millions over the course of a year, see the entrance with our iconic palm trees, the lighted up rings, the sign of welcome to Miami Beach. If you look at the very rendering that the developer has provided and the board has provided here, we would be seeing a high tower dominating that entire entrance, which is very much out of type with the neighborhood. Second argument is the precedent. As has been pointed out multiple times, once the genie is out of the bottle, there is no going back. And I'm a professor at the University of Miami Business School. I'm very much for business development of my neighborhood here on 41st Street, but not at 140-foot towers. This is a very different neighborhood. The third argument for me is the traffic. That very particular area of traffic outside of coronavirus times when school's on is a deadlock nightmare with traffic backing up halfway down Alton Road already, and adding to this one would make the situation much, much worse. In short, I ask you to reject it because I fail to see how this is anything but a free multi-million-dollar check to the developer with only disadvantages for the community. Certainly single family homes around the area would decline in value. Thank you so much for your time.
Thank you. Let's go to Mrs. Reed.
Okay. Do you swear under oath that any and all testimony that you'll give at this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do. I affirm.
Thank you. You have 2 minutes.
My name is Yitzhak Zweig. I'm president of Talmudic University. I want to begin by pointing out that no matter what anybody says, my property is affected more by this project than anybody else, and I'm staunchly in favor of it for several reasons. First of all, the developer already has 85 feet approved, and it's like a kind of short, squat building. And even though he's asking for another 55 feet, I think it's about 5 stories more. It's not a lot to give up to have a much more elegant building with a lot of green space in front. I do not believe it will be more impact in terms of traffic. And the fact that he can push it back further will actually really improve the way the street looks and the overall neighborhood. I happen to live in Miami Beach now for 45 years. I live at the end of North Bay Road. And even though the whole Sunset Harbor district is surrounded by what you call high rises in terms of Sunset Harbor and developments on the water all over, I think everybody can agree it's a beautiful walking pedestrian area. It's a pleasure to walk there. And I feel that with a nice, elegant building over here and more green space on the street, it'll have a very attractive feel for the neighborhood. Lastly, I want to say that I've known Camilo now for about 5 or 6 years. I've always found him to be a very kind and accommodating neighbor. I think he's a good person that is just trying to do the right thing. And I think this will actually be excellent for our community. As a long-term Miami Beach resident, I highly support it.
Thank you, Mrs. Reed. Let's go to Mr. Castro.
Mr. Castro, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. You have 2 minutes.
I actually am a neighbor right across the street on Garden Avenue, and I am directly affected by the project. I'm in support of the project. The developer has been really transparent and from day one has worked with me to alleviate the concerns that I had by putting the short-term deed restriction in, by lowering the height of the building. I actually think, just like the previous caller, that a tall building, signature building, landmark building would be great on this property. And I was really concerned about the traffic, but the reality is the traffic is caused by systemic problems that we have in our transportation system. This building is not going to make a difference. If anything, it might improve it by adding that turning lane there. So I'm in support of it, and I think it would be a great project. Camilo's a great developer. They're coming and talking to the community, getting our feedback. No other developer would do that. And I think that he's solid, and we should support it. Thank you.
Thank you, Mr. Castro. Let's go to our next call.
Okay. For our next caller, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You have 2 minutes.
Okay. Hi, good afternoon. My name is Mitil Simancas. Thank you to talk today. I would like to see development. I'm a realtor, and I believe in that. And I happen to live across the street from this new project. But I want to strongly oppose to the proposal as it is presented by mass developers. We lived already in a very problematic part of the city due to traffic west to east bounds, north to south. And this is just going to make it worse. They already have a proposal approved for 85 feet. I don't see why they cannot build based on that. That was already approved. And I oppose to the 3 ordinances presented, you know, the zone change, the density, and the newly created Julia Total District. After being on this meeting since 9 a.m., it is just disheartening to see that the voices from residents do not have the same weight as the developers. If this zone change gets approved, we all know that it will be the beginning of a domino effect. And let's not fool ourselves. It just happens all the time. I don't want the entrance of the single home residential neighborhood to Miami Beach to look like Sunny Isles in a few years. That's why I did not move to Sunny Isles. And for the gentleman who is talking about a showstopper, just go sit in traffic and then there you have it, your showstopper. It's already bad as it is. Thank you for allowing me to talk.
Thank you. Let's go to the next caller, Ms. Casanova.
Ms. Casanova, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You have 2 minutes.
During the last few months, the MBNA board, Mid Beach Neighborhood Association,
had extensive discussions on this project, and we were not in agreement with the initial plans presented by the developer. After studying the recent revisions presented, which include a height reduction to a 12-story building, which is only 4 stories taller than what is already approved, and which is in line with the height of Mount Sinai Hospital, and after seeing the other enhancements and modifications that are part of this project, we feel a luxurious building designed by a renowned architect, built by a respectful developer, with green areas facing Alton Road, will serve to enhance and beautify this important gateway to our beautiful Mid-Beach. That is primarily why the MBNA Executive Board presented a resolution in support of this project.
Okay, our next caller is Michelle Kay. Michelle, do you swear under oath that any and all testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I've actually spoken before, so I just wanted to point something out. I believe when I was reading the application that Talmudic University and Rabbi Zweig signed the application as well. So I just wanted, if that's the case, I can't find the application, but I think it would be helpful if someone could confirm that, because if he's signing the application to come, obviously he's in favor of it, but to seem like he's just one of the neighbors petitioning doesn't seem right.
Thank you, Michelle. Mrs. Zweig, one more time, we're just running on a little bit. You had like 2 minutes before we have to close out this public comment, and I think you're the last speaker anyway, so let's go ahead. You've already been sworn in, so Mrs. Zweig, if you have one more comment.
Yeah, I just want to point out that this is not the school's property. There's no reason I should be on the application. I don't know if you're looking at an application from many years ago, but this is a separate parcel. I do not own this property. I have no interest in this property. Matter of fact, the developer is not a donor to the school. This has nothing to do with me. I just think this is good for the neighborhood. It's not my property. I'm not sure why I would be on the application.
Thank you, Mrs. Zweig. With that, we'll take one last Captain Robert Arkin.
Okay. Before you testify, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Affirmative. My name is Robert Arkin.
Thank you. You have 2 minutes.
Okay, I'm a lifelong resident of Miami Beach. I live actually 1 block from the proposed project. And even though my family has been in the development business for 90 years here in Miami Beach, this particular project, as the entrance to Miami Beach, should not exceed the proposed 85 feet that's already been granted at this point. And I think that anything other than what the development rights that they have at this point should be given would be a gift to them. If they wanted to buy the property with highest and best use, they knew what it was when they went in. They don't need any additional height because that's just money in their pocket. It makes no difference whatsoever to them what they build there because they're going to profit from it. We're the ones who have to live with the traffic, with the eyesore at the very, very front of coming into Miami Beach. I think it's a terrible project to go ahead and put at the entrance to Miami Beach, and I think you guys ought to understand that this is not that you guys don't live there. We live here, okay, and we're vehemently opposed to it. And I just heard about this last week, okay. So the developer never came to my house and let me know that this was happening less than 100 yards from my house. Okay, Robert Arkin, thank you.
So let's do this. Michelle, we're going to jump you and let Gina Russ speak. You just spoke, so let's let Gina have one more shot. She's already been sworn in.
Thank you. I just want to follow up, Michelle. My understanding is the special district includes Talmudic University, that they're part of the application. So if the staff could confirm that or not, and also that the extra FAR came from Talmudic University. So if that's not correct, I think that would be helpful for us. Thank you.
If I can clarify to that point, that for the application that would come forward for the site, it would be combined with the Talmudic University site as one site for zoning purposes in terms of FAR and setbacks.
Okay. With that, let's go ahead and close the opportunity for the, well, let me do this. Michelle, go ahead. One last comment on this. I want to make sure we are getting your take fully, but
I just also want to directly on Mass Capital's website, it says that they got the additional FAR from Talmudic University. So clearly there is some other interaction other than just neighborly friendship between Talmudic University and the developer. It says so directly on Mass Capital's website. So I just, it's a little frustrating. So he's entirely allowed to give his opinion, but I think everyone needs to know that it's not totally, it's not a free opinion. There's some working together. Thank you.
Thank you, Ms. Khan. And I think Michael just right before you added that point, Michael had made some comments to that. So with that, we're going to close the opportunity for the public to speak, and then we're going to go back to the board.
I have opportunity to rebut some of the comments that were made.
One second, Michael. Let me just check in with my board members and see if they have any comments before we hear your rebuttal.
I mean, I'm okay with Michael. I mean, I don't know what everybody else thinks, but I'm okay with Michael rebutting, and then we can discuss as a board, perhaps.
That's fine. Let's go ahead, Michael.
All right. A lot was said, Mr. Chairman, but a few things. First of all, I've never heard anyone attack the rabbi's character before, so that was new. We are not using any of the floor area from his Talmudic U. It is one part of a unified development site, and that has the advantage of erasing interior side yard setback lines. But he has his own floor area to use. This application that was mentioned is not a part of this code amendment process. He's owned this property for a long time. Could have been a part of a prior application, but it wasn't nothing to do with this code amendment process. With regard to the idea of precedent, please note again, this is an island of RM2 zoning. It is surrounded by significant highways. It stands apart. The closest contextual neighbor would be Mount Sinai with a maximum height of 150 feet. With regard to some type of ripple effect going down the Arthur Godfrey corridor, please bear in mind, that's a different zoning district. That's CD3. And there's a built context already in that neighborhood that will be respected by the planning department that should analyze that corridor for any type of height increase. And remember, the parcels there are differently shaped. They're very, very narrow. They're not deep. Our parcel is significantly larger, and those parcels along the Arthur Godfrey corridor are not that deep at all. They're bounded by parking lots mostly in the rear. With regard to the idea, again, going back to the ripple effect, when south of 5th was rezoned to permit great high-rise in the perimeter, on Collins Avenue between 26th to 44th Street, where there's been 200 feet in height along the oceanfront and 75 feet on the west side of Collins, that height pattern has not been broken at all. There has been no presidential effect there. Even with 87 Park, which was when the height was changed from 60 feet, it's an RM2 zone, to 200 feet, there was no ripple effect heading westward to the RM1 district around those what they call west lots and then around Harding. With regard to traffic, we can certainly bring up our traffic engineer, but the net new trips generated by this development do not in any way deteriorate the levels of service in the adjacent intersections, whether you're going to the north or south. And again, we can invite Adrian Dabowski from Kimley Horn to talk about that. With regard to spot zoning involves an introduction of a more impactful use. It has nothing to do with amending the text of zoning regulations. When you have spot zoning, it's typically very intense zoning surrounded by much less intense zoning. A perfect example is out in Western Dade. There's something called horse country, where the county commission allowed an intense commercial use surrounded by agricultural lands. There, the 3rd district struck that rezoning and called it mellow zoning. With regard to FDOT, as recently as yesterday, FDOT has issued a surplus declaration declaring finally this property is surplus property. So that issue is now behind us. With regard to the injection wells, they are not a part of our stormwater management requirements. They are above and beyond. That is precisely why they're characterized as public benefit. And with regard to our public benefit, our request to you all today is to transmit these 3 items to the City Commission with a favorable recommendation. we can resolve all these questions that have been posed by staff. We don't see any difficulty there. They do need some details, but they can be resolved. The difficulty here is as the planning department tries to address water management issues, that's not their expertise. So they need help from the public works department. Coordinating between these departments takes some more time, but I'm very confident that, and I commit to you all that before the city commission would ever hear this, that we will resolve the questions that were raised to me yesterday. Our client, bear in mind, Camilo Miguel, has agreed to design, fund, and install this water management structure, which is above and beyond what he has to do, at a value of over $2.7 million in exchange for this modest increase in height. All of these obligations will be set forth in a covenant that will run with the land. And just going back on a very important point that I think hasn't been talked about today. There is a famous American author called Mark Twain. He said, buy land, they're not making it anymore. Right now in the 21st century, with the city of Miami Beach, we have to combat sea level rise. And that has led to a significant increase in flooding throughout our city in the low-lying neighborhoods. The city needs land for pump stations, outfalls, and wells to control this flooding, but the city doesn't have it. The percentage of property that's publicly owned is a fraction of what is privately owned. As a result, these type of partnerships between the private sector and the city are vital for our continuing efforts to control and mitigate flood. When an agreement is reached, when a balance has been struck between a private party and the city, I think it's imperative that we go forward and consummate the deal and transmit all these items up to the city commission. That's all I have, Mr. Chairman. I don't know if Camilo has anything else you'd like to say.
Go ahead, Camilo, if you have something you want to add.
No, I think Michael pretty much covered all the things that we wanted to discuss today. I mean, our goal is to do something that's sensitive to the community, sensitive to our neighborhood, sensitive to Miami Beach, and something that is portrays as people continue to arrive in and out of the beach or that main arterial. I'm very grateful for all the time that everybody on this call is taking away from their private time, from their work time, to participate and listen to us present our project. We're trying to do the right thing. We've proffered a lot to the city, things that are very, very substantial as a give back for what I find to be a modest ask. I would say that, you know, we have the ability to develop something on the property. All we're trying to do is redistribute the mass to allow for better views, a more distinctive architecture, and something that's much more aesthetically attractive. I think the green space and the gardens and park in front of the property will be a tremendous value add for the community and the neighborhood and for anybody that drives by this location. Again, I thank everybody for their time. I'm hopeful that we can get this transmitted to the commission, and I look forward to continuing to work with everybody on future projects as well as this one. Thank you.
Mr. Chair, just as a housekeeping measure, we can have the convention center room until right around 4, but after 4, they're going to lock the doors. So what you might want to do is close the public hearing and then engage in your deliberation so you can try to conclude this item by 4 o'clock.
Yeah, Tom, we've already closed the public opportunity to speak. There was the rebuttal, and then we can go from there. So now we're just going to open it up to the board.
I'm happy to go first, or I can wait. We have some Mid-Beach folks on the board.
I have questions for staff before we get into the meats of this application.
Daniel, you want to go first?
So staff, if you can help me out to understand Unified Development Site and how application is coming in front of us as Unified Development Site, but yet you have two separate owners that are not really joint owners of it. So can you help me there a little bit? Because when we start talking about setbacks, I'm curious how I'm able to regulate setbacks within this Unified Development Site, and I can use your help on explaining that.
If I could just touch on that first. So this is a Unified Development Site. I think there is a covenant. So we take the setbacks based upon the entire property in terms of especially the side setbacks, rear setbacks, based upon the lot width of the entire parcel, including the Talmudic site. And I know they've drawn like a property boundary along the building line of the Talmudic University to separate the lots. But effectively for zoning purposes and FAR, based upon my understanding of how the lots were joined, we are taking the setbacks and the FAR for zoning purposes of the entire parcel, including the Talmudic site and the vacant portion. Because even if you look at the Talmudic site now, you have the access point to some of the parking in the front of the Talmudic would be going through the entrance to access those parking spaces from what is called out as the developer site. So it does share common access points and crossing what would otherwise be property boundaries.
And I appreciate that because usually when I'm in a unified development site, I'm working with one property owner that has control over the development of the entire parcel. Here, it's coming in as a unified development site, but they're two separate owners. So I'm just curious how we can achieve that. How can it be a unified development site if there really isn't a unity of title? Because they're separate parcels, separate folios without, and I know you're going to say covenant. I got that. The FAR calculation that's going into the new development, because it's a unified development site, I'm assuming you're calculating it based on the footprint that they've outlined in their presentation. And my last question is there any unused FAR on the university site that can ever be used in the future, or are they maxed out on FAR?
Well, I don't have an analysis since we don't have a project that's been analyzed before you with that specifics. Based upon the prior project that was approved, that included new construction on the vacant portion, as well as additions to the Talmudic site. My understanding, based upon that would have maximized the available FAR for the combined site.
So to be clear, I don't even know what to call it, but the undeveloped portion of this unified development site is going to max out the FAR that's available in the entire parcel.
That's my understanding, yes.
Thank you.
Well, is your understanding, or is it yes? I mean, that's pretty important.
Well, that's why they're purchasing the additional FDOT parcel is to also give them additional square footage.
As a unified development site, someone comes forward to me and says, I want to develop this undeveloped portion of this entire site. Can I force them to do improvements to the portion of the site that's not within their control? Because I'm losing track of why it's a unified development site if I don't have any control over the other portion of the site that's unified to it.
Well, I think for that discussion, all that unification happened back in 2013. So I don't have all that information in front of me now in terms of the application that was approved. And I do know that when this did go to the design review board, it included improvements to both the Talmudic site as well as for the vacant portion.
Thank you.
Michael, you want to go ahead?
Sure. Thanks to everybody who's participated and those folks who've been on the line since 9 o'clock this morning. I know we do this once a month. We're kind of used to it at this point, but that's a big hardship. And thanks to the developer, I am a little bit familiar with this developer's work. A project built in my neighborhood that was very compatible and super nice, fit right in, and has been great. Never heard a complaint that I'm aware of. But overall, in this situation, I am mostly persuaded by the idea that and I don't think we can underestimate, as a board, I don't think we can underestimate the degree to which somebody who buys a single family home, lives in a single family home neighborhood, just it's a non-starter. I mean, you can't even visualize the idea of a 140-foot building in the neighborhood. And so, Garden District, Alton Road North, Alton Road South, Nautilus, I think for these folks, they're counting on us to to protect the character of their neighborhood. And I'm persuaded by those arguments. I'm persuaded by that. I just don't see, I think it's my understanding there's a master plan that's in the works. The 41st Street Committee is working on a master plan for the 41st Street corridor. And I don't want to underestimate the importance of bringing some life into that area. I think that's important to a lot of folks as well. And perhaps, you know, thinking about the North Beach example and how the master plan, you know, was comprehensive and included the entire community as a part of a conversation. Maybe this parcel could be included in that conversation as a part of a master plan. You know, that may be there might not be any interest in that, but that would seem to be a better way to go than I think the comment before ad hoc, I think that was mentioned. Maybe David, was that your comment before? And yes,
it was.
That's how this feels to me. It seems like a one-off and a situation, and it doesn't. I think we should respect the wishes of the folks who live the closest, and they don't want to see the character of their neighborhood change. I live in a multifamily, in a mid-rise multifamily building with contemporary architecture. I'm a big fan of contemporary architecture. I chose when I moved to Miami Beach after many years of building single-family homes and building single-family neighborhoods. I chose to live in a multifamily building. So I think I understand very well the difference between the two. We have several folks on the board who live in single-family homes. I'll be curious to hear what everybody else says. But I'm going to be voting no today.
Excuse me, guys, before I try to interrupt, but just to confirm, I did confirm that we do have an application submitted this year to the Design Review Board that includes the Talmudic University as an applicant to the application.
Yeah, I mean, I'd like to try to get clarity here. We have someone from the university saying they're not involved. You know, I need legal expertise here. This is a unified development site. That means I have the ability to control the entirety of the site and impose conditions on the entirety of the site. It seems really strange to me how you had one site that got subdivided. They're coming in on a unified development site, which benefits them, but at the same time, I don't have control to impose changes on the other.
Daniel, let me see if I can provide a little clarity. When they came in for the proposed zoning changes in 2012 and 2013, the reason for that is because Mass purchased the south side of that site, which was previously owned by Talmudic. When they purchased it, they wanted to maintain it as a unified development site because splitting that site off would have created an inconsistency. There was also circulation aspects that needed to be addressed because there are shared circulation elements on the site. That's the primary reason that it is still a unified development site, is so that they can have shared circulation. So when it goes to DRB, as Michael indicated, for zoning purposes in terms of setbacks and FAR, it's going to be looked at it as one site. But the portion that's owned by Mass is what the DRB is going to focus on, even though the larger site will be part of the application.
And I appreciate that. I'm just like, let me give you an example. Distance separation between the university and the new development site. I can't control that because it's a unified development site. So I can't impose any setbacks in between the two buildings. I can impose setbacks on the entirety of the overlay district we're creating, but there isn't a code amendment, an LDR amendment that I can do to control the massing of the building in context to the university. Is that correct?
No, you could absolutely recommend development regulations. People do this within sites that have multiple buildings. Within a single unified development site, you can have regulations that create minimum building separation standards within a development site. So
that's
I don't think you need to do it in this particular instance, but you could recommend that.
Yeah, I mean, to me, looking at the plans, I go, we're not approving a project today, but just looking at the plans, they're certainly trying to fit a lot of FAR in a limited site, and now they're looking to increase that FAR, and the only way they can fit it is by increasing height.
Daniel, they're not increasing the FAR. The FAR is remaining at 2.0. They want to redistribute the FAR vertically, but the FAR will remain the same. If there's no change in height, the same FAR will be utilized in an 85-foot building. That's the only difference.
Let me rephrase that. By taking the FDOT land that's now government use and rezoning that to RM2, they're gaining additional square footage, same FAR ratio, but they're increasing their square footage. So in order to accommodate that additional square footage, you got to give them additional height.
No, Daniel, no. Again, we've done an analysis that shows that even with the addition of the FDOT parcel, you can do 85 feet within that site and accommodate all of the allowable FAR.
But I haven't even, defined the distance separation between the existing building and the new construction. It's like when you look at the plans, yes, there's some shared components like a driveway, an access point, but they're two separate uses, 100% two separate uses. And there doesn't seem to be any thought into the impact of those two uses together. We keep on talking about the impact of the overall site to the context of the surrounding neighborhood. I'm really concerned also with the success of the project of having this university use, which, by the way, has some significant housing on site, versus this high-end residential use being proposed, and how to ensure the success of that high-end residential use and trying to create some distance between those two uses, to me, seems to be a challenge.
Well, what I would say to that, Daniel, is that regardless of whether the project that comes forward is at 85 feet, which is the current height, or is at a slightly higher height, whatever the number is, they're going to have to go to the design review board, and MAST will have to do this in partnership with the Talmudic University. And obviously MAST is not going to submit an application that the Talmudic University has concerns with. If there's an issue with distance separations between the buildings, they will work all that out before the application is even submitted. But that's how it was addressed when the first MAST application was approved back in 2014. They had an approval on their existing site at the current height limitation, and they were able to work all that out with MAST. In this particular instance, if the FDOT parcel is eventually added, they're going to come back to the DRB with a new application, and regardless of whether it's at 85 feet or another height, they'll have to work that out with the Talmudic University, and that would be done as part of the DRB review.
And then when it comes to drainage, are they looking at the drainage for the entirety of the site? I'm assuming, based on the drawings that I saw there, are they looking to create drainage for the entirety of the site, including the university's footprint?
Under the current code, they would have to meet the on-site water retention and drainage requirements for the entire site. And I believe that they are able to do that.
Is there anything else, because they're a unified site, that I should be aware of that they'll be responsible for the entirety of the site? Parking requirements, anything like that, landscape requirements, anything like that?
MAST is not responsible for the landscape or parking requirements for the Talmudic University because that is an existing building. If down the line there was ever a proposal, if FAR became available to do an expansion, then they would have to provide, and parking was required, then they may need to work together to address that. But there's nothing in the MAST proposal now that would affect the parking on the Talmudic site.
And to my original question, was there any unused FAR left on the university parcel that you believe might be able to be incorporated, not related to the additional FDOT parcel they're looking to obtain?
Michael, can you address that?
So the project that was approved previously included new construction on the Talmudic site. So unless they're going to take that away and add it to the vacant portion, my understanding is that there was available FAR for modest additions to the Talmudic site, but I haven't seen their latest application, new proposal. If that's no longer proposed, it hasn't been constructed, they could use that square footage on the vacant site.
And just to be clear on the previous project you're alluding to, that addition to the university was for the benefit of the university or part of their new proposed plan?
No, it benefited the university as, you know, attachments to the existing university. And then the new construction was a new residential tower. And I know at the time, there was some talk about the separation. And I know that that's what the university was really concerned, to make sure that there was a separation of views between the students at the university and the new residential units, which were addressed in that application at the time. So I'm sure, as like Tom mentioned, that would be worked out with the Talmudic, which is a co-applicant as part of the would be the design review board application.
So we all agree the university is going to have to be a co-applicant when it goes to the DRB for this?
They signed off on the application.
And just from your perspective, looking at the plans, what shoots out to me is how close the new project is with the distinct use to the university project with its own use. Don't look at the constraints of this site. What do you think should be the separation between those two? And do you think this site could accommodate enough separation between those two uses?
I think they pushed the separation as far as they can with a proposal to reduce the setbacks along the south. Push it. So I think they are pushing the building away as much as they can. It's not, I don't have the dimension in front of me, but it's not smack up against the university site.
Ultimately, Daniel, a lot will depend upon what the floor plans are and how they're laid out on the new residential building. They probably are going to lay that out in a way so that the uses on the north side, immediately adjacent to the Talmudic, would not cause any type of interruption to that site. But obviously, as a co-applicant, the Talmudic University would have to have a comfort level with what they are proposing in terms of new construction. They certainly did when the DRB approved a project a few years ago, and they would have to when a new project is submitted with this new iteration.
Well, yeah, that's only going to be more challenging now that, you know, they're looking at potential additional square footage and how to confine that square footage in the site. I think, you know, my opinion is that this was once one site. They built this, what I call the Howard Johnsons, the university there. It was all intended to be one site, and it seemed to flow really well. Now you're really trying to push additional development onto a limited site with a lot of constraints.
So, I think what we're getting lost in the weeds here. Michael Larkin said that the 87 Park is in RM2, but not all. That's an oceanfront piece of property, so not all RM2 zones are the same. What we're talking about here is a neighborhood issue, and there's what seems to me to be an overwhelming reaction from the residents that they don't want this height increase, and that there is a debate as to whether this is going to be a, quote, showstopper, or whether it's going to be a vehicle for more congestion on Alton Road and coming off the Tuttle Causeway. I don't see how I can possibly vote in support of this project or the change in this ordinance, because there are too many people that are upset about it. And I think we do have to have some kind of sensitivity for what the people want. There are legitimate issues that are still unresolved. The traffic issue and the drainage issue, and who's deriving a financial benefit from this. If Talmudic University is deriving a financial benefit from this, it erodes their credibility as a witness. There's just too many things that don't resonate with me. So I don't feel that and plus I feel, from my view of and very importantly, I think from my view of the picture, is that it is not contextual with the neighborhood, and by no stretch of the imagination is it contextual with the neighborhood. So we're talking about a project that doesn't belong where it's supposed to be put.
David, I don't disagree with you. The reality is that the developer is going to have the right to develop this lot one way or another, whether we give him the height increase or not. He has the right to develop it, and that's what I'm trying to better understand. I'm not in favor of.
Daniel, I'm not undermining your inquiries about these details, but I just wanted. We were spending a lot of time on it, and I sort of understand where you're going. I try to anyway, and that's not a derogation of you. It's just that maybe my comprehension is not what it should be.
I just think we all need to understand this developer.
Yeah, I know that. I understand they have the right to develop it, but they don't have the right to develop it at 140 feet.
I agree, and now that they don't go to 140 feet, if they obtain that FDOT parcel, where does all this additional FAR go?
It goes at a lower level.
To Massey.
It's going to be a short, squat building, which is what the immediate neighbors prefer.
And Mike,
but also, guys, Daniel, here's the point, just quickly. So this is not the case where the city is selling right away, which the developer cannot build on anyway. This is the case where they're actually acquiring the land. So that land expands the footprint of where they can build. It's not just a matter of acquiring additional right away for purposes of FAR and within the same footprint of the site. So they are expanding the footprint. So there's more room on site to build a new construction. So it can easily be accommodated within the 85-foot height limit.
So one of the things that we're looking at today is height. The other thing that we're looking at today is a change in zoning from GU to RM2. So could we focus a minute on the change from GU to RM2? When they purchase this GU site, they have a right to that site becoming RM2, or does that site require our approval to become an RM2?
It requires your transmittal and recommendation, but they need to rezone it because GU is specific to government-owned parcels. So once a government-owned parcel is transferred in ownership to a private entity, you have to rezone it. Our code requires it. So that's just purely a technical exercise.
I agree. And what are our options for rezoning that GU site? The only option we have is RM2?
RM2, correct.
We can't go to a lower zoning district. It has to be RM2, correct?
Yeah, because that's what the two abutting parcels are.
So there's nothing I can do to encourage them not to buy that additional parcel, and we're going to have to approve it to an RM2. So not to be negative, but I'm just a rubber stamp here on that regards as far as it becoming an RM2 site. Once they buy it, it's going to become an RM2.
I don't know if I would put it that way. Tom, do you agree with that? I don't know that I would put it that way.
Yeah,
I think it requires your review.
I wouldn't say a rubber stamp.
Yeah.
It's a recommendation. Clearly, if you believe that it should not be made part of that site for whatever reason, you can certainly make that known, and the board collectively could make that in their recommendation to the commission.
I understand that. From a planning perspective, changing it from a GU to RM2 increases overall unit count and overall square footage. Unlike someone that already had the right to develop something they bought, here they're buying something that doesn't have development rights. They bought it. That means now they have a right to build more square footage and more units. If I'm a planning board and feel that that's not in the best interest of the city to increase additional units, to increase additional square footage, that they don't have a development right today to do, what am I to do as a planning board to curb that and ensure that that doesn't happen?
You could recommend that the city purchase the property. You could recommend that the rezoning not go forward. I mean, your role is not to just, provide a rubber stamp in this regard. It's like any other proposal for rezoning and a change in the future land use designation. You make a recommendation. We made a professional recommendation in the staff report. It's your job to consider that and make an informed recommendation in your transmittal to the commission. If you believe that it should not be rezoned to RM2, then you can certainly say that. But let me just say, with regard to the development regulations, if that was going to be developed as a GU parcel by the state, for whatever reason, they would take an average of the abutting development regulations, which basically means that if they wanted to develop it as a GU parcel, you would get a 2.0 FAR and you would get 85 feet in height. So you basically, you already get those regulations because the GU takes an average of the abutting parcels. And since the abutting parcels are RM2, that's what the development regulations would be for any application if, like, say, the state wanted to build a housing project.
So those development rights are already there in a GU site, and they're contemplated in our comprehensive plan that's a site that can be potentially developed?
The Rogelio, with the current future land use designation, does that allow residential?
Yes, it does. It allows for workforce and affordable housing, and it allows market rate housing. It does not allow for market rate housing, but it does allow for workforce and affordable housing.
So the current future land use designation is a little bit more limited, but with a private developer, if you were to say we're not going to allow if we're not going to permit market rate housing, that could have an impact, obviously, on their project. But if you believe that adding this to the zoning atlas as an RM2 doesn't make sense, collectively the board could make a recommendation like that.
I think that that's a good idea.
I mean, I'm with you guys. I think you have to have a comprehensive plan for 41st Street and a vision for 41st Street to encourage development to come. You know, you have this 41st Street committee that's been working really hard. Certainly, there are some issues they want to address, and I think a comprehensive master plan with community input would be a great way to steer development into the right direction of what's needed. I certainly feel uncomfortable with the purchase of an additional site, which is a GU site, to add additional square footage to a previously approved project that for one reason or another didn't move forward, and a unified site that was subdivided that just doesn't seem to work. I just don't know how successful this residential project is going to be with the existing university use right next door to it. It just all seems like you're trying to put something there that probably isn't the best interest to put there for financial success and for the overall planning of the neighborhood.
And Daniel, that could change too. I mean, we don't control necessarily what happens in the future there, so we can end up with unintended consequences in that situation.
I agree. I mean, there's a reason the university probably sold that parcel. I mean, how long will that university succeed there with taxes the way they are and everything else? I don't know what the future is for that parcel, but I certainly feel that we're trying to facilitate development where it probably shouldn't be. I don't know.
Yeah, and how can it be that this is not a part, this a little add to my comment, how can it be that this is not a part of the master planning process if there is in fact, and I agree with you, I've attended some of the meetings of the 41st Street Committee. It's a hardworking bunch and they're very sincere and they're on it, they're really trying. And, but I would question as to how this can be such a significant proposal and a significant change of character for the western side of 41st Street, and how can that not be a part of a master planning process if in fact that's what's going on? That's my understanding that the master plan will be released soon. So I don't know, Tom, if you have a comment about that, maybe.
Yeah, the master plan would include traffic implications. I mean, has this project undertaken a traffic study?
Two things. I'm not familiar with the process that the 41st Street Committee is undertaking. I've been to some of their meetings on a very limited basis, but we haven't been staffing that, so I don't know if and when they will be releasing a master plan. My understanding is that the developer did go before the 41st Street Committee and that the 41st Street Committee endorsed their proposal. With regard to traffic, David, when the application is submitted for DRB approval, a full traffic study will be undertaken. That's when traffic studies are always taken.
Well, that's just a suggestion on my part. I mean, and of course, I don't know how the rest of the board's going to vote, but I think that kind of grassroots, community-oriented, holistic kind of an approach obviously worked very well in North Beach and reassured a lot of North Beach residents that it wasn't going to be this domino, that it wasn't that no, here's what we're going to do to create some growth, but it's going to be right here. It's going to be in this specific location, and everybody could understand that. And it took
Michael, until some of the people saw some of the projects that were coming out, and all of a sudden they had some heartburn, right?
Yeah, could be. But what I'm saying is it as a part of that process, everybody got to participate, and there wasn't as much fear that it was going to be a domino kind of thing.
Can I ask staff a question? How much land does the city own around this? Where the sign, the Welcome to the City of Miami Beach sign is, which is a beautiful sign, I don't really believe we need a better entrance than that. I drive by it every single day of my life. But how much land do we own there? Because part of the public benefits that was put forth here was some stormwater mitigation and the like, which we need some land for. But it seems like perhaps we already have a lot of land already to deal with that if necessary.
Mark, in terms of the land ownership, there's a couple of different triangular parcels that abut the I-195 interchange. And the large triangular parcel where the signage is, that's all FDOT owned, I believe.
That's correct.
And yeah, we just verified that. So that's all FDOT. They've allowed us to put signage there. And I think what the developer was saying was that they would be happy to participate in redoing that signage in some capacity.
Right, but what about the land necessary for stormwater mitigation? That was put forth by the developer. Do we have?
Well, that's on their property.
No, I know, I understand that. I understand that, but I'm saying that they're saying that's a public benefit. But is that truly a public benefit? When we perhaps have alternatives to that. That's the question.
Well, I think it really depends upon the details of that proffer, and a lot would really depend upon the amount of infrastructure that is eventually provided, how it would be connected to surrounding areas. And those are the details that we still have questions about. And one of the reasons that we had recommended continuance on that, because we just don't have enough detail to say to you, yes, for sure, that's a major substantial public benefit.
Right, because some of these may be illusory here when, there are alternatives already, and perhaps also illusory in that they have to do that as part of their project. So I'm not sure what our real benefits are when they would have to do it anyways. But couch it as a public benefit.
So in any event, if we turn this down today, they can't build anything above 85 feet, correct?
Well, if you were to transmit it with an unfavorable recommendation, they would go to the commission on September 16th for first reading. Unless the commission approved it, then they would be limited to 85 feet in height, which is the current allowable height.
Right, and then Tom, and everybody else, that if they were to just move forward with what they can already do, which is the 85 feet in height, then that separation that they're trying to achieve, which I was looking through their package to see kind of how the building has evolved. They're getting that separation from the Talmudic building by the acquisition of the land and by changing the massing of the structure and the height. Otherwise, in 8 stories or whatever, 85 feet, they're pushing, to Daniel's point about separation, they're actually kissing almost in their previous design. Doesn't mean that it can't be designed better, but in the current design, they're pretty much kissing that existing building.
That's correct. And if in the end they have to design a building at 85 feet, then they will have to take a fresh look at their parking circulation, at their floor plans, and they'll have to come up with a design that the Talmudic University would not be averse to.
Now, Tom, the board could always transmit the map changes with a favorable recommendation, but the text amendments with an unfavorable, right?
Yeah, you could do a separate actually, all three require a separate vote, so you could do a separate recommendation on all three.
I think we're looking at all this at one time. I'd hate to send one without the other. We're not really
exactly.
it all.
And I'm happy to hear what everyone else has to say, but that doesn't sound like an attractive option to me. So,
I mean, the issue of the height, I think, is easy enough. You know, we deal with height increases all the time. This is certainly an area surrounded by single-family neighborhoods, which is why, for the first time I've been on the planning board, I've gotten so much opposition to a height request, is because it's surrounded by single-family homes that are clearly going to impact by height. This isn't about someone, hey, you're blocking my view because I live in a tall tower, so you can have a tall tower. This is about a single-family home that all of a sudden has an overbearing development overlooking their single-family area, and I can completely understand that. So, you know, I think the height might be out of context. I'm more focused on, you know, someone has a right to develop. What is the best way to encourage the right type of development? I don't think that providing a public benefit should be a trade for development rights. I think it often somehow got there in our current city, where if you provide enough of a public benefit, we'll provide you with development rights. But, you know, from a planning perspective, it's the city's responsibility to deal with drainage. I hope all the residents are aware of how high our taxes are going to be as we try to deal with all the sea level rise and drainage issues, and I think we're all aware of that. Sure, it would help to have some help from developers, but everyone's going to have to pay for the price of making our city resilient and move it forward, and I don't think that should really be something we're trading for development. You know, I'm mostly concerned with learning about this potential added development or square footage by purchasing this GU parcel, adding it to a privately owned, and increasing, you know, the number of units in an area, and what can we as a planning board do to not encourage that? Because I certainly don't feel that increasing units and increasing square footage on this site is helping the situation, which from what I understand, everyone has explained to me, they've been trying to develop this since 2014 unsuccessfully. So the only way to make it successful is by increasing the square footage of the project so that it's more viable. Maybe the fact is that this isn't the right place to develop the project.
We're talking about square footage without changing the FAR. Is that right, Daniel?
Yeah, from what I read staff report, it's another 39,000 square feet of developable square footage that they're going to gain from purchasing the GU site and changing the GU to RM2. And that's really my bigger concern than the height request, which clearly I don't think my fellow board members, from what I heard, are supportive of. And if we don't give them more height and they do get that square footage, then that's only going to make that site even more dense and constrained.
Very massy. Yes.
So
I'm trying to figure out, what do I do as a planning board here, knowing this is in front of me? You know, send it with a non-favorable recommendation. Sure, I think that's easy enough. For the first time, I'm hearing something of changing GU to an RM2 for a private applicant. I've seen this when the government is working together in a joint venture with a private developer. I see that. I've seen that. I've never seen it in front of me to a private person. I don't know what tools I have to discourage that GU becoming an RM2 for the reasons that added unit count, that added square footage probably is in the best interest.
Yeah, that has to do with the change of zoning for that other parcel, no?
From what staff is explaining to me, you know, from what I think I understood from Tom, is that we can make a recommendation that we don't recommend the GU change to an RM2. Legally, once they purchase it, do they have a right to keep it a GU and develop it? They just won't be able to do market housing?
Daniel, just to add a thought, I mean, assuming the extra square footage is available in the future, based on the folks that I've talked to that live nearby, they would still tell you real quick they don't want it higher than 85 feet. Now, I mean, I understand your point that that's maybe not the best urban planning, but I think that's a strong preference and the sentiment within the community, within the neighborhood.
Is what you're saying that if you approve the rezoning and the parcels can be unified, that you'd still want the height to be capped at 8? Is that what you're saying? Like, leave the existing development regs, but hypothetically, if the parcel was rezoned, that it could be unified.
I think that's my question. I think that's my question is, it can't be unified and the FAR can't be incorporated into their new project for the FDOT parcel they're trying to buy if they don't rezone it from GU to RM2. So I think that you guys have clarified that, I'm assuming. The next question is, how can you stop them from rezoning it to RM2? If they bought it, do they have a legal right to force the city to make it an RM2 zoning?
Yeah, the GU district has regulations for what happens when a government use ceases, and that's in section 142.425, and it says upon the sale of GU property, the zoning district classification shall be determined after a public hearing with notice pursuant to Florida statutes by City Commission in a manner consistent with the comprehensive plan. Upon the expiration of the lease, the city or other government agency, the district shall revert the zoning district and its regulations in effect at the initiation of the lease.
This wasn't a lease. This was always owned by FDOT. So now a change in ownership. I mean, I'm not an attorney. I have to assume it's going to revert to an RM2, but I don't know that.
No, I don't think it does revert to an RM2. Maybe I'm wrong.
No, Tom said that earlier, didn't you, Tom?
Application for it to revert, to change.
What I had said was that since the abutting districts are RM2, that was the most logical district to rezone it to, because it would allow for it to be absorbed by abutting parcels. It's probably also important to point out that over time, the city has purchased property that became government owned that is not shown on the zoning map as GU. And we need to do some cleanup amendments in that regard, because since they are city owned, they are actually zoned GU. They're not the underlying zoning district. This is the opposite effect, where this would no longer be owned by a government entity.
I have a question for staff with regards to the whole sale and transfer of the portion of land. Do we have an understanding of what that process is relative to our deliberation here today? Is that contingent upon what we do here today, or is that something that will transact potentially regardless of what we do here today?
That transaction either will or won't move forward on its own merits. Your role here is strictly to make a recommendation on what was referred to you, and that is to rezone the property to RM2 and change the future land use designation. The referral was predicated upon that transaction consummating. If it doesn't, then the commission will not adopt either piece of legislation at first or second reading, and the property will remain GU.
Okay, so we spoke about height. We spoke about rezoning from GU to RM2. Do we want to talk about this overlay district for the Julia Tuttle and the setback requirements and everything else that's being requested, or is that not relevant at this time?
I think, guys, if we're going to have more discussion, we need to continue it or make a motion.
No, we're okay. Since we concluded the public hearing, we were able to close the room at the convention center.
Okay.
So we just won't be able to open the public hearing. That's all.
And the people that are in there can't get out.
I think we could cross these other bridges when we come to them.
Yeah, Daniel, on the overlay, the biggest component of the overlay is obviously the height. And the setbacks that were proposed were designed around the increase in height. And so everything kind of works from there. Those are the two biggest components of the zoning overlay. If the planning board is not going to recommend in favor of the height, and the commission does not approve the height, then I suspect that the applicant probably will withdraw the overlay because there's no sense in it going forward because everything has been designed around that height increase.
And I understand, and I most certainly think that if we gave them additional height, they have a better way of distributing the FAR that would be better for the overall site. For me, I just feel that this was once one site. They should really purchase the university, redevelop the entirety of the site, so then that you can really distribute the FAR in a way that you can have a successful project. I'm not the developer. I don't know what he's tried here, but just based on history, I think what I heard from testimony was that this is the second project that was approved by the DRB for this site. It clearly didn't move forward for one reason or another. I don't know what that is. And rightly so, Mass Capital is trying to figure out a way to develop this site. And, they made an investment and they're trying to make it work. And I don't want to just say, no. I want to figure out what's the best way to develop this site, which is why I'm asking all these questions. Is there some amendments to the regulations that we should entertain to assist this private developer in developing this site without increasing height or encouraging them to increase square footage?
You're absolutely right, Daniel, about the unified site issue. It's like trying to make a sandwich, putting the mayonnaise on first, slapping the bread together, and then trying to put in the ingredients afterwards.
Mm.
Yeah, I feel for people that bought a parcel with a set of defined rules and they're trying to develop within those rules. I get that. And we see that a lot. We're trying to preserve a building. They're going to take the unused FAR and the available square footage and try to develop a new tower there and, try to preserve the existing building. And we see that a lot. Here it seems a little different. Here we had one site. Someone came in, purchased the unused portion of that site, separated it in the attempt to develop the remaining portion of that singular site that was once a singular site. And that really started to create a ripple effect that brings them in front of us today, trying to amend the development rights so that they can develop the portion they purchased.
And also, Daniel, just to add on to that, is they got a 30% increase right away, which we weren't part of. It was a different planning board.
2015, right? Went from 60 to 85 feet in 2015.
I guess I'm just confused, how you have the ability to buy a portion of a single folio and then not have underlining development regulations to try to account for that. Like us, we don't have side yard setbacks between the new development and the existing university as a result of that. And I think that's where it just starts to get a little tricky.
Is the Talmudic University a contributing building, Tom?
It's not in a historic district.
It's not in an historic district. It's not a contributing building.
So probably the ideal thing would be to demolish it and then unify the site and then put something in there that conforms with what the neighborhood would want or would accept.
That would most certainly be the way to develop.
As part of a holistic approach for the 41st Street corridor overall, not just all by itself.
Yeah.
From my perspective.
Are we
ready to vote?
I don't know. I want to ask staff if there's anything in the LDR amendments that they want us to consider. If they felt that we weren't inclined to approve the height increase, is there anything in those development regulations that we should consider while they're in front of us that would make the existing development site, make it better for the development of the unused FAR at this site?
Well, I can tell you that everything in the ordinance revolves around the proposed increase in height. The setbacks certainly do because they contemplate that redistribution of the volume. So no, I don't. I think that if you're not comfortable with that height and you don't believe that that height should be approved, that it should remain at 85 feet, you're probably better off just transmitting it without a favorable recommendation in that regard.
In regards to lot coverage for pervious areas, didn't we amend the RM2 on the percentage of lot coverage that a new development can have?
No,
RM1
that was
only.
RM1.
Originally proposed for RM2, but we took out RM2 and only stayed with RM1, correct?
Correct.
Yeah, I don't have any questions. I think, it's a confusing application. It's a confusing site, just, with how it was once one and then divided. And I just still having a hard time getting past that. But I most certainly don't think an increase in height is going to be beneficial for the neighborhood. I'm still concerned, how we can help make any potential future development better at this site.
Mr. Chairman, I call the question.
You need a motion.
We need a motion.
You need a motion.
Yeah. Are you moving to? You called a question. Are you moving to?
Yeah, I moved to submit the entire package to the commission with an unfavorable recommendation.
I think we should, if you don't mind, Mr. Weeder, I'd like a motion on each portion. 2 of them are quasi-judicial and 1 is legislative. So okay. I believe Tom should the comp plan first, right?
Yeah, if he would read the.
That's correct. If you could do the comp plan, separate motion on the comp plan, separate motion on the rezoning, and then a separate motion on the LDR amendment.
Okay. Do you want to read the? Text? I don't have it in front of me.
Yeah. So basically, we're saying.
Give him the number.
We're going to take 368 first, then we will take 367 and then 369. Correct?
Correct.
That's correct.
Okay. So the first one is David. Are you moving for the first one? I don't want to. There's no motion there. Are you?
Yeah, I'll move on all 3.
Well, so let's take the first one.
Can you do them separately?
We can do it separately, but I can move on all 3, and then we can take a separate vote on each.
All right. Well, let's do it this way. So we're going to take the first item, Planning Board 20-0368, 4000 Alton Road, the Flume comp plan. David, you're moving that we send this unfavorably to the commission.
Correct.
Do we have a second?
I'll second it.
Michael?
Okay, Mr. Batia?
No.
Mr. Milan, so that's no to the negative recommendation.
I say no, I do not wish to transmit it with a favorable recommendation.
Okay.
That's a yes.
Yes. We need to be very clear on the roll call. So the motion is to transmit with an unfavorable recommendation. So all we need to hear from each of you is a yay or a nay.
Yes.
Yeah, if you vote yes, that's to transmit it with an unfavorable recommendation, just to be clear.
I'll say yes, unfavorable.
So again, Mr. Batia?
Yes, unfavorable.
Mr. Milan?
Yes.
Mr. Weeder?
Yes, unfavorable.
And I think Mr. Jalpi is absent, correct?
That's correct.
Mr. Barano?
Yes.
Mr. Pietro?
Yes.
And Mr. Brantley?
Yes.
Motion passes 6-0.
Okay, so David, now let's take the second one for you, which will be Planning Board Item 20-0367, which is the rezoning, and you want to transmit that unfavorably to the City Commission, correct?
Correct. I move it.
Who was the second again? I'm sorry.
I'll second. I'm happy to second.
Michael's the second.
Okay, Mr. Batia?
Yes, unfavorable recommendation.
Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Barano?
Yes.
Mr. Pietro?
Yes.
Mr. Brantley?
Yes. And then so the
motion passes 6-0.
The last one will be Planning Board File 20-0369 to be referred to the Commission unfavorably. Moved by David. Do we have a second?
Just make it consistent. I'll be happy to second. So.
All right.
Okay, Mr. Batia?
Yes, unfavorable.
Mr. Milan?
Yes.
Mr. Weeder?
Yes, unfavorable.
Mr. Barano?
Yes.
Mr. Pietro?
Yes.
And Mr. Brantley.
Yes.
Motion passes 6-0.
All right. I just, and I voted the way I voted because I just don't think that we were here to do the type of development that is right for this location at this time. I don't think that should be a reflection that this developer has not presented something that was really, really good, I think, relative to what they could build. And I had some real concerns about the proximity, and then they pulled the development away from the other building, but they're to the full extremity. There's nowhere else to go. They're 10 feet, I think, setback from the edge of property or property line. And it just, I think that we're going to have to look at this a little bit further at some time in the future. But it just wasn't here in that kind of heightened volume for this neighborhood at this time.
Yes, and taking into consideration the voluminous emails and negative feelings from the neighborhood, then I think the board is making the right decision.
I would have liked to see that same design at 85 feet.
All right. So hopefully the developer will go back and look at some other alternatives, maybe reducing the amount of units. I don't know. I can't speak to the economics of the deal and what makes sense. But anyway, what we've submitted to the city commission will stand as of today, and we'll see what happens on that end. So
if I can add, I would encourage a developer to talk with the university about trying to buy the site so they have the ability to redevelop the whole site and come forward with a real plan versus trying to redevelop the only remaining parcels on the site. I think that's what, to me, from a planning perspective, seems very challenging.
Yeah, I just want to commend the design team. I thought it was really creative, trying to really pull the massing back away from the existing building there, and it was just very creative. I thought that it was a decently designed or a great design building. It just, like to your point, Daniel, it's just not fitting on that site in that way. So we'll see what they come back with. So let's move on to the next item.
How many more items are there?
Three.
And just, Mr. Chair, at 5, I got to jump on a call. I can still be part of the meeting. I'll just be absent for about 15 to 30 minutes if this meeting goes beyond 5.
All right, let's see what we can do. So let's take up Planning Board File 20-0384. This is a regulation to permit neighborhood impact establishments as a conditional use. We're scheduled for 11:45 a.m.
All right, so hopefully this one will be a little bit quicker. So this is a proposal for an amendment to section 142-693, which is related to the performance standards districts. It specifically affects the RPS 4 district, which is the highest intensity of the residential performance standard districts. They're generally located, the RPS 4 districts are generally located on beachfront properties south of 5th Street. And the proposal allows for neighborhood impact establishments, NIEs, as an accessory use to oceanfront apartment buildings that have more than 300 units and are adjacent to a park. And the NIE would require conditional use approval from the planning board. So anything that's approved under this ordinance would have to come back to this board. It requires that the NIE be located in a separate building from the main building and that building be a minimum of 8,000 square feet. It also places restrictions on any potential NIE. It requires that there be a maximum occupant load of no more than 250 individuals located on any open level above the ground floor. Any open level above the ground floor must close by 8 p.m. Outdoor music and television sets, whether amplified or non-amplified, are prohibited in any open level above the ground floor. Outdoor bar counters are prohibited and special events are prohibited.
Could you please?
Sorry?
Could you define or could you explain why you're using the terminology open level, a level above the ground floor, just so everyone knows? This is the Chibo site in my neighborhood. Rooftop. I mean, are we why are we saying it? Why are we not saying rooftop?
Because I think there's some open areas on the second floor. I think there's a balcony in the building, if I'm not mistaken, and so that it would be applicable to that area as well.
Yeah, I can't think. Okay, so you're.
If there happens to be anything that's not a rooftop that's open, it would apply to that.
Okay, all right. So you're trying to cast a wider net and make sure to include anything above the first floor that is not indoors. Is that right?
Correct. That's exactly the point.
Okay, thank you.
Yeah. So anything that's above the ground floor must close by 8. That's open above the ground floor must close by 8 p.m. And as I said, outdoor music and television sets are prohibited in the open areas above the ground floor. Alcoholic beverages, even though the outdoor bar counters are prohibited, you are allowed to have an alcoholic beverage in the outdoor areas. You're allowed to possess them and drink them. You just can't purchase them outdoors. Any open area above the ground floor can only be open while the restaurant is open and serving full meals. So you can't have that functioning if the restaurant's not functioning. On the ground floor, outdoor areas are allowed to function until 12 a.m. until midnight. And also outdoor bar counters are prohibited as well. The interior areas would be required to close by 2 a.m. So this ordinance was prepared on behalf of Ochi, which is a dart club from Norway, and they're looking at leasing the site where Chibo was previously located on South Point Drive and Ocean Drive. Because of the size of the space, their occupant content would exceed 300 persons, and therefore it qualifies as an NIE. So in order for the site to be leased, if this ordinance is not adopted, it would have to be split into 2 separate establishments. And NIEs are generally prohibited in the RPS 4 district. So that's why this ordinance would allow that entire space to be leased as one single establishment.
So Rogelio, am I correct also that because this is a zoning ordinance, if I think they pronounce it Aki, but I could be wrong. If Aki is gone after 2 or 3 years, anybody else who leases a space would be subject to the same ordinance that we're considering today.
That's the case. There is a possibility that an establishment, based on the way they lay out their furniture and other requirements of the fire code, that their occupant content could be reduced below 300 persons depending on the layout of the place. So the occupant content is very much dependent on the layout of furniture that's determined by the fire marshal. So that could be brought down depending on what they do indoors. And then potentially they wouldn't have to comply with these restrictions. But generally that's going to be the case.
Okay. So, but they would have to submit to a CUP approval process regardless, a subsequent applicant or no? Just depending on...
It depends on the occupant content. So if somehow...
300 is the trigger there.
Right, exactly. So if somehow, based on how they organize their furniture, that occupant content gets reduced to 290, then they can open up by right. And they wouldn't need to go through the conditional use process.
Yeah, and then we got to talk about that because the by right on the rooftop is 5 a.m.
Yeah, well, there is the prohibition in South of Fifth for entertainment continues to apply. So this does not modify that. They're not allowed to have entertainment, even if people are out on the rooftop.
Okay, even though this is, because the last time when Chibo came through, it was grandfathered at 5 a.m. They agreed to something less than that, but that's what they had the right to do.
Correct, and so they would have that this prohibition would apply.
Is that 2 a.m. then?
Yep.
Okay.
I just want to comment.
I just thought we'd clear out some stuff right away. So.
Yeah. So we recommend that you transmit the proposal to the City Commission with a favorable recommendation. So, yep.
I just want to comment how great it is that you're codifying what we would normally look at a CUP process individually. I think this is a really good template to look at citywide of what we can codify and what should be left for CUP discussion. I rarely have CUP requests coming from south of 5th Street. I don't know if that's a result of the banning of entertainment or that, but nonetheless, this consistent codification of hours and open beer counters and outdoor spaces and all of this is a really good way to create consistency in what we would normally look at on an application pace by pace for a CUP.
Yeah, it's buttoned up pretty tight, really. I think on the Firestone application, it reminds me of the Firestone application on Alton Road that we saw last month. And the only thing that I'm thinking is Daniel's suggestion on Firestone was, what was it, a dance floor? No dance floor?
That was it, but they were allowed entertainment. We were approving entertainment. Here, they're not allowed entertainment, but I, by all means, am happy to include these types of things to encourage business owners to know as of right, these are the rules. Don't expect changes to them.
Yeah, this applicant has no interest, I think, in the way they're planning to operate, but I would like to ask the board to consider that. So
I think we can discuss dance halls, as far as in this ordinance, should we remove the ability as of right for anyone to have a dance hall? I think that's what we should consider.
We can add that as one of the conditions in subsection 4 of the ordinance, that dance halls shall be prohibited.
Are there any existing dance halls in this district today?
Not that I'm aware of. Not in the RPS 4. Entertainment is prohibited. Let me check if dance halls are part of that prohibition.
They are.
They are.
Dance halls. Yeah, they're
Yeah.
considered entertainment, and they're prohibited.
I was thinking about a dance floor,
that would be prohibited as well.
Okay, all right. It's tight.
You can throw darts.
It kind of, when I looked at their website, it reminds me a little bit of, I don't know if anybody's ever been to Dave and Buster's, but, you kind of sit at a booth, or you sit and you have a meal, and then you go, play a game, in this case, throw darts. You can stand and drink a beer, but it's pretty low key. So,
yeah. And you will have the opportunity to review it again when it comes in for the CUP, and put additional conditions if any are necessary.
Well, I like the rooftop or the outdoor rooftop, closing up at 8 p.m. I think that's very super neighborhood friendly. So
I see.
Mr. Chair, I know that Michael Larkin, who represents the one of the proposers for this, would like to address the planning board.
Sure, that's fine. Michael, you want to go ahead?
And Michael, I believe Michael, you're still under oath, to the extent that you're presenting evidence.
Michael, you still willing to talk to us? You still willing to interact with us?
Oh, I think, has he been moved over? Let's see.
Michael. He's unmuted now.
Can you hear me now?
Yep.
Great. All right. Yes, I'm still on good talking terms with all of you. Thank you. Challenging hearing. This one's a little bit easier. So we represent Aki. It's an innovative restaurant concept that originated in Oslo, Norway. It's spreading throughout Europe, and this is the first location in the States. We really realized from the very beginning that the South of Fifth neighborhood is a great neighborhood. It's also complicated in terms of neighbor outreach. So from the very beginning, we reached out to Continuum and to Portofino and to South Point, and we obtained their support. We also reached out to Frank Del Vecchio, and we have his blessing as well. We're going to SOFNA in September in the Council of Presidents, but there's a voluminous amount of restrictions in here, and that was due in no small part to Frank's guidance. And so they're all in there, and that's why we're able to obtain the neighbor support. So, but I'm here to answer any questions you all might have. With regard to dancing, I think that Tom answered correctly that dance halls are prohibited south of Fifth as much as entertainment establishments are. But
How do you throw darts in between dancers?
That might have to be a new prohibition. So, but I'm here to answer any questions you all might have.
I like it. I think it's buttoned up real tight.
Mr. Chair, do you want to open to the public?
Yeah, so I don't see any, let me see. I don't see anybody from the public with their hand raised on the item. Okay, we have Mr. Marks. Go ahead.
Mr. Marks, do you swear under oath that any and all testimony that you'll give in this proceeding is the truth, the whole truth, nothing but the truth?
Sure, I always speak the truth, power.
Okay, you have 2 minutes.
All right, I'm the Continuum on South Beach Master President, and therefore we are the controlling association over this particular property. We do not own it, but it complies with our rules and regulations. I just want to say that, and I'm speaking not only for myself, but the other contiguous neighbors of ours in South Point and in Portofino, that we were approached by Michael, and very nicely, and Ochi's methodology, what they're proposing, fits our neighborhood, fits our regulations on entertainment and outdoor entertainment in particular. I know we have a restriction against rooftop, but unlike Chibo, which was always a battle and became a battle at the end when they were having financial difficulty before they left, we're very happy with this agreement. Again, unlike Chibo, which required us to fight for about 6 months in city meetings, this was done wonderfully. We also told the land use that we were supportive. So I just want you to know that it has got full community and association support. Thank you.
Thank you, Mr. Marks. Seeing no other members from the public wishing to speak on the item, I'm going to close the public time to comment and throw it back to the board.
I'm happy to make a motion to recommend with a favorable recommendation.
Second.
Moved and seconded. Michael?
Okay, Mr. Batia?
Yes.
Mr. Milan?
So I'm going to have a conditional yes that as long as we get a darts tournament between the planning board members and the staff. I used to be a pretty good darts player in my day.
Oh my gosh, that sounds like a plan.
The gauntlet is thrown to the
Very
staff.
good, very
The
good.
gauntlet is thrown.
Mr. Weider?
Yes.
Mr. Barrow?
Yes.
Mr. Pietro?
Yes.
Mr. Brantley? Sorry, Mr. Brantley, I think you're on mute.
Yes.
Motion passes 6-0.
All right. Next, let's take up Planning Board Item 20-0386, simplification of single-family regulations and DRB administrative review procedures.
So we do have a presentation. I know the time is late. With the board, does the board feel they need the presentation or just the introduction?
Well, the presentation is fairly short and we can go through it quickly. There's some good visuals that might be helpful. The visuals were attached to your memo, so we'll leave it up to you.
Okay, I'll go through my introduction. I'll go through the introduction, and Stephen Williams is online. He will go over the presentation. So just for some background, a form of this ordinance was actually reviewed by the planning board last September, and the board recommended unanimously in favor of the ordinance. When the city commission took up the ordinance for first reading the following month, there was a concern that there would be new commission members that had not seen the ordinance previously. So the commission at that time referred the ordinance back to what was at the time called the Land Use and Development Committee, which has since become the Land Use and Sustainability Committee. Since that time, staff prepared graphics for the more complicated changes and made some further tweaks and refinements to the ordinance. Included in these changes are the recommendations made by the planning board in September of last year, most notably continuing to allow the extension of a non-conforming side setback for a single-family home for a distance of up to 20 feet. These changes were reviewed by the Land Use and Sustainability Committee on July 21st of 2020 with a recommendation to refer the ordinance to the planning board. The city commission referred the ordinance to the board on July 29th. The current requirements or proposed modifications, the current requirements and proposed modifications are listed in chart form as Exhibit A, included in the online package and the staff report. The chart also includes the corresponding reference numbers for Exhibit B, which is a set of graphics that were prepared to visually depict the changes. And Stephen Williams will go over the presentation that also has those graphics. Then we can answer any questions. And Stephen, are you here?
Yes.
And PJ, can we bring up the presentation?
Okay, can we go to the next slide? Okay, so for the ordinance unit size, we are actually not changing the unit size requirement, but we are changing the way that we're calculating it. So currently the code counts unit size. It includes exterior portions of the home. The proposed modification would only include enclosed areas. Next slide. Second floor requirement. The existing ordinance further regulates the second floor of homes that have a lot coverage in excess of 25% of the lot size. The proposed ordinance would continue to regulate the second floor. However, it would require additional setbacks for the second floor instead of limiting the square footage. We found that the way the code is currently written, the intent was to regulate the mass, but the square footage could be pushed towards the front of the home and still have the same perception. So by requiring an additional setback, we are reducing the appearance of the mass of the second floor. Next slide. So again, this would be required for homes that are over 25% lot coverage, and the code currently does allow a provision for the DRB to waive this requirement. So this would continue as well under the new ordinance. Next. The new ordinance is proposing that understory homes, which currently has 2 tiers of regulations, would all be approved administratively. But we would be codifying the additional regulations that are required for homes that go to the design review board. So currently, as the current draft is written, the ordinance would apply the stricter requirements to all understory homes, but would allow them to be reviewed administratively without DRB approval. Next slide. Lot coverage is being simplified to only include roofed areas and courtyards, which are enclosed by 4 or more sides. Roofed overhangs and eyebrows with a projection of 5 feet or less would not be counted. So this is a change from the way the code is currently written, where any courtyard, regardless of if it's roofed or not, that is enclosed by 3 sides, does count as lot coverage. Next slide. So homes that exceed a interior side yard elevation for 2 stories of a certain amount have to incorporate an additional setback area in the side yard. Currently, the code limits that area as to what can happen there. So we are proposing that the space to be used for other things such as mechanical equipment. Next slide. Additionally, the new ordinance would allow the space to be elevated to the finished floor of to the lowest finished floor of the home to allow it to be more usable. Next slide. Additionally, the proposed ordinance would reduce lot coverage for single-story homes from 50% to 40%, change the trigger for a 10-foot minimum interior side yard setback for properties with a 60-foot width to 65 feet, limit the continuance of a non-conforming interior side yard setback to 20 linear foot extension. It would eliminate the unit size limitations of an accessory structure. However, they would still be limited to 25% of the required rear yard, and the setbacks, clarify the setback requirements for accessory structures. That concludes the presentation.
Thank you, Stephen. Oh, Nick, welcome back.
I had to go get him. I told him we needed him. We have some important discussion coming up. We have Daniel, our resident expert as well, and we need both of them.
Yeah, I'm sure Nick can attest to the challenges that exist in our current single family regulations.
And a test. Don't make me do it.
Do we want to take public comment first?
I don't have any, hang on. I don't have anybody waiting with their hand raised. So if anybody from the public wants to speak on the item, please raise your hand. So we have Mr. Matt Amster. Go ahead.
Good afternoon. This is Matt Amster of the firm Burkow, Riddell, Fernandez, and Larkin. Our firm regularly handles a large number of single-family home applications, mostly going to the DRB. And I just wanted to get some clarification regarding the implementation of these new regulations, specifically the zoning in progress, the exception portion of this ordinance uses today's date when the planning board acts as implementing this. And typically that is the case when regulations are more restrictive than the current code as it travels through up to commission. But this ordinance seems to be a mix of some stricter regulations, but also some relaxation. So just trying to give guidance to other homes that are about to have pre-application meetings as well as submit to for the DRB application process. Thank you.
I can address that if you'd like, Mr. Chair. Matt's correct. There are some parts of this legislation that are actually easing the restrictions and some that become more restrictive. We have suggested an applicability section, which the Land Use Committee was okay with. And this will be going to the City Commission for first reading, assuming you guys transmit it today on September 16th. So what we had recommended was that in the applicability section, I believe that we recommended that anybody who had a building permit process number as of the date of the planning board transmittal, which is today. Is that correct?
Correct, yes,
Michael?
correct, yes.
So if you already have a building permit process number, the more restrictive parts of the code won't apply to you. But once the ordinance is adopted, potentially in October, if you wanted to amend your plans to take advantage of those portions that ease the restrictions, you would be able to do that.
And we also have for applicants who submitted or filed an application to a land use board on or before today, could take advantage or comply with the current code.
Do they also have to comply to the more restrictive parts?
No, if there's an application on file for, say, design review board, they can follow the code as it exists now.
Okay, so they can take advantage of the change that favors them, but not the other part. It will not be applied to them.
A lot of them are very integral. So, for example, if we could do a recalculation of lot coverage. You can't pick and choose, from the ordinance what you want to include. Either go with the old ordinance with lot coverage counts, or go with a new ordinance as to what's defined for lot coverage. So as long as we're consistent with either the new ordinance or old ordinance, then that would apply.
So, Michael, from the standpoint of somebody who's already contemplating, already in line in the process, they're not disadvantaged by the ordinance, is what we're
right.
talking.
Correct. And if they decide that there actually are some benefits to this ordinance, and we actually had an application before the design review board that was asking for variances for lot coverage last month or 2 months ago. And we let them know that if this ordinance were to be adopted, they could take advantage of it and not count the courtyard as part of their lot coverage.
Do we have any more unreadiness on it or questions?
So,
looks like, go ahead, Nick.
Sorry, I just tuned in. So are we like on page 3 where we're looking at these 4 categories, these 4 separate categories?
Yeah, we're looking at where there's a presentation on exhibit. There was exhibit A, B. There was some diagrams with the interior side yard with some linear foot percentages that change when you have second floor story single family homes, etc. I don't know if is that the one you're looking at?
No, on the digital agenda, there's just a link to the staff report. I don't see exhibits there, actually. Sorry.
So item 8 has the staff report, exhibit A and B, the ordinance, and the presentation that Stephen just provided.
Item 8. I see. Okay, I was on item 10. I apologize.
Yeah, we're not at the FAR yet.
I'd love to see this. I'm sorry. I just finished a class.
No, I'd like you to look at it. I mean, that's what I was saying, having you here, especially given, your own home and experiences with these types of items.
This is great. Okay.
Like I said, a lot of this is consistent with what the board looked at last year. We did make some simplifications, especially for lot coverage. Previously, what the board looked at last year, we said that you're allowed a 3-foot overhang. And if your overhang is more than 3 feet, the entire portion of it counts as lot coverage. And now we're saying, okay, we're giving allowance for a 5-foot overhang with no penalty. As an overhang surrounding the building for lot coverage, it doesn't count. But any portion beyond 5 feet now counts for lot coverage.
We also included the change that the planning board had recommended regarding linear extensions. Correct. You had made a really good recommendation on the floor. We included that when we sent it to the commission. Now it's just fully incorporated into the ordinance.
Is this ordinance designed to avoid having to send single-family homes to the DRB and allow staff to work with them at administrative level?
Not entirely, but it will have that impact in some instances. In our experience, given the fact that, most of the home replacements are pre-42 homes, that automatically sends you to DRB. And if you're looking for a height waiver or variance, that automatically sends you to DRB. What we think this will do more so than that is provide an expedited manner of review at the time of permitting. It will make it easier for architects and homeowners to understand when they're designing a home. And it will be much easier for the contractors to implement on site.
I know you guys have been doing really hard work over the last 10 years to try to modify the single family home regulations and try to codify. It is challenging, and, I'm not the architect expert, so I do welcome Nick's comments as far as understanding, is this going in the right direction that allows single family homeowners to work with staff at administrative level and just get approved what we think is a good design envelope.
One of the things we are recommending is, currently we have 2 paths for understory homes. One, which was like an ancient path, which was adopted, over 10 years ago, and a more recent set of requirements for understory homes that has a whole slew of items in terms of setbacks, pervious area, a whole host of requirements that are in the code right now. And right now, the code requires that all understory homes have to go to DRB. We believe that since the code is so prescriptive now, that we're recommending that those understory homes, which we see more and more people doing, as long as they're not demolishing a pre-42 home, aren't asking for variances or waivers, that review can be done administratively now. That's part of our recommendation.
Yeah, I would encourage that, and that would also encourage a homeowner not to seek waivers, design waivers, or that 3 additional foot, and avoid having to go to land use board just to build a single family home. So I certainly support going in that direction.
How does that affect the size of the home that's put on the lot? There's percentages that they have to follow, correct?
Yeah, we still have the same maximum lot coverage and unit size as before. We're just doing a different calculation for how we get to that number. Just for example, right now, the code is a little bit obtuse in that it requires that if you have a covered terrace more than 10 feet, you count as unit size the portion of your terrace that's over 10 feet. So we're taking that out and regulating it more with lot coverage, which is the 30% lot coverage. So, which is really the bird's eye view from above. So if you have an allowance for projections, overhangs of 5 feet, once you go beyond 5 feet, the portion beyond 5 feet counts in your lot coverage. So it's a really integral, like, building blocks of push and pull.
Isn't there an additional level of protection for bad design by requiring them to go to the design review board?
Well, there is. It's not. It's there. Staff, planning staff, in reviewing. Well, plus planning staff in reviewing applications, we do apply the design review guidelines. And if something is really onerous, if someone doesn't agree with our recommendation, they can take that to the design review board, in the most extreme circumstances. But we feel right now, especially for understory homes, the requirements are so strict, almost like what Daniel's talking about, for planning board CUPs, putting it in the code, so that people are aware of what the requirements are, and you don't have to have that reviewed by the planning board, in this case, the design review board, because those are all very, very prescriptive. And of course, if somebody doesn't want to provide that or wants the waiver from that, they can then choose to go to the design review board and ask for a variance or a waiver.
It's complex. Can I ask? I mean, maybe we could just look at a few of these in particular that I just have some questions about. If it's okay. Can we look at the lot coverage existing and proposed? That one to me seems great and very significant.
Yeah. So right now you can see where the code requires that if you have a courtyard, open to the sky, surrounded by 3 sides, there's a penalty. That whole area counts as lot coverage.
Yeah, that's the worst.
So that's one thing we're taking out.
Let me ask about this. However, it looks like you're able to discount the entire front, if I understand it correctly, the front courtyard. However, in the rear and the side, or in the rear, for instance, you need to count everything beyond 5 feet. Is that what it is?
Exactly. No, because the front overhang is only 5 feet. If there was there's a portion. If you look at the proposed,
but it's enclosed on 3 sides, correct?
But it's open to the sky. If it's open to the sky, it never. So under the proposal, if it's open to the sky, it doesn't count in lot coverage unless it's enclosed by 4 sides, like a donut hole. Pretty good, like a donut hole type house with a courtyard in the center, that would count in your lot coverage. But if you look at the proposed diagram, we have the existing, which shows the courtyard in the front that's open to the sky, with the exception of an overhang for an entrance and surrounding the courtyard. The same courtyard in the proposed, because there is a larger overhang at the front, that area is noted as 85 square feet. That's more than 5 feet in depth. So that portion beyond 5 feet would count in lot coverage. And at the rear, that whole area is covered. We note it as a 15-foot covered terrace. So the portion that's more than 5 feet from the building would count as lot coverage.
Oh, I see.
If somebody were to open up that or do a trellis, they could turn that into a trellis, and that also would not count as lot coverage. So it's only solid portions over 5 feet in projection would count as lot coverage.
Okay, yeah, that makes sense. I think that's a great adjustment to make. I mean, the planning principles of tropical modern houses was always these courtyard spaces that assisted in ventilation and, also allowed for a creative embrace of the landscape. So this helps. This helps a lot.
That's one of the reasons why in the next slide you see right now, currently there's a maximum courtyard size that you can provide along your side elevation. We're removing that maximum and allowing a greater depth.
5% of the lot area was the max.
Yes.
That's right. Yeah. And how about those side niches carved into the massing were required for a 2-story elevation longer than 75 feet? Is that what
that's still in place. Yes, that's still in place.
But okay, and so those voids had a maximum of 5%, correct?
Exactly.
And let me ask one more question. Sorry, Michael. That 5%, that max open space requirement, that's per courtyard. So if you had like one on each side, each could be up to 5%, correct?
I think it's in total. I think it's in total for the site.
Okay. But if there is now no maximum, then it won't matter, correct?
Right.
That's great. Okay.
We're also allowing, right now the code says you have to leave that courtyard at your side yard elevation. So it results in an unusable area for elevating the house. You have 4 or 5 feet of steps down to your courtyard, which is really awkward. So it really allows more usability space without impacting the neighbors. And then one last thing that's very important in terms of the setback. The code right now says if your lot is over 60 feet in width, your setback has to be 10 feet. We have a lot of angled lots. So technically we take your lot width at the 20-foot setback, and we have lots that may have a technical lot width of 61, 62 feet, 63 feet. And because of that minor tapering of their lot, they have to provide a 10-foot setback versus a 7.5-foot setback. Our proposal changes that 10-foot requirement to properties that have a lot width over 65 feet. So I think it's much more understandable and easier to design a house on a small lot with a 7.5-foot setback versus a 10 feet on, say, a 60-foot wide lot.
Yeah.
And a lot of these too are a result of, hundreds of applications before DRB and our practice in reviewing building permit applications and just seeing the level of time and questions involved in addressing concerns and questions from architects and homeowners and applicants. It's really, the code has become so, we keep adding and adding on to it. We needed like a wholesale look at the single family to sort of simplify some things. And that's why you can't just, cut one area without modifying something. It's really like an integral building block. And so it's the lot coverage and unit size are tied together.
Could you talk about the modifications to the accessory structures in the rear yard?
Yes, let me just pull it up. Hold on.
Is that in the staff report?
It's in the ordinance. Let me just a second.
We don't have Ralph Choish here supporting these. Where is Ralph?
I think we have it in the chart. Stephen, are you on the line? The chart, exhibit.
Yes, the last item in the chart is the accessory structures in the rear yard.
In the
Exhibit A, correct?
Blue and white matrix chart.
Exhibit A?
Yes.
Okay, so right now we have very strict requirements for accessory structures in the rear yard. We're keeping the lot coverage requirement at 25%. Currently, the size is limited to 10% of the size of the main house. The second floor cannot exceed 50% of the first floor. However, we see lots of single story accessory structures that may be more than 10 or 12 feet in height. So they're 13, 14 feet in height. So rather than say the second floor cannot be more than a percentage of the first floor. We're saying if your structure is this high, this is your setback. So as proposed, structure is 12 feet high or less, requires a 7.5-foot interior setback for side and rear. And if it's facing the water, your required rear setback is 50% of your main home. And if any portion of your structure is above 12 feet, then the entire interior side setback is going to be at least 10 feet, or the required side yard setback, and the rear setback will be 15 feet. Except when facing the water, it'll be the greater of half the required setback, or 15 feet. So it's really going to be easier to calculate based upon the height of the structure. The height of the structure, higher structure gives you a greater required setback from both the side and the rear, and more so when facing the water.
The single story, or let's say 12 feet or less to be single story, remains a 7.5-foot setback, which is what it currently is, correct?
Correct, yes.
And then if it goes beyond 12,
the entire structure. We had people applying for variance because they had portion of the structure was above 12 feet. So it's really complicated, calculations and variances. So I think to simplify it based upon the height of your structure, this is your setback. It makes it much easier and understandable, to regulate and to design for. And also with the greater height and greater setbacks, that mitigates any impact from neighboring properties. You may remember that before maybe 10 years ago, the code allowed accessory structures up to the maximum height at a 7.5-foot setback from both the side and rear, even on the waterfront. So that's why you will see driving around, or in a boat, some large accessory structures on the waterfront with such a minimal setback. And then also in the end, your overall lot coverage and unit size are regulated by the maximum unit size of 50% and maximum lot coverage of 30%, for a 2-story home. So that's all factored in versus having a limitation of your accessory structure can only be a certain percentage of your main structure. We have lots of properties where we have older homes and they're sort of penalized because they want to add an addition as an accessory structure, and it may be more than 10% of the main house. So they've had to apply for variances. So this looks at the regulations more holistically.
So you've eliminated the maximum size requirement, correct?
Yes, because it's going to be regulated based upon the 25% of your rear yard plus the overall lot coverage and unit size for your lot.
So I guess
really the biggest limiting factor is the 25% lot coverage.
And for it to qualify as an accessory structure, it just needs to be detached and separated by 5 feet?
Correct.
Is that correct? Similar to
and located in the rear yard.
The rear yard, yeah.
Michael?
Yes.
The rear yard is also limited by the requirement for open space. So the size of the structure will be further limited based on if there's a pool in the rear yard, if there is a pool deck, it's going to limit the available space to build the structure.
Yeah, because the code requires that 70% of your rear yard is, landscaping, but a pool, provided it's under a certain height, counts as that
50%
percentage.
Yeah. I think these look good. Was there any consideration given to the exemption of the garage, which needed to be detached?
Yes, I think that is in there now. That's a good point. I think that is in our ordinance.
Because that is a tough, nobody wants to count the garage, but then separating it, not being able to connect it with the roof, you're walking through the rain.
That is included in the ordinance.
Which, is that in one of these charts, maybe, Stephen?
Yes, it's the third item.
Exhibit A.
1-story portions of 2-story structures may be located at a 20-foot setback if the second story portion of the structure is set back a minimum distance of 40 feet. So we're incorporating the requirements that the 2-story portion be set back further, but the 1-story garage can be attached.
Oh, now sorry, where is it? I don't see it.
On the chart, it's the third item. It says front
Exhibit A?
setbacks.
Talking about Exhibit A?
Correct.
It says unit size is the third item on the Exhibit A. Is that what you're talking about?
I'm sorry, third item, second page.
Under front setbacks.
Yeah, second page, sorry.
Yeah, effectively that will allow a garage placed at a 20-foot setback, then a 20-foot depth of a garage, and then the 2-story home, the 2-story portion of the home to be constructed.
Oh, that's great. Yeah.
That's an addition that we did compared to what the board looked at last September.
Yeah, that's smart. That's great. And I also remember us discussing, Tom, something about if you were to extend an existing non-conforming structure, we put a limitation on the amount.
Correct. Yeah, we did that so that you could do like your 1-bedroom, kitchen, bathroom addition.
What did that end up being now? I'm sorry, I'm late.
20 feet for a linear extension.
That's on Exhibit A, second to last item.
Is that And then the last thing, I just remember, I did a small addition to a non-conforming 1962 house. And I think it's a 1-story home. I know there had been some discussion. I don't remember where we ended it, but we were discussing about not allowing 50% lot coverage on 1-story homes anymore. But we took that out, I believe. Can you remind me?
We modified that as well.
I see it here. Lot coverage single-story homes. Okay, great. I still will just say I have a slight problem with that, just because we're eliminating. Everybody maxes out their unit size, and not having the ability to add more square footage. I don't think anyone's going to build a 1-story home anymore if they can't add the amount of bedrooms that they would otherwise be available to add. Let me ask this. Are you able to build a 40% lot coverage single-story home and then add a second story to it 5 years later?
We have to get a variance.
If you can establish a hardship, you could apply for a variance, but that's a pretty significant level. We wouldn't want people gaming that. They build a home at 40%, then 2 years later they come in and say, you know what, I'm going to add a second floor to it. There has to be a good rationale for it.
Yeah. If it were a non-historic home, yeah.
And we have seen that. We have seen cases where we have a home that's single story now, maybe 35%, 40% lot coverage, and they want to do a small second floor addition. There is a process to go through. They can request a variance, and that can be evaluated and reviewed. So, none of the items here, I think, would prohibit or could address all conditions and issues. So we're trying to, take away the reason for asking for variances for most applications, but there may be some where it is warranted still.
And just to remind me why are we trying to squeeze these 1-story homes? Is it just, I actually, it's coming back to me a little bit. I think it would be great if we could still allow 50% coverage, but you needed to offset that by providing additional permeability. But wasn't it a permeability issue?
It was a combination, Nick, of both permeability but I think more importantly, the fact that these single-story homes now have to be raised to a significantly higher elevation, as do 2-story homes. And when the 50% maximum unit size was developed for single-story homes, the intent at that time was to give people more of an incentive to do shorter homes. But now that homes have to be elevated so high, you're not just elevating them significantly higher, you're covering up a significantly larger part of the lot. And so that's why we're seeing mostly two-story homes anyway, but we didn't want one-story homes at that type of an elevation and at 18 feet in height to take up that much of the land.
Because of, I mean, they still would be lower in terms of massing. I guess you just worry. I mean, it seems primarily.
They'd be slightly lower in terms of massing, because if you max one out at 18 feet and you put the first floor 3 to 4 feet above base flood,
right.
You're potentially almost at the same height as a two-story home that's a BFE plus one.
Yeah.
Also, most people that are doing most people that are looking for more than 40% unit size, they're doing two-story homes anyway.
Yeah, I agree. I mean, I wonder why we don't just say, you know, a majority are going to be two-story homes. I mean, look, as an architect, you know, the zoning is so tight in these beach homes that the massing is very similar. And so, you know, the prospect of a unique one-story home excites me. I mean, do you think it's significant of an issue, enough of an issue that, you know, it's going to be a problem if we were to leave it at 50%?
It's not something that we would recommend, simply because it's just going to be that much more lot coverage. I think that, you know, we even toyed with the idea of just limiting lot coverage to 30%, even if you did a one-story. But we said that's probably a little far reaching. If you really are a one-story home, you can have a little bit more. But, you know, 40% lot coverage that's significant. That's a significant part of a lot that you're basically paving over. 50% we just thought was way too high.
I just think maybe for, you know, elderly people, I don't know if they're building new homes primarily, but to avoid lifts and stairs and things like that. But, you know, I'm open to it. You know, I think these are well considered and appreciate the work you guys have done and put into this. I do think it simplifies things significantly. I just know my single family home built in 1962, it's at about 45% lot coverage right now. And we wouldn't even allow that, Tom, through like a variance or?
Yeah, you could get a variance.
Oh, you could still get a variance to do 50%?
Yeah.
But not for a new home, correct?
You could apply, but it's harder.
You could apply. It's more difficult.
For the hardship, right? Yeah. Okay. I don't know if anyone else has any comments or thoughts about that, but that's the only one to me that sticks.
Is anybody else there?
I'm here. I'm listening.
Okay, thanks. Sorry about that. I had to take a call, guys. I'm here.
I'm here.
So if there's no more comments, we can, or if there's no more questions.
Are you settled with that single family lot coverage issue, or you want to make an amendment there? You want to make a proposal?
Does anyone else on the board have any?
No, I think what I understood you to say is that if somebody wants, like your home is a single family home, and somebody wants to keep a single family home, in your case, you would not. If you wanted to expand the square footage, you would not be able to do that because you're already over the limit. Is that what I heard?
No. In my case, my home is built in 1962, so it's pre-1965. Okay. So I could still apply for a variance to expand it. My only issue, Tom, is that at a certain point, you extend and expand a historic home. It almost becomes a new house. And again, I appreciate the intent here. I think there's a value in single family homes, and
well, one of the things that you might want to consider is, rather than recommending that it be expanded to 45% or 50%, maybe what you do is you create a waiver provision where the design review board could allow up to 45% or 50%. That way you don't have to go through the lengthy hardship criteria and establish that, which is much more difficult.
It's impossible
from a
to
design
prove,
standpoint. If you can show that you're addressing permeability and everything else,
yeah,
they can let you go up to 45% or 50%.
I would be really happy with that if we still had some avenue for that. Yeah,
because there would
Yes,
be
we can include
reasons why someone would want a single family versus a single story versus a two-story home, right?
I mean, I do agree. I think a majority are building two-story homes in the beach. But I enjoy.
Would you recommend with the DRB waiver? Would you recommend up to 45% or up to 50%?
I would like to keep it at 50, just so that there's an equitable investment in terms of the square footage you could resell it for. I just worry that when people are reselling these things per square foot, if you've got less footage and no ability to expand it, it's going to be worth less of an investment. So I would like to see those things kept the same, whether people take advantage of it or not. But at least some avenue through DRB, a waiver process would be great.
Okay, so what your recommendation would be that for one-story homes, the maximum unit size lot coverage would be 40%. However, the DRB could allow up to 50%.
Yes. Yeah, that would be great. Thank you, guys. Yeah.
Is that
Anything else?
Yeah, is that a motion to recommend in favor of the ordinance with a modification?
I would make that motion, yes.
So we're just making the one modification to the lot coverage single-story homes. Is that correct?
No, I think
they get a waiver, apply for a waiver.
Just giving an opportunity for a waiver through DRB.
Right, but that's the only item that we're modifying on.
Right.
Okay.
Right, but I think Nick's motion is to send the ordinance with that modification to the City Commission with a favorable recommendation.
Yes.
Mark seconded.
I'll second it.
It's been moved and seconded.
Okay, Mr. Vitia?
He's out.
Approved.
Oh, there he is.
Okay, thank you. Mr. Milan?
Yes.
Mr. Weeder?
Yes.
Mr. Jelpi?
Yes.
Mr. Barano?
Yes.
Mr. Pietro?
Yes.
And Mr. Brantley?
Yes.
So the motion passes 7-0.
All right. Let's take our almost home. Planning Board item 20-0387, West Avenue overlay, Suite Hotel prohibition.
Okay, and this is item number Planning Board 20-0387, West Avenue Suite Hotel prohibition. So this ordinance applies to the West Avenue Overlay District, which was initially created in 2002. A map of the area is provided in the staff report with the darker shading denoting the RM2 zoning and a lighter shading denoting the RM1 zoning. The primary reason for the creation of the overlay was to preserve the character and quality of the neighborhoods fronting West Avenue, which was being impacted by infill development that did not reflect the cohesive low-scale character of the area. The subject overlay, by expanding the list of permitted uses for existing low-scale buildings in the neighborhood to include, at the time, suite hotels and bed and breakfast inns, created incentives to retain and adaptively reuse the existing single-family and or multifamily buildings that were no more than 3 stories in height. Then in 2013, the City Commission prohibited hotel uses in the RM2 and RM3 zoning districts where it was previously allowed. Elsewhere in the city, hotels are a main permitted use in the RM2 and RM3 zoning districts, except for this West Avenue neighborhood and the Palm Avenue neighborhood. Currently, suite hotel, office, and bed and breakfast and may be introduced as part of the renovation of existing structures in the overlay district. Under the proposed changes to the ordinance, suite hotels would no longer be allowed, but office and bed and breakfast would continue to be permitted. Now, a suite hotel is typically larger than a hotel room and contains a full kitchen, but is rented out on a daily, weekly, or monthly basis. Suite hotel units must also, or properties must also contain a registration desk and lobby. We did note in our report that removing suite hotels from the list of incentives for the adaptive reuse of existing low-scale buildings in the neighborhood could result in more demolition of such structures and the replacement with larger buildings up to the maximum FAR allowed in the underlying zoning district. However, we are supportive of the ordinance as it addresses concerns that have been expressed over the years from area residents regarding transient uses in the neighborhood, and we are recommending that the planning board transmit this ordinance to the city commission with a positive recommendation.
This is addressed at Airbnb hotels, correct? Or
no, this is to, well, if somebody could operate a suite hotel basically as an Airbnb, this would prohibit suite hotels. Hotels are already prohibited in the area. This would add to that prohibition suite hotels. Suite hotels were included as an allowable use when the overlay district was created as an incentive to adaptively reuse existing buildings. The concern over hotel use and now even suite hotels is the reason for this ordinance, which would remove the allowable use for a suite hotel in the district.
The original and the rationale for that is?
Yeah, let me add to that question because the original intent was to approve hotels, but not suite hotels, and to add to David's question.
Well, originally, hotels were allowed in the RM2 and RM3 when the West Avenue Overlay District was created. It added suite hotels, bed and breakfast, offices as incentives. Later on, because of the concern from residents, hotels were removed from those zoning districts, but because the West Avenue Overlay District allowed suite hotels, there still was a provision for somebody could come in and adaptively reuse an existing building, not for new construction, but for existing buildings, turn them into suite hotels.
Why was that thought to be safer than a regular hotel or a hotel?
No, those at the time the suite hotels were created, hotels were also allowed. It's when the prohibition on hotels was created. I think at the time a lot of people didn't think about the allowance of suite hotels that was allowed in the West Avenue Overlay District.
Mike, I think the rationale also had to do with the fact that a suite hotel is a much bigger hotel unit that requires a kitchen. So you have to have a full kitchen, and it's basically the same size as an apartment unit. So I think the rationale was those were a little bit more consistent with the fabric of the area because they had bigger units and they had full kitchens. And it wasn't like the smaller hotels that you see in more intense commercial districts.
And perhaps with the advent of Airbnb, they are more problematic. Is that what I'm also hearing?
Well, I think that the West Avenue folks who lobbied for this have a concern with the number of suite hotels that are being converted, number of older buildings that are being converted. Part of that, I think, has to do with the fact that these older buildings, a suite hotel use obviously is going to have a much more significant economic benefit than a residential apartment use, and in terms of income. And so the rationale behind leaving the suite hotels in the overlay was to provide an incentive for the retention of these older buildings. But I think what the residents in the area are concerned with is the number of transient uses in relation to permanent residential uses.
But isn't this basically a street that's behind Alton Road, and it's really kind of a commercial district to begin with?
Not really. It's predominantly residential. It's all residential zoning. It's all RM1 and RM2 zoning. So
I would agree with that. I think, David, it's mixed use like my neighborhood, but I think they consider themselves a residential neighborhood, you know, and they're constantly working to preserve and protect their quality of life.
Has the city encountered any litigation involving this issue on whether this type of regulation, which is kind of on the borderline, might cause more litigation and disruption based on that litigation? People come in and they sue the city because the city is unreasonably regulating their business. I mean, it's not an open and shut deal, is it?
Well, this would allow the continued operation. So if somebody already has a suite hotel in the district, they can continue to operate.
Right. That's right, Michael.
But no new ones.
Correct.
And the draft ordinance has an applicability provision that would need to be included in any commission adoption that would allow people who have obtained a building permit process number by today, on or before today, to continue with the conversion of the building to a suite hotel. So anybody that may have started the process already but didn't quite get a building permit yet or didn't get a DRB approval, they'd still be able to move forward.
Are there a great number of contributing buildings in that area?
The area is not historic, so they do not have a classification of contributing or non-contributing.
So if it were historic, would any of those buildings be contributing?
A number of them probably would meet the definition of contributing, the ones that are left. How many, it's hard to say, but there are some that certainly would.
Wouldn't the city want to be encouraging adaptive reuse of these buildings and rather than...
That's one of the things that we mentioned in the memo. We did make it clear that when you remove an incentive, you are potentially going to be re-incentivizing the replacement of those buildings with new buildings. Now, there's a couple of different ways that you could look at that, because most of the new infill construction that's being built is far more resilient because it's built higher and it's built in a more sustainable way. But with the development regulations that we have in place in the RM1 and RM2 districts, most of the new construction is very contextually compatible. So although an older building might be replaced, the newer construction is contextually compatible. So you balance it with that, and you balance it with whether or not it's appropriate to have all of these transient uses within an area that the people who live there on a permanent basis see as more of a permanent residential area. And you might hear that in some of the comments. I don't know if there's anybody who's raised their hand who wants to speak on this or not.
Yeah, actually, we have Carmen Bernard.
Or not.
Carmen, do you want to speak on the item? I think you have to press, what is it, *6? Okay, let's keep going.
Can you hear me? Yes.
There you go. Go ahead, Carmen.
Okay, give me a minute. Hello, I'm Carmen Bernard. I own a building on 1241 West Avenue. We own a small fourplex on West Avenue and 13th Street for 22 years. When I first bought this building, we paid just $4,000 in property taxes. Now it's $25,000. With mall improvements, we used to be able to rent to snowbirds, students, and families that came here for under 6 months, but then the city made that illegal and imposed $20,000 fines for landlords for simply renting their rental property. Now we are going through the very expensive process of converting our small building into a suite hotel just to be able to rent it under 6 months. But again, the city wants to intervene and discontinue this incentive. It is not the government's place to interfere with free enterprise. Your actions will essentially give a few prize properties that have already gone through this expensive process a more competitive advantage by eliminating and taking away that same right from others. This is un-American, and it hurts property owners like myself just trying to survive. We're not big shot developers. We're just two seniors in our late 70s and 80s, and you're taking away our retirement income that we have worked so hard for. I want you to understand that the actions you take today have devastating effects on people's lives and their livelihoods. If you will go ahead with revoking the previous incentives, quote unquote, granted to us, then you should at least let people who have already started the process, paid architects and applications, free to continue the process. It would not be fair for people like ourselves to change the rules after we started the process, and would absolutely consider legal action if you did. Please think really hard about how your decisions affect the everyday lives of senior citizens like ourselves. Thank you very much.
Thank you, Ms. Bernard. So, staff,
Tom, is she correct that she? I'm sorry to interrupt. Is she correct, Tom, that she's already in process? How will she be affected by this?
So, if she filed an application with the building department and obtained a building permit process number either today or yesterday, with the applicability provision that is in the draft ordinance, if the commission approves the ordinance with that applicability, she would be able to move forward. But the commission would have to adopt the ordinance with that applicability provision.
And we could add that to this ordinance.
Well, it's in the ordinance. It's in the ordinance that you're reviewing. So you could transmit it if you transmit it with a favorable recommendation, it would include that applicability provision.
How long has she known about this requirement? When
the proposal for this ordinance went to land use in May, so this has been floating around since May.
Could we ask her if she was aware of that, or whether she's applied? Well, I mean, she's started construction already, so I imagine she's applied, and it wouldn't apply to her.
Well, if she started construction, she probably has a building permit, and if you have a building permit, it wouldn't apply to you. You don't even need an applicability provision for that.
Okay.
Perhaps, Kareem, we could ask Ms. Bernard. Well, maybe she's gone now.
No, she's there. Go ahead, Ms. Bernard.
We have a permit number. We were able to introduce it today, and we got it.
Okay. All right.
Okay. Thank you, Ms. Bernard.
Thank you.
All right.
I like the proposal. I would like to make sure Ms. Bernard is not swept up in it, but I like it.
But there may be other people who are and who haven't been here today. Maybe they didn't know it was coming up today, or maybe we ought to put it off a little bit and make sure that there aren't projects under construction where people have invested their money and are going to be foreclosed from filing an application, and maybe give them a grace period to apply application, to forward an application to the city, rather than this be the deadline.
Wait,
but how was this noticed to the West Ave community? Oh, Michael, how was this noticed?
It was noticed in the newspaper.
A lot of people probably don't know. Yeah, maybe probably a small subset of people, but I mean,
yeah, these could be senior citizens who have invested their savings in this type of building, and then I think we should give them a grace period.
How do we do that?
Well, you could include, you have an applicability clause in the draft that's before you. I mean, Tom I guess the board could recommend a date that's later if they wanted to.
Sure. You could recommend that you could recommend a later effective date. You could recommend that the applicability provision be extended to anybody who receives a building permit process number by the end of October, end of the year. I mean, you could recommend anything that you saw fit.
I think we should do that through December 31st, and also maybe impose a little more burden on the city to make sure that the people who are in the process or in the beginning of the process will be able to proceed with their projects. They may have undertaken initial investments, gotten loans, whatever. So maybe we could, maybe not that long, but 90 days or whatever.
Yeah, I like that idea. I don't like being called un-American.
Well, that's kind of an exaggerated term.
That was a joke. I know it's late, but that was a joke.
Yeah, that's okay, Mike. Your jokes are funny sometimes.
Sometimes, I know.
So you want to call a question, or do you want to move?
Do you want to make a motion?
Yeah, I move that we send it with a favorable recommendation, but impose a time deadline to the end of the year.
90 days would be the end of November, and 120 days would be the end of December, the end of the year.
Yeah, 120 days.
Why don't we, to keep it clean, I would say December 31st, 2020.
Right. That's
okay.
Perfect.
Yeah.
Is there a second?
I'll second it.
Oh, also to include an additional notice to those people who may be in the process. I mean, maybe the building department maybe impose a burden on the city, because it could be something that sneaks up on people and they don't know.
Well, if they have a building permit process number, then they're good, because that's what signals that they're in the process and have started the process. So if they've already submitted plans to the building department, they would have the building permit process number.
I mean, one of the downsides to, so folks who are already in line and have that process number at a minimum are covered, right? People who actually have a building permit are even more so covered, because they already have gone through the exercise of having the plans reviewed. The downside to extending so long is that you may get more people trying to I don't know. This may not be a big deal. I mean, it may not be a whole lot of
a rush of applications that we wouldn't have had. Is that what you're saying?
Right. Yeah.
That's true. Yeah.
I'm not sure that I'm really comfortable with all the way to the end of the year. But I can go for some kind of time period. I mean, is the city going to actually notice? I guess is a question for staff. I mean, is there going to be budget money to go ahead and put how are we going to advertise this that David's actually requesting?
So the minimum notice requirements are a little bit more, because this involves a change of use. And so it will require 2 public hearings at the city commission and a bigger newspaper ad. However, there is no requirement to do a mail notice to every single property in that area. That's something that you could recommend to the commission. And if the commission wants to direct us to do that, we could certainly do that. Or we could do an email blast. to our communications department has a list of all the people who have signed up for Constant Contact, and we could do an email blast to those people. But whether or not we would do a mail notice, if the commission directed us to do that, then we could do that.
I mean, do you think it's going to be a line of people? Are there enough?
No, I think that if there was going to be a lot of people who wanted to do this, you'd see the people doing it already. And I think, you know, the number of people that have done it over the years, it's been kind of a trickle. And I think that we did hear one person speak today who had an intention on doing it. And so she expedited the submission of her building permit process number. But I'm not aware of anybody else that would be running to the door to do this.
Okay, so why don't we just leave it at, make it 90 days.
And that would be the end of November.
Yeah.
So we would say November 30th.
You okay with that, Kareem?
Yeah, I think so. I just, yes, I'm okay with that.
Okay. Do I have a second?
I'll second it again.
Okay.
Thanks, Mike.
Mr. Vitia?
Second, yeah.
Is Daniel still on the line?
No, I think he had to leave.
Okay. Mr. Milan?
He was unmuted for a second.
Sorry, did you say yes, Mark?
No, I said aye.
You said aye?
Yes. Okay. By the way, I said aye.
My last vote is permanently going to be
yeah,
aye.
really
trying to do my thing. Stealing David's thunder.
Michael, Daniel is there. Did you hear him?
No, I didn't. Daniel, did you vote yes?
Aye.
Thank you. Mark voted aye. Mr. Weeder?
Aye.
Mr. Jelpy?
Yes.
Mr. Berno?
I'm sticking with yes, yeah.
Mr. Pietro?
Yes.
And Mr. Brantley?
Yes.
So the motion passes 7-0. Now, does the board want to discuss the FAR, or do you want to continue that to next month's meeting?
So that is 7-0, Michael?
7-0, correct.
Okay.
If it's not time sensitive, you know, and don't put it at the end like that. I mean, you know, it's you know, we're not going to have a real.
If you want, we can put FAR first.
Yeah, please.
Well, if you want to have a good discussion, don't put it, you know, so late at night. You know, so
9 hours into the meeting. Yeah.
My opinion. So
let's not all blame Mike.
Yeah, well, look, I was the last time we had some kind of discussion, I can't remember what it was about. I felt the same way. I was exhausted, and I don't feel like I really participated. So,
no, it's not critical. Any action that we take on this would not go before the voters until over a year from now or 2022. So this is just a really advanced discussion to start the direction for FAR.
But it's an important one.
Yeah, I look forward to that conversation.
Let's definitely do it at the next meeting.
All right.
Next meeting.
Yeah, I move that continue the item, the discussion of our September meeting.
I'll second that.
Aye.
All in favor?
Aye.
Aye.
Thank you.
Common consent.
All right, everybody.
Thank
Have a
you,
good
everybody.
run. Stay
Yeah,
safe.
have a great evening, everybody.
Time for a cocktail.
Great work today. Yeah.
Thank you all. Take care.
Thanks, guys.
All right,
guys.
Bye-bye.
Take care, everybody.
Bye. So long, everybody.
Bye.